All right, good morning. We'll call this special Leap Day public hearing of the General Law Committee to order. And the first hour is reserved for public officials. After that, if the public officials haven't yet finished, we'll alternate between public officials and the general public. Just remember that there are 3 minutes to testify. The clerk MJ will be timing. So if you hit your time, we'll just ask you to summarize and then the committee can ask you questions. So with that, we're going to get started. And first up is Senator Huang.
Thank you, Chairman Maroney, Chairman D'Agostino, and the ranking members Rutigliano and Ciccarella. I am State Senator Tony Huang, representing the 28th District. My testimony is in part supporting Senate Bill 2 related to artificial intelligence. I want to commend this committee for its incredibly hard work in trying to understand and try to articulate policies on a fast-changing and profoundly impactful technology innovation that is affecting all of us. And it's an incredible challenge. And I think one of the most important parts that I have learned, being a member of the Connecticut Task Force, as well as the multi-state task force on AI that's been capably coordinated by Senator Maroney. Thank you for your incredibly hard work in that area. We have learned a lot to be understood, a lot to be learned, but then also a lot to be addressing. And I think for me, I want to applaud the provisions of this bill that I think has come out as a result of the fruits of the work and the lessons that we learned. Is I'm fully in support of the Artificial Intelligence Advisory Board. I think it is an important continuation of the task force, and it allows us to continually learn and understand this fast changing and adaptive technology. It seems like we're always chasing what's coming next, and having this advisory board is incredibly important. I think the second part is in regards to addressing the deep fake information. We have seen in regards to technology innovations, copying voices, and as well as changing photos and misrepresentation and misinformation. I think this committee has demonstrated tremendous leadership in addressing these concerns. And I also believe this General Assembly has demonstrated an absolute intolerance of this kind of fraudulent misinformation. Not only is it misinformation, but I think it deeply pains and impacts people's livelihood and their ability to be able to function. Reputations can be ruined overnight. And this kind of misinformation is critical, and I appreciate the bill's consideration in that area. Another area of interest is in regards to the education initiatives that's been offered, to work with the Governor's Workforce Council, to work with our colleges and universities, to understand that this is an evolutionary process. We can't just stop at a finite point, but ultimately AI is continually evolving and changing. And I think this focus on academic innovation, understanding, and education is absolutely critical. I do want to raise some concerns that have been raised by many of the constituencies in regards to sections 1 through 7. There are concerns and testimonies related to the removing private right of action, the impact in regards to placing the burden responsibility into strictly the Attorney General's office in the state of Connecticut, but also really the concern that private citizens would lose their right to be able to have cause of action and presumable rebuttal to address legal as well as damaging impact as a result of AI. So I would ask for the committee to reevaluate and get feedback from all engaged shareholders. And may I dare say, in regards to section 1 and 7 in the judiciary aspect, that it gets some feedback from members of our Judiciary Committee as well. But nevertheless, I think it's important. It is important for us as a legislative body to address it. And I want to commend this committee again for the leadership. But we've heard so much about AI. And I think one of the things that we want to try to do as fast and as innovative and as daunting the technology is, we need to understand AI is simply a compilation of algorithms. algorithms with super technology and computer power that feeds hundreds, if not millions of data points to be able to create algorithm responses. And I think it's important for people to understand AI can be this amalgamation that has been spread through the news, and the possibilities are profound and endless, but it ultimately comes down to algorithms that are inputted by human beings, knowledge that is put into a process that gets repeated over and over and over again. And I put caution to that because part of that is human beings are inputting that data. Specific categories or backgrounds or knowledge base can be a influencer in creating those data points. So as we look at AI and trying to understand and manage it into the future, we need to understand that we have to pay special attention to equity, to social input, but also the disparity in informational input. So I don't know how we can legislate that, but ultimately, I think that has to be a part of the education, that algorithm input can create simplicities and ease of use for our general society, but bad information spewing bad input with the proliferation and the impact of AI has to be one of our primary goals in relations to discrimination, social equity, as well as its impact on the people that these policies will implement. But for me, I think it's inevitable. I think we need to understand we can't stop technology, but I think it's critically important through the advisory board and all the actions that you've demonstrated here that we're heading that way to better understand it. And again, I commend the leadership of this committee for their forethought on this. But I also want to throw caution in the wind that we need to balance it and proceed very cautiously, that we don't eliminate personal rights, personal liberties, and the protection under the law. So I'm welcome to any questions. And I think MJ has been very kind beyond the 3 minutes. So thank you. Thank you, Mr. Chair. I'd be happy to take any questions.
Thank you. Are there any questions? Senator Kissel.
Thank you very much, Chairman Maroney. Senator Wong, I just want to congratulate you for all your hard work on this, as well as the chairs and ranking members on this committee, especially Senator Maroney. But I know you within our caucus, along with our esteemed ranking member, Senator Ciccarella, have really led the way on this, but you have spent a tremendous amount of time on the AI issue and participation on those task forces. I guess the part that is most important to me initially from your comments is this idea of a private right of action, right? And there's something in this bill that says all this power is now going to vest with the Attorney General's office. And I consider William Tong, our Attorney General currently, to be a close personal friend. We were co-chairs or tri-chairs on the Judiciary Committee. And I think there are aspects of Senate Bill number 2 that has to go to the Judiciary Committee just under our legislative rules regarding cognizance. But why do you feel, or do you indeed feel, that it's important for private individuals to have a private cause of action regarding things that come out? And you talk about the deep fake. I mean, I can't go to this on Instagram without getting John Goodman trying to sell me something about losing weight. And although I'm thankful to, but I think it's a deep fake as much as I do need to lose weight. So how do we stop all that? And should I have a right to go after some of these companies?
Thank you, Senator Kissel, for your insights and question. I think the first thing, and the point well taken, is, and I've heard some feedback on both ends, and I think that's an important exercise for us as policymakers to hear all sides of the story. And the private right of action is important because anyone could feel like they're wrong. And there is a wide spectrum of people that think varying degrees of being wrong. And we want to be able to manage that process, that not every person who feels slightly slighted can jam up our judicial system. But I caution that balance, because to now put all of that investigative and judicial power under one person who is an elected official, it is something that we need to take caution of, because attorney generals can change. They can change affiliations, they can change individuals, they can change political philosophies. To put all of that power in making that determination to one office is something that I'm extremely concerned about. Power corrupts, absolute power corrupts, absolutely. And I think that is one of the causes of provision that says we shouldn't place all of our authority in regards to regulating what is right or wrong related to AI technology as it impacts our society, impacts our economics, and also some of the political spectrums that we're dealing with. So I think that is a point of concern that is on Section 7, relating the power invested into the AG related to AI investigations. I also am concerned in regards to probable cause of action in regards to where our technology companies, they're an integral part of the solution, but they've been integrally involved in sharing the technology of the work group and their insight, which is value. But they have also offered that they have some protection in regards to the output that they are responsible for. So I think we have to look at sections 1 through 7 with a much wider lens and engage on all shareholders, whether the viewpoints are welcomed or not, to make sure that all the interests are represented and not just siloed into one particular department. The second part about the deepfake is, you know, the societal impact, the emotional impact. What may seem as an innocent, non-intentional deepfake can create such devastating emotional impact. And I know we're going into an election year, a presidential election year, as well as the entire General Assembly election year. The fact that a recent voice, a tape recording of President Biden was shared in the New Hampshire primary, and I listened to it, and I got to tell you, it sounds real. And that deep fake, as well as personal violations of privacy and trust, is something that is damaging beyond what is the sensationalism, because the impact on the people and the reputation that it impairs is profound and incalculable.
Well, I appreciate that very thoughtful response, Senator Huang. And again, you have tremendous insight regarding this. I will say that as an attorney here in Connecticut, I've taken continuing education courses to meet requirements. One of them was studying some of these companies in social media, and we as a country made a decision over a decade ago to protect a lot of these companies so that we would have a position in the forefront internationally when it came to this exploding technology. And that's why in trying to cycle back on some of these enterprises like Facebook and Google and others, they've been given a huge amount of latitude going forward. And we've all benefited, I think, as the United States of America. But there's also a very important mechanism out there that can bring honesty to the marketplace and to how businesses behave. And that's the issue of private attorneys general, right? And so while I have the highest confidence in our Attorney General, William Tong, right now, and I think there's plenty of resources, and I'd want us to go as a state against some of these companies that acted with negligence or even intentional actions that harmed our citizenry. I think nothing is better than individuals being able to access attorneys. And that's why if you go back to Shakespeare, that line about first thing we do is kill all the lawyers, that is not a statement against attorneys. That was a statement by someone beginning the road towards despotism, saying they are the biggest threat to our heavy-handedness and our ability to control what's going on. And so people misunderstand that Shakespearean quote and use it incorrectly. And so I, as an attorney myself, but someone who highly respects the trial bar here in Connecticut, which I think is second to none, would not want to take away that mechanism that protected ancient common law right as folks here in the United States of America to seek redress, and that we should have open court systems. So I think that's an area that we should pull out of this law proposed bill, but that's just my 2 cents. So thank you for your hard work on this issue. Thank you, Chairman Maroney.
Thank you, Senator Kissel.
Thank you. I think Chair D'Agostino.
Thank you. Just piggybacking on these points, it seems like there's a simple fix to this, but I want to make sure we're all on the same page. And this is obviously subject to Chairman Maroney's, since he has the pen on the act. But the provision that precludes a private right of action for a violation of the act or any other law is the language that I think we're talking about. And if we were to strip out the or any other law, I think we'd be very clear for purposes of not just legislative intent, but the legislation itself, that what we're saying is when it comes to the specific prescriptions in the act itself, what the developers have to do. The AG is the sole enforcement authority, but we would not be neutering or vitiating or otherwise stripping out common law causes of action that an individual consumer may have for invasion of privacy, false light. I mean, you name it. I mean, we do this all the time in our statutes. I'm thinking in particular of like our Product Liability Act, where we specifically said the product liability claims will be in lieu of any other common law cause of action. So what we said in that statute is this is the only cause of action you've got that exists. Here, what we can do is if we strip out that particular phrase, any other law, we would be saying for the act itself, violations, AGU enforce, nobody else. But we've made clear, and we could even be more explicit if we wanted to, that any other existing causes of action under common law that consumers have are not impacted by the act. I think by stripping out that language, we would do that. So that's the paradigm. But I want to make sure I understand what you're saying. Are you saying that you want consumers to be able to sue also under this act if it passes? Because that's something different.
Mhm.
I mean, I understand the argument of making sure that we are not undermining existing common law rights that consumers have. And that strikes me, as I said, as a very easy fix. We can do that. But if what you're saying is we want consumers, in addition to the AG, to be able to sue under this act, that's something different that I think maybe we need to have a more extensive policy discussion on, because I don't think I would be in favor of that. I think maybe down the road I might be, but I think on a bipartisan basis, we've been very careful to, when we create new regulatory overlays, to make sure that in the first instance, we've got the appropriate regulatory enforcement agency looking at it and not opening up the floodgates to civil litigation right away. We may decide to do that, but then you've got, class actions and other suits that can be brought. And then there becomes sort of this weight to the act that I don't think that we would be intending right off the bat. So that I just wanted to make sure I understood the distinction in terms of what you were asking for when it came to private right of action.
Thank you, Mr. Chair. And I mean it sincerely when I want to applaud the level and the effort that has been put into this bill by this committee's leadership. No doubt, I think it's a very important point, and I think that points out the profound challenges we have in looking at AI as a technology. It's so new, but its impact is so widespread. And I think for me, as I was reading it as a non-attorney, and getting information from all the different shareholders, and they have their interests, no doubt. But I think that's why we go through this deliberative process, this public, transparent, democratic process that we articulate the language. And the good chair, you have, as an attorney as well, articulated some of the legislative intent that may be misread through the language that's written. The language is the language, but then the ability of intent and legislative intent is critical. So I would defer to the attorneys and our LCOs to be able to define the regulatory guidelines. And I think that is one of the challenges we have with AI. It's not as crystalline clear in regards to defining lines because the marker keeps moving. The technology is so profound, it impacts every aspect of our lives. So my answer to you is I raise it as a point of concern, and maybe it's misunderstood, because you're right. We do not want every individual to file action if they feel slighted. And I shared that in my exchange with the good Senator Kissel, but I think there has to be a balancing line, and the legislative intent is critical. And that's why I said in some of the legal aspect, some of our members in the Judiciary Committee can offer some guidance and leadership in that area. But no doubt, my applaud and acknowledgement of the great work that the chairs and the ranking and the various committee members have undertaken this. We are being shined a light throughout this country in addressing this issue. As part of the multi-state work group that's coordinated by Senator Maroney, we have seen the work that we've done in data privacy and bringing forth protection in social media for our young people. We have done it the right way. And my hope is through this vetting process, through this collaborative exchange of ideas from all shareholders, we're going to craft a bill that moves us forward on AI while keeping an eye and focus on that this is an evolutionary change. Like I said before, that was my point of concern. But as you can acknowledge, and I'll acknowledge again, there are significant portions of this bill that I thought are incredibly important and I fully support.
Great, thank you. Are there other questions? So, Senator Wong, just talking about, you've been involved in both the state task force as well as the multi-state working group. So can you just talk a little bit about how many different people we've spoken with? Because I think in a lot of testimony we're going to hear, we need to do stakeholder engagement. And I would just like people to know how much stakeholder engagement we actually have been doing over these last 2 years.
Senator Maroney, again, I want to acknowledge your leadership on this. You are tireless, but you come with an incredible wealth of passion and information in this. As a member of the task force, I feel as though we meet every week with you. You have held meetings while you're on a plane and everywhere. The contributors deserve to be acknowledged, and there are far too many to do so. But the co-chair, your co-chair on the Connecticut task force has been remarkable in sharing their time and passion for this issue and legislation. So there's no doubt we have been incredibly tech heavy in understanding the technology. And I think that's one of the hardest learning curves for us as a legislative body, is one, not to be overwhelmed and informed by biases and sensational impact of AI. That's why I think for me to emphasize, and you've been an advocate in that, AI is algorithms. It is algorithms supercharged. But nevertheless, we as policymakers and consciousness to input of that algorithm is human. And we need to really ensure that we have the right information. And so to answer your question about the task force, the multi-task force, we've gotten tremendous contribution, tremendous support of people, endless meetings, but nevertheless, has now engaged in the legislative process. We enter another sphere. Now we have the sphere in regards to legal action, impact on societal impact outside of the technology, societal, economic, personal or selfish or corporate interests come into play. And we need to mesh all of that. And that's the challenge that we have right now, that the technology side and the workforce has been in play. Now we're hearing from all the people that have vested interests to make sure that it's done correctly.
Great. Thank you. And I agreed on the importance of the data, right? And that's why parts of the bill look at making sure you're revealing what data you're looking at, right? Garbage in, garbage out, that you're using representative data sets and you're being transparent. So I think that that's an important first step. And it is difficult to strike that balance between providing our citizens the protections they deserve and not hampering innovation. So I look forward to continuing to work with you to perfect, or done is better than perfect. I don't know if any legislation is ever perfect, but to improve on this legislation. So.
Yeah, it continues to be a work in progress. And I think the advisory council is an important part to continue to learn and process and be on the forefront of this information. But as I mentioned, the other part of it is the education. One of the challenges we have with technology innovation is it will impact our workforce. And as knowledge becomes much more sophisticated, it is going to displace at the level of convenience, but also efficiency, some of the knowledge-based talent pool that we have. So I think the sections in 16, 17, and articulated by some of our business industries, we need to put a particular focus on workforce development and skill retraining in that arena, because we may struggle to make the incremental changes and understanding of AI, because there may be selfish interests of particular knowledge-based experts that fear that they may lose their job. They may lose their ability to earn their knowledge-based income. And I think we need to be fully conscious of that. Technology and innovation has a way of displacement. but we need to be on the forefront in implementing these policies to ensure that workforce training, retraining, and moving away the fear of technology to know that it can be an ally and can be an incredible skill set for people to be able to get gainfully employed into the next century.
Thank you, and definitely agreed on that point. Representative Brown and I had a great meeting yesterday in regards to creating the Connecticut Citizens AI Academy to make sure all of our citizens have the skills they need to succeed in this new knowledge economy. So thank you for your testimony.
Thank you very, very much. And I want to close by thanking all of you again for your leadership, but also for tackling this very important subject matter. It's still going to be quite a steep learning curve, but I'm confident that the hard work that's been put in by many of you has leapfrogged us in the nation in regards to trying to create better policies that's sustainable and maintained and equitable as well. So thank you very much for your time.
Thank you. Mr. Clerk? Okay, Representative Cheeseman?
Good afternoon. Chairs Maroney and D'Agostino, ranking members Ciccarella, Rentigliano, and distinguished members of the General Law Committee. I'm back, and I'm not even talking about cannabis this time. I want to thank you for hearing my testimony on SB 2 today. As we've heard from Senator Wong, the whole subject of artificial intelligence is incredibly complex, continually evolving, and much in the news. And it has incredible potential for good. But as we've seen from some recent examples, the potential to do great harm. And it is only as good as the algorithms the human beings put into it. I think we've seen some things with Google's Gemini artificial intelligence tool when asked questions like, is it worse for Elon Musk to post memes on X or for Adolf Hitler to kill millions? The answer was there's no right or wrong answer. Or if you could prevent nuclear holocaust by using the wrong pronoun in terms of Caitlyn Jenner, the answer was never. Even Caitlyn Jenner admitted she might be okay with that if it would prevent nuclear holocaust. So as we go forward with this incredibly complex new tool, new asset, and possibly damaging creation in our society, this committee, as Senator Wong said, has done a very commendable job in addressing and working to understand this, both in terms of the work in this bill to prevent discrimination through AI, to prevent AI and the misuse of it from affecting our elections, from really trying to protect our citizens from its adverse impacts. But I want to particularly focus on that section which deals with so-called deepfake porn. The use of artificial intelligence to manipulate the image of an innocent person and present it in pornographic fashion and disseminate it through the internet is so incredibly damaging. There is an organization called Sensity AI that monitors deepfake videos. And since 2018, they have found that 90% of those videos depict pornography. And of those videos, 90 to 95% depict women. This is so incredibly damaging and can be life-destroying in many cases. So in particular, this section, which I believe is section 9, to address that, given that there is currently no law on the federal level that would make this a crime, there are currently 10 other states, ranging from California, Virginia, Texas, New York, our neighboring New York, that have made this an unlawful act. And I am so proud that Connecticut could be joining this group because, as I say, this can be a wonderful tool, or it can in fact be a life-destroying element. So I want to commend you for this. I look forward to further work on this. I encourage you to continue to explore the ways in which artificial intelligence can enhance the lives of our citizens, but also stay vigilant on the ways it can inflict terrible harm. So I want to thank you for your hearing my testimony today, for your constant attention to ways in which we can improve the lives of the citizens of Connecticut. And I'm happy to take any questions if you have them. Thank you so much.
Thank you very much, Representative Cheeseman. Are there any questions? I just want to thank you for your advocacy on this. This is probably one of the most important issues we'll address in the bill. I think, as elected officials, a lot of people are worried about the deep fakes for elections because that's the life we live in. But as you mentioned, the deep fakes or the non-consensual images for porn are harming disproportionately young women. And it became big news when it happened to Taylor Swift, but back in December in New Jersey, the same thing was done to high school girls at a high school where they took their picture out of the yearbook and sent naked photos of them around through the school. So it is important that we address those known knowns, right? There are certain risks that we know now, and it's important that we address them. And I thank you for your advocacy and for working with us in the past on data privacy, and looking forward to working with you on this issue as well. So thank you. What? Okay. Next, I believe Senator Looney and Senator Duff are going to testify together.
Representative D'Agostino and members, distinguished members of the General Law Committee. This is certainly a committee that does great work every year and has a number of major pieces of legislation pending this year. And I'm Martin Looney, represent the 11th Senatorial District, New Haven and Hamden. Proud to count Representative D'Agostino as one of my most outstanding constituents. And our great majority leader, Senator Duff, and I are here today to testify on Senate Bill 2 and Senate Bill 3. First, on Senate Bill 2, an act concerning artificial intelligence. This is a bill I certainly wanted to mention Senator Maroney's work on this, in which he has become a national leader. Just want to point out some of the sections on it. Sections 1 through 7 strike an important balance between permitting the untethered use of AI while regulating the use of AI that's most likely to have an unjust impact on consumers, and focuses on risks of discrimination based on race, age, religion, disability, and other protected classes under our state laws. In addition, as was mentioned in prior testimony, we are greatly concerned about deep fake crimes in the most critical time. And this can also cause great impact in a time leading up to an election with the use of falsehood. That's why it's critical to act now to outlaw political deepfakes, and Section 11 of the bill deals with this issue. We've also need to address, as was mentioned earlier, deepfake pornography. Section 9 of the bill makes a simple update to our current criminal statute on the unlawful dissemination of an intimate image. But now more and more we need to deal with the greater sophistication of what happens in that regard under AI. We're also concerned about economic vitalization and workforce training. Section 14 of the bill amends the duties of the chief workforce officer to include AI training into the state's workforce training programs, to create a broadband internet outreach program for underserved communities. And we also want to enhance greater cooperation between our higher education institutions and studies of AI and use of AI and mastery of AI. So sections 14 through 17 of the bill deal with that in various ways. We have Section 15, for instance, ask the Board of Regents on behalf of Charter Oak to establish a Connecticut Citizens AI Academy for curating and offering online courses. Section 16, ask the Board of Regents on behalf of regional community and technical colleges to establish certificate programs. And Section 17, ask DCD to work with UConn and the CSUs to offer high-performance computing services. So we're preparing for this brave new world. And Section 12 of the bill asks every state agency with employees and bargaining units to study how generative AI may be incorporated into their work to improve efficiencies. Section 13 asks DAS to work with agencies, experts, and bargaining units to train state employees on generative AI and how to mitigate risk and inaccuracies. And finally, Section 8 of the bill establishes an artificial intelligence advisory council to develop best practices for the use of AI in state government. The one thing I'd also like to add is one thing I think we need to work on in addition to the bill is that recognizing that there may be some circumstances where the right to bring class actions or actions beyond those that might be brought only by the Attorney General might be of significance and merit as well. And I'll turn it over to Senator Duff at this point for a discussion on Senate Bill 3. I think he's going to concentrate his testimony there.
Thank you. Thank you, Senator Looney, and good afternoon to members of the General Law Committee. Great to be here today with our great Senate President Pro Tem and members of the General Law Committee talking about two Senate Democratic priorities. Today, Senate Bill 2 and Senate Bill 3. I'll focus, as Senator Looney said, on Senate Bill 3, an act concerning consumer protection, which will protect Connecticut consumers of internet services and electronic devices. I will spare you by going point by point, unless you want me to, into great detail on all 7 sections of the bill. But what I prefer to do is just to give some overall highlights of each section. 2 of the 7 sections of the bill specifically seek to provide greater protection to internet consumers, and this bill addresses this inequities by adopting net neutrality standards, which prohibit internet service providers from speeding up, slowing down, blocking, or charging higher fees for select online content. Further, the bill addresses affordability and accessibility of broadband by requiring state agencies to only do business with internet service providers that offer affordable home internet service to all eligible households by adopting a policy that broadband internet subscribers benefit from equal access to broadband internet service within the service area of a broadband provider. To further ensure affordability of internet services as well as consumer protections, consumer products in general, this bill also regulates junk fees. Junk fees are surprise charges attached to goods and services that are not yet disclosed until it's time to pay them. I know we've all dealt with that ourselves. Next, the bill regulates the ability of electronic devices to eavesdrop on consumers and then use or sell the information learned for advertising purposes. So, for example, and this is not something that is just we're guessing on, in 2023, Amazon agreed to pay more than $30 million in fines to settle claims that it violated privacy rights by keeping recordings of children's conversations with its voice assistant, Alexa, and by monitoring customers' Ring camera recordings without their consent. And over the last few months, we've seen Cox Media Group has been bragging about its ability to use microphones and cameras in smartphones, smart TVs, and other devices to actively monitor uses that have been gathered information for targeted ads. So when you're talking about buying a new pair of socks and you see sock ads, it's not something that is just by coincidence. This is a violation of consumers' privacy, is untenable with our democracy. Government is prohibited by the U.S. Constitution from doing this, and so should private corporations. Senate Bill 3 will protect Connecticut consumers from this invasion of privacy. Fifth, the bill builds upon what we accomplished last session when we required video service providers to prorate customers' final bill. Now this requirement will also apply to streaming services like Netflix, and a lot of folks in this committee and in the legislature said, how come when we did last year's bill, we weren't including them? This year, we are seeking to do that. Sixth, the bill protects Connecticut consumers by making repairs more affordable, and it creates a statutory right to repair by requiring electronic and appliance manufacturers and others to provide devices where people can actually repair the things that they own. According to a 2019 report by the United Nations, the world produces as much as 50 million tons of electronic and electrical waste per year, which we can solve a little bit of that by having this right to repair. And yeah, finally, this bill addresses an important issue, and this I'm going to focus a little bit more on in detail. Addresses an important issue of national and state security. This came to us from a meeting that Senator Maroney were actually at a few months ago. Over the last 3 months, the FBI and the U.S. Department of Homeland Security and Cybersecurity and Infrastructure Security, CISA, have issued warnings that drone manufacturers in China and Russia are sending proprietary information back to China and Russia through backdoors installed in the drones, which grant manufacturers access to the data the drones collect on critical infrastructure and U.S. agency operations. So this is a huge security risk for us here in the state. And I will tell you that, as we know, in Congress, they have not done a lot. I think we all talk about our frustration with what's happening in Congress these days in the House and Senate. One of the bills that they actually did pass was to prohibit Chinese and Russian-made drones from being sold to the military in the United States. They only need to be American-made. Only can be American-made. And so in this divided Congress that we have, that was one of the things that they were able to get accomplished. And again, the U.S. Homeland Security, the FBI, CISA have all said this is a major problem with having these foreign-made drones, because what happens is they end up that information gets sent right back to the country, foreign country, hostile country, into their military, and that puts our infrastructure at risk. And so we don't want to have the state or local governments owning and operating drones that put our security at risk, and we should be taking steps to mitigate that. If the federal government sees this as a problem, we should be seeing this as a problem here in the state of Connecticut as well. In fact, other states are looking and have banned foreign-owned drones as well. So I'll stop there, and I'm sure we'll be happy to take any questions on Senate Bill 2 or 3.
Thank you very much. Senator Kissel.
Thank you very much, Chairman Maroney. Gentlemen, it's great to see you here before the General Law Committee. I have a brief question for both of you, different one. First of all, Senator Looney, usually I see you coming before the Judiciary Committee. It's delightful to see you here before General Law. I was actually heartened by your final words regarding the artificial intelligence bill, where you said that there might be some room for additional private right of action regarding some violations of Senate Bill 2. I know that Chairman D'Agostino said maybe removing some of the language so as to disentangle and allow private litigants the right to use their common law rights and any other statutory grounds to continue to bring a suit. But I actually see that there might be some valuable, not only individual, but public policy goals that can be attained by really not limiting actions to the Attorney General, but perhaps fashioning some kind of private Attorney General action on fair trade practices. I see that sometimes violations, over in the Judiciary Committee, there's sometimes through social media, there's great harm that can befall, especially our young people. So I'm looking forward. I believe that we have Attorney Belair from the trial lawyers, the current president, as well as Attorney Ziotis, former president of the trial lawyers. I look to them for guidance when it comes to litigation issues, because I feel very strongly that Connecticut and our nation benefits from private bar, bringing civil litigation to help remedy wrongs. And I'm wondering, Senator Looney, I'd probably work through Chairman Maroney and the other leaders of this committee, but do you see that there's maybe further dialogue that can take place there so that we can help fashion Senate Bill 2, not only just giving our Attorney General, who you know is a good friend of mine, former chair of the Judiciary Committee back when we were tied, but again, not tying the hands of all the private citizenry that may be really substantially harmed, that can actually redress wrongs in our civil court system.
Well, yes, Senator Kissel, to your question, that's why I mentioned it at the end of my testimony. I think there has to be additional dialogue about the scope of actions that may be brought and by whom. Obviously, I think the Attorney General will be the primary flag bearer in looking at addressing areas where AI users and in the corporate world may have damaged the public interest. But I don't think it should be limited in all cases only to the Attorney General as having that access.
Thank you very much, Senator Looney. And Senator Duff, I don't want to throw the company under the bus, but I am aware of a cable franchise. When I went to negotiate down my bill, it was brought to my attention that the least expensive option would require me to obtain a camera for my house. I said, I really don't desire a camera for my house. I have no purpose for a camera in my house. They said, well, that's really the least expensive option, sort of pushing this product onto me. They said you could use it for pets, things like that. I got to be honest, I was looking for the best deal, so I took the camera. I did not hook it up. Now, from what you're testifying to, you're saying that a lot of times these companies, and I don't know if this particular cable franchise, but it seemed like a full court press to get this device into my home, are picking up stray information and then either selling that to other third-party companies or utilizing itself somehow to sell me products, to sell other people products, either what they pick up audioly or also visually. And so that's very scary. My perspective on a lot, and you had a lot of great testimony here this afternoon, but I am particularly concerned about to privacy. That, I mean, sometimes I just monkey around with this cell phone, say a few words into it and see what pops up. And then like an hour later, crazy stuff pops up. And given Representative Cheeseman's testimony, it can be really scary. If someone's now turning pictures into pornography, and that can really hurt, especially our young people. What private action or what do you envision can be the remedy for when these massive corporations sort of are stealing this information or just picking up on this information without us knowing about it? And then either we're getting bombed with ads for products, or we just know that our sanctuary, our homes are being invaded by this technology for their own profit. What's your envision in a perfect world for the people of the state of Connecticut? What is their ability to seek redress? And as much, again, as I respect our Attorney General, there's got to be other mechanisms than petitioning the AG's office to try to bring a lawsuit.
Yeah, and I appreciate that question. And, it's one of those things where, you helped pass in this committee, helped pass a really very strong data privacy bill that is considered one of the strongest in the country. And people look at it as the Connecticut model around the United States. And we're the only country in the, I think was it the G8 that doesn't have is it the what in Europe, and although every European country has a data privacy bill, we're the only, I think, industrialized country that doesn't have a country nationwide data privacy bill. But we have our state by state one. I'm glad that we have a very strong bill. The problem is, as I see it, Senator, is that we keep trying to get ahead of things, and we see then that companies are still looking for more and more ways in which to mine our data or figure out how they can sell information to make money to advertise to us. And so we've got to be very careful about that. We've talked about, I know I have with Senator Maroney, have talked about the listening devices on or listening ability on devices for a number of years now. We've now, thanks to aggressive federal action and also public calls, that's how we heard about Cox, their reporting calls, that we're hearing actually, and we're seeing in legislation, seeing in court cases that this is actually being done. It's not something that's just people who have conspiracy theories saying it's being done. It's actually being done, and we know it. So that's why we got to put some legislation here, and how the enforcement works out, whether it's with the Attorney General, whether it's just CUTPA, whether it's with the private right of action. I think we're all willing to make it as strong as we possibly can, that it gets enough votes to pass both chambers and signed by the governor. So I'm willing to make it as strong as possible, provided that we can get something through both the House and Senate and signed by the governor.
Thank you, Senator Duff. And I just want to say to both of you, it's always been a pleasure serving with you in our Senate chamber and here in the legislature. We may not agree on everything, but this is not a partisan issue. This has to do with the sanctity of our constituents, their security, and their privacy. And this has to be about redressing wrongs in our free and open court system, whether it's the Attorney General or our citizenry itself. We have a highly skilled bar association, ready, willing, and able to redress wrongs. And, I'm not inherently against major corporations or technology. I am very sympathetic to the fact that Chairman Maroney is walking that fine line. And we don't want to hinder the advancement of technology as if we even could. But at the same time, we don't want the rights of our citizenry trampled along the way. And so I look forward to working with you and the leadership of this committee to make this the best bill possible. And again, with our great leadership here with Chairman Maroney and Chairman D'Agostino and the ranking members to be a trendsetter for the rest of the nation. So thank you for your hard work and testimony. Thank you, Chairman Maroney.
Thank you.
Thank you, Senator Kissel. And I know this isn't the way the committee usually works, that I don't usually ask questions of another member of the committee, but given that you said that you sometimes monkey around and say things in front of your phone and that you're seeing deep fakes of John Goodman, how many times have you said deep fakes of John Goodman losing weight? And are we all going to be seeing those videos now? With that, Senator Duff, I want to thank you. I mean, you've been a leader on both thank you and just thank you. You've been a leader on tech policy. You've sent me down a rabbit hole, which I don't see getting out of in the foreseeable future. But just I want to address, there's something we've heard and a concern that's been raised is in regards to the costs, right? If we were to purchase American-made drones versus a Chinese-made or a Russian-made drone, can you address that cost issue?
Yeah, thank you. I appreciate that. Thank you for the question. And, you know, we've worked on technology issues together and you have really done such a great job. And I always tell people how Senator Maroney goes to various conferences and is called all over the place, and he packs a room because people want to hear what he has to say. Not only ones who are doing business, who are sitting over here with the badges, but people who just want to know a little bit more about these issues and be educated about it. So I appreciate your kind words. I'll also just say that in my testimony about the drones, one of the ones that are actually being used in Connecticut, DJI Matrice, is owned by the Chinese military. So this is not like some, small business in another country. It's actually owned by the military. And again, we need to be much smarter about that. But you asked to say, well, these are cheaper than the American-made ones, so we have to go with the cheaper one. But if you look at it, the DJI Matrice drone, which again Connecticut departments are using, retails around $12,460 and $13,700 per drone. By comparison, the Parrot ANAFI USA, which is manufactured in the USA, retails for about $14,000 per drone. So it's about $300 difference. And I'm not saying to buy this particular company because none of us care. We just want to be safe and secure. We don't need to have our infrastructure being spied on by a foreign government or foreign military. In fact, we saw that in Ukraine. So this is not theory, like listening devices. It's not theory. In Ukraine, there were Chinese drones sent, and that information was sent to the Russian military, and their Ukraine infrastructure was then blown up. So this is a real issue. This is a real security issue for us here in this country. And this is why both state, their contractors, local governments, their contractors have to move away from foreign-made drones, and why the Congress of the United States, in its paralyzed way, was able to get this done.
Thank you very much. Are there any further questions, Rep. Pizzuto?
Thank you, Mr. Chairman. Senator Dove, just quick questions. You mentioned the drones. Does our supply chain allow us to use existing American-made drones now, or would we have to wait?
Can you repeat that question?
Yeah, our supply chain.
Yeah.
Could we get drones and the parts that are needed that are American-made if we suddenly gave up the Matrice drones tomorrow?
I haven't heard that they're not available. So I think they're.
I just would worry from a public safety perspective. The police, fire, they all use them. And if they don't have any American-made ones, I wouldn't want to just make a law that wouldn't allow them to use those.
Well, the way the bill is written, it doesn't say you have to, like by October 1st of this year, if we pass the bill,
Right.
everybody takes a hammer and starts, hammering their drones out of existence. There's some time that lets
Right.
people buy those. So, which I think is a good policy. I mean, frankly, I don't think they should be used anymore, but you can't turn off the switch and turn it back on. You've got to have a little time for transition. So that's.
Very good.
that's where
Thank
you're
you
at.
very much.
Thank you.
Yeah.
Mhm.
Great. Are there any further questions? Okay. Senator Looney and Senator Duff, thank you very much.
Thank you so much to the chairs and members of this committee that always do outstanding work. I'd like to just direct one comment to Representative Anaskevich, ask you to say hello to your brother Bill, who was is a dear friend, former colleague, and was a great legislator.
Thanks, everybody.
Okay, Mr. Clerk?
Yes, Mr. Chairman, do we? Next up, I have Kara Passaro from the Office of the Attorney General.
Good afternoon.
I'm not Kara Passero. She's just to my left here. I'm Mike Wertheimer, Chief of the Attorney General's Consumer Protection Section. And thank you for the opportunity to testify in support of Senate Bill 201. The changes that we recommend in this bill address four things. Hidden and exorbitant junk fees, protects consumers and homeowners from certain predatory and deceptive residential exclusive listing agreements, increases eligibility for the New Home Construction Guarantee Fund, and strengthens an enforcement mechanism under CUTPA known as AVCs, or Assurances of Voluntary Compliance. Starting with junk fees, as Senator Duff mentioned, junk fees are charges that are not included in the advertised price of a product or service, but are ultimately imposed on consumers other than taxes imposed by a government entity. It's simply a bait and switch. We commonly, in our consumer protection work, encounter such fees across a variety of industries, including internet, cable providers, hotels, lodging, delivery services, car rentals, on and on. Given what we see across the marketplace, we believe a junk fee prohibition should capture all sectors and not be limited to just a few. The bill that we propose requires advertising the full price up front, including all mandatory fees and charges other than taxes, and makes failure to comply a violation of CUTPA, which would strengthen our enforcement ability. With respect to exclusive listing agreements, Connecticut and a number of other states are currently investigating a Florida-based company known as MV Realty. MV Realty targets lower income and senior homeowners offering residential exclusive listing agreements, which they call HBAs, or homeowner benefit agreements. Pursuant to these agreements, MV pays these homeowners modest amounts up front, $500 to $1,000, maybe $1,500, in exchange for the exclusive right to list their home for sale for a period of 40 years. And that's listing only. That's not actually selling or acting as a broker. The penalties for noncompliance and noncompliance would be listing the home elsewhere are extremely onerous. 3% of the market price or the sale price of the house. And these instruments are recorded as liens on land records. There are about 400 consumers in Connecticut that are subject to these arrangements. Our investigation has revealed that many of these consumers are not even aware they exist on their land records, do not understand the terms, were not given an opportunity to review the terms before they entered the deals, were not provided copies, and a number of other sales abuses. Our investigation is active and ongoing and continues, but as part of our effort to protect these consumers, this legislation would clarify that these sorts of agreements are unenforceable and would also provide mechanisms for removing them from land records. the provision on the Home Improvement Guarantee Fund would expand this fund to a greater population of victims. The new Home Construction Guarantee Fund was created to reimburse consumers who are unable to collect for losses resulting from work performed by new home builders following a court disposition. Problem we're trying to fix here is that court judgments against contractors are often made against the individual person and not against the business entity, often the LLC. This issue came to light and was really highlighted in the recent events surrounding Sunlight Construction Incorporated and its owner, William Ferrigno, which I'm sure you heard of. Simsbury developers facing 5 counts of failing to refund large deposits on homes that were never built. Took deposits ranging from $40,000 to $175,000 for new construction in Avon, Burlington, and Simsbury. Homes not built, deposits never returned. And in some instances, Ferrigno never even owned the land he was claiming to build on. This proposal permits payment to consumers from the new home guarantee fund when a home builder who was found judicially liable has an ownership interest in the business entity. This is an important point because oftentimes the judicial finding of liability, which can be criminal or civil, is often made against the individual, but the consumers can only access the fund if the judgment is against the entity. So this would seek to close that loophole. And the final provision in our bill relates to AVCs, or assurances of voluntary compliance. Currently under CUTPA, the Commissioner of DCP is authorized to accept an AVC from a respondent to resolve an investigation as an alternative to litigation. AVCs typically require respondents to come into compliance with the law on specified terms and often include monetary payment terms as well. By statute, AVCs are not admissions of legal violations. But as it stands now, there is no enforcement mechanism for the violation of a term of an AVC. The only remedy available is to start over with an investigation and treat it as if it's a whole new case. This flaw really limits the availability of using AVCs as another tool in our toolbox or to the DCP commissioner of having a variety of mechanisms available to resolve investigations, and frankly forces more cases to be resolved through a more formal and onerous structure of seeking consent judgments in Superior Court. To expand the availability of AVCs as a remedy, we propose to make clear that the violation of an AVC is a violation of CUTPA, to allow the Attorney General's office to enforce violations of AVCs in Superior Court, and allow us to seek civil penalties for violations of those AVCs. Those are, Kara.
And we'd be pleased to take any questions.
Thank you. Are there any questions? Thank you very much for your testimony and your work on behalf of consumers. Last year's, I think it was 1058, was great legislation with the protecting ticketing and other issues. So we look forward to working with you on these consumer issues. Thank you.
Thank you.
Okay, are we the first up with the first hour? Okay, let's go with DAS. So Mark Raymond. Mark, are you and Doug going to testify together? Okay, great.
Good afternoon, Senator Maroney, Representative D'Agostino, Senator Ciccarella, Representative Ritagliano, and distinguished members of the General Law Committee. My name is Mark Raymond. I'm the Chief Information Officer for the state of Connecticut, and also the chair of the Connecticut Commission for Educational Technology. I'm joined today by my colleague, Doug Casey, who is the Executive Director of the Connecticut Commission for Educational Technology and the leader of our commission's Digital Equity Plan. On behalf of DAS and the Commission, I will comment on Senate Bill 2, today, and Doug will comment on Senate Bill 3. Our written testimony contains additional details, so we will handle summary just here. In regards to Senate Bill 2, we know that artificial intelligence is a dynamic and an emerging field that brings both opportunity and a need for caution. Aligning our efforts in the state with emerging federal and global standards allows us to protect our residents' privacies in meaningful ways, but also benefit from emerging technology solutions. On behalf of DAS and the Commission, I look forward to continuing to work with this committee on potential considerations for the executive branch. Given our AI policy, which was recently delivered at the beginning of this month. In other parts of Senate Bill 2, Section 12 calls for reporting on potential uses of AI from our executive branch agencies. We believe that aligning the reporting and the timing of this requirement to existing reporting responsibilities under 4D7 will make it more efficient for the agencies to support and more efficient for the legislature to consume. So we would look forward to working with you on that. And then finally, Section 18 of Senate Bill 3 identifies the creation of a marketing program around broadband. So to ensure that the alignment of our existing efforts to promote broadband adoption through a promotion of affordable programs, we recommend linking that proposed program with the state's effort in the Digital Equity Plan. That's developed under DAS, and that plan provides funding for support through the Bipartisan Infrastructure Act. Specifically, we recommend adding the Commission for Educational Technology to the end consultation section of Section 18. And so I will turn this over to Doug to address Senate Bill 3, and we'll both remain available for your questions.
Thank you.
Good afternoon. I want to share comments on Senate Bill 3 and act concerning consumer protection. A few different sections, as Mark indicated. The Commission leads the work through the Bipartisan Infrastructure Laws funded Digital Equity Program. Over the past year, we've conducted extensive research. We've contacted more than 7,000 residents. We've conducted focus groups. We've worked extensively with our agency and community partners, as well as private sector partners, to identify what the barriers are to technology access, and then develop a 5-year strategic plan that addresses those barriers. That plan should be approved soon, and we look forward to implementation in beginning later this year. Specifically, the goals of that plan align directly with the outreach, speed, and cost provisions within Senate Bill 3. And we're specifically recommending that, as Mark suggested, that this work proposed in Senate Bill 3 take place in direct alignment with the state's digital equity plan. A few points specifically, though, we commend the call for outreach and advertising, have a telephone support line to support the low-cost program signups. Based on our extensive research, we found 2 key factors get in the way of people accessing technology. One is cost, and another one is just awareness. So I think you're addressing those in this bill, as are we in our digital equity plans. We're looking for alignment there. Second of all would be the cost. Low cost is defined in the proposed statute as $40 per month. We would encourage consideration for $30 a month. That's based on a federal benchmark through the Affordable Connectivity Plan. It's a sound benchmark. What we found is a lot of people cannot afford even that $30 price point, and so and making it more affordable is a huge barrier to address. And then finally, we would encourage the definition of broadband to increase beyond what's in the current draft statute, from 25 megabits down to 3 up. That may sound like gibberish. The Peanuts teacher to non-techies, but just to put it in context, these are household benchmarks, and so consider a house full of people who are doing telework, telehealth, remote learning, we encourage, and it's really an easy adjustment, to adopt what's already in Connecticut state statute under Public Act 21-159, adoption of those state benchmarks for connectivity, which would be 100 megabits down and 20 up as the benchmark. It's what's required in this day and age and moving forward to have a proper connection. So we'll take a pause with those comments and welcome any questions.
Great. Representative Pizzuto.
Thank you, Mr. Chairman. Mr. Casey, do we have to go to fiber optics in order to handle the bandwidth within our own agencies? I gotta believe our bandwidth is stretched to the max now.
You may
Yeah.
answer that one.
I might be the more appropriate person to answer that question. All of our state agencies are connected via fiber location. There are a few outlying locations that may be really small that we would use more commercial connectivity. But the vast majority of all of our network locations are already connected by fiber today.
Yeah, excellent.
You're
Okay,
welcome.
thank you very much.
Great. Are there further questions? If not, I thank you guys both for testifying. Mark, it was great working with you and implementing 1103 or 2 from last year. And in those policies and procedures, I believe you created a committee, right, as part of those policies and procedures for going forward. Would there be a way of utilizing that committee? And so, again, as part of the bill, and this is something you don't have to answer now, we can hopefully continue working on this together. But one of the goals was to solicit feedback from within the agencies on potential pilot projects. And that was modeled off of the California executive order. But
I personally have enjoyed working together as this technology evolves. I think the better solution for all of us is that we do continue to work quite closely together and learn from each other where we might have more practical implementation in the state as some of this technology begins to unfold. We'd love to be able to share that.
thank you. And I think, right, that's important that we're all working together and including, and one of the things we've learned, right, you need to include diverse voices and all voices to get a better product. Doug, I have a question for you. One of the issues, so from the digital equity report, I believe is it 27% of those 7,000 families that you surveyed are not connected to high-speed internet? Was that?
That's an accurate measure. And by the way, any listeners, anyone interested in taking a look at either the executive summary or the full plan, can just go to ct.gov/digital equity to take a look. But based on the focus groups, surveys, and census data, those numbers are correct. I think of it this way: Connecticut is a very well-connected state. We have about 99% availability of broadband by household, and yet only about 3/4 of households subscribe. So it's really looking at that, what we're trying to get at when it comes to connectivity. We're trying to understand what those barriers are. Digital equity is obviously a lot more than just a connection. You need skills and a device that will support that work. But yeah, that number is correct.
And also, was it from that same survey, was it 39% of those surveyed who failed basic digital literacy?
Yeah, that's correct. We set a digital literacy benchmark and a digital privacy benchmark following the federal guidelines of measures. And those numbers are correct. And that's blended results. Once you start to look at subgroups like veterans and people who are living with disabilities, the sort of skills gap and competency gap using technology goes down, which is a way to quantify the challenge that we have and the opportunity to improve those numbers.
And you mentioned the lack of a device. Is that something that had happened? I believe during the pandemic, we found that a lot of lower income families were connecting to the internet through their phones. So is lack of a device one of the barriers to accessing, or for a reason to access high-speed internet?
Yeah, that's correct. Obviously to have a connection without a proper device is a big difference. And if you think about the experience of trying to do homework, as a lot of our students did, off of a phone, or try to engage in applying for a job or skilling up or engaging in telehealth. These are really, really challenging without a device that kind of works not just to consume information, but to create and engage and collaborate those higher level skills that we're looking for.
So, and I know you had testified more on SB3 than SB2, but I would love to work with you going forward as we move towards, it's critical that we all become lifelong learners. And I think, as we look to create a Connecticut Citizens AI Academy that's online, it's hard to learn on your phone, right? And to test and iterate on ChatGPT or other models, you really need a device, and we need to have access to this uptraining and upskilling. And so I think it's critical that we make sure that all of our citizens have the ability to participate in this new economy. And I think that getting people connected, devices, and just the awareness of the opportunities we want to provide them. So I would welcome that opportunity to work with you. And then Senator Ciccarella.
Thank you. Thank you for coming to testify and provide us some clarity on these really complicated bills. I understand how important it is having two kids that had to, work remote, learn remote. Connectivity is important. Everything we do, I feel like you need a phone to do it or a computer. And it frustrates my father to no end that he can't just pick up the phone and get something done. He has to go on a device, which he doesn't want to do sometimes. But that leads me to a question. We were talking about the report that I guess basically 1/4 of our population is not connected to high-speed internet. Is that what I heard? Does it take into consideration people like my father that don't want to be connected to high speed, or people that are using their telephones to tether to a computer? Is any of that data collected to really make sure it's an accurate number and that need is as big as we think it may be?
Yeah, great question, Senator Ciccarella. The measures that we're looking at are based on the state broadband maps of availability and actual adoption of broadband. So it's important to find these terms. What we're talking about is home broadband access. So a fiber or coax connection to your home. And that's what we define as home broadband. That's what our federal guidelines are asking for. We also took it a step further at the Connecticut state level and also looked at how many residents have both a mobile as well as a home broadband connection. We're all probably carrying smartphones with us, and we all probably have home broadband connections. So looking at the different needs across the places that we go to and the things that we do is essential. We want to make sure that people have the technology and the technology choices to do what they need to do. So if your father or other residents choose to opt out, it's up to them. Our goal is availability and affordability, and we leave the agency to choose the type of and level of technology engagement up to residents.
Thank you. I think that kind of answered my question. But again, some of the additional concerns I have when we're trying to, I'm not going to say solve a problem that might not be there, right? Because I think you're trying to collect as much data to determine the actual need. But when you say 1/4 of the population here in Connecticut needs it, and maybe they don't, I just want to make sure that we're not going to budget something that's a very large number and it might not be needed, because I don't want to have that waste, because as we see with the utilities, with the UI and Eversource, and the high rate it costs for our electricity, I hope that doesn't translate into connectivity for the individuals that have to pay the bill, the full bill, because these companies need to make money at the end of the day. And who's going to end up footing that bill? Just want to make sure that we're paying attention to that. And when we're trying to solve a problem for maybe a population in Connecticut, we're going to do that with, really accurate numbers and keeping in mind that cost, which may end up falling on the back of individuals that have to pay the full price for that connectivity. So I hope that's taken into consideration here.
And just to clarify, we're not stating that 25% of households need broadband. We're saying 25%, about 1/4 of households do not have. And so if someone says, I don't want it, that's fine. What we're after is making sure that reducing barriers to what has commonly been been seen, and I think we can all acknowledge that to engage completely in society today, you really need to have some level of technology access. Yeah, I should also clarify that this digital equity program, is paid for through federal funds. No Connecticut taxpayer dollars are going toward this. And second of all, it is part of a suite of bipartisan infrastructure law broadband efforts. One of those sister programs is called the Broadband Equity Access and Deployment, or BEAD program, administered out of the Department of Energy and Environmental Protection. They're really concerned with the sort of boxes and wires and making sure that build out occurs to the final households that don't have broadband. So we're working in close concert with those other agencies and other programs, again, around availability and affordability, as opposed to investing taxpayer dollars into connecting people who may not want a connection. Hopefully that clarifies.
I think it does. So you're gonna survey essentially that population that does not have the connection, and then determine the actual need, and then budget that money for the population that needs it. Is that what you're saying?
Yeah, what we're after is reducing barriers to technology adoption, and one of those levers is encouraging the establishment of low-cost programs, which many of our carriers already have. I think putting it into statute, giving people the opportunity to invest in that service is what we're after. We're not looking at investing state dollars into paying for people's internet.
It's gonna be federal funds.
Clearly state funds and federal funds through this program, that's not where we're looking to invest in, correct? Yeah. Another point Mark just reminded me of is, one of the barriers to technology access is people just understanding what their options are and how to use technology. So one of the primary areas that we're looking to invest in with the digital equity program is what are called digital navigators. This would be going to the library and having someone actually help you sign up for service, work on a job application, engage in a telehealth appointment, engage in advanced learning, those kinds of activities. So this is probably more about the skills side of it than pulling fiber or paying for people's connections. So one of the biggest barriers we're seeing in the research that we've done is really focused on that skills gap, which is essential to making sure that people can, the why behind this whole program is making sure people are engaged in today's digital society.
And I get that. And thank you for taking time to answer the questions. As you answer my original question, I continue to get more. But for the sake of time, I'll just summarize. I think it's important that everybody has the ability to this technology, availability and ability to use it, as it's becoming so important for medical appointments and education and really just your daily life. And I do think it's important, but I just want to make sure that we're doing that responsibly. I see all too often here, we try to solve a problem and we implement these programs and no one uses them. No one's going to go to the library. No one's going to do that. And we're going to pay people to do that. We're going to study it. Just want to make sure we're doing it responsibly, because at the end of the day, I was confused when you said that was going to be federal money that was going to be funding this, but then you said it wasn't going to be taxpayer dollars and it wasn't federal or state money. So I was just confused there. If you could just maybe clarify that for me.
Sure. Let me be really specific. The federal digital equity program is not going to go toward paying for people's internet connections. One of the reasons why we're submitting testimony on this particular bill is because it also is not looking to invest in connections. What it's doing is encouraging the creation of affordable broadband programs and then promoting those programs. And that aligns directly with the digital equity program that we're running here. So again, this is federally funded. It's not state funded, and it's toward the objective of raising awareness of these affordable programs so that people have the choice to choose those programs if they want to. Just as another data point, we found out in speaking in more than a dozen focus groups, and again, conducting 7,000 surveys, we heard from a lot of residents that they weren't even aware that there were low-cost programs that were already in place. In fact, many residents under the current federal Affordable Connectivity Program can get free internet. Again, doesn't cost anything to Connecticut residents. And the research that we conducted indicated that even though there were these programs out there that could help people, they just didn't know about that. So that's why we are encouraging that component of this proposed statute, because we do see awareness as really being a big barrier to getting people connected, people who really want to be connected but feel like they can't afford it. Hopefully that clarifies.
That does. Thank you very much. And then just one last question, but in section 2 of this bill, it talks about the affordable broadband and the access and, you know, creating a certain amount of upload and download speed and then the cost per month. And if we put that in now and in 20 years from now, it's just way more expensive to provide that service. Who's going to pay for that? To my original question about the UI and what we've seen with Eversource, and people have to pay more on their bill. Is that taken into consideration when looking at section 2 of this bill?
Yeah, it may be advisable to look at some more flexible language, because I hear where you're coming from. My only comment about the $30 versus $40 a month, right now, that's how we define how the national standard is for affordable broadband. I know that other carriers offer even more affordable $10 a month programs. So it's a point well taken that to put a specific dollar point into statute that is going to age as soon as it's signed into law, there is a risk there. So I think maybe providing some more flexible language is an option too.
Excellent. Thank you so much for taking the time to testify and answer my questions.
Thank you.
Great. Thank you very much for your time and for your testimony. Okay, Mr. Clerk, I believe Alexandra Gillespie from Live Girl.
Yes, Mr. Chairman, she's online.
Okay.
Hello, everything working okay with the technology?
Yes, we can hear you. Please proceed.
Excellent. Thank you very much. Dear Chairman Maroney and members of the General Law Committee, my name is Alexandra Gillespie. I am a resident of New Canaan, Connecticut, and currently attend college at Colby College, where I study computational psychology, English, and philosophy. This combination of disciplines serves my research in computing ethics, including ethical issues and regulations for AI. I'm published in the field and intend on pursuing a PhD after I graduate in the spring of 2025. Since middle school, I've been involved in Live Girl, a Connecticut-based nonprofit that equips women and girls with leadership development, mentorship, and career readiness. Today, I advocate on their behalf on Bill 2, an act concerning artificial intelligence. I am very passionate about making technology safe and in service to society, but unfortunately, regulation for such technologies comes too little and too late for many victims of its abuse. The bill in question today, Committee Bill Number 2 concerning artificial intelligence, takes an important step toward protecting women and girls from some of the most disgusting evils AI is capable of enabling. I am a firm believer that the utilization of artificial intelligence is a privilege, not a right, and requires far heavier regulation than we currently see at every level of governance. I take a particular interest in Section 9, the contents of which deal with pornographic media produced without the consent of the subject. Modifying this section to include images generated or modified by AI is of special interest to Live Girl as an organization because of the disproportionate impact of this technology on women and girls. An NBC article from March of last year found that at least 96% of deepfakes that currently exist on the internet are non-consensual and sexually explicit. Nearly all of these feature women and girls. There is also mounting evidence of women and girls whose lives have been ruined by the production of AI-generated or modified pornography, from engineering students to A-list celebrities. In preparation for this testimony, I reviewed a Washington Post article detailing that 26-year-old comedian Bobby Altoff had non-consensual images produced and spread across a popular social media platform within the last week. This social media platform is frequented by my peers and girls younger than me, demonstrating the wide range and ease of access to materials such as these. It is also worth mentioning that the websites that generate or modify images using AI often retain the rights to the images generated and even sometimes the images which are fed into the program. These images could then be used as training data for future iterations of the models or sold to third parties at that company's discretion, further violating the bodily autonomy and privacy of these women. To call this a disgusting violation of human rights in every respect is an egregious understatement, but the best that I can do to implore you to instate the protections outlined in Section 9. AI is a weapon wielded from behind a computer screen. There should be greater protections in place to treat AI as such, especially where women and girls are concerned. Thank you for your time, your service, and your consideration of my support for this AI bill. Thanks.
Alexandra, thank you very much for your testimony. Are there any questions? If not, did you have recommendations for strengthening Section 9? And are you going to submit written testimony? I didn't see your written testimony in yet.
That was not originally my plan. I was roped in
That's fine.
a later stage of this. My only suggestion for enhancement is there's currently very implicit mention about editing/modifying technologies in Section 9. The specific language is an image that is partially or fully generated by a computer system. A suggested enhancement would be to modify that slightly to include generated or edited, simply because there are a lot of AI tools specifically advertised as editors, and that involves uploading the images, which I mentioned towards the end, that could then be kept by the website or used for the website or service or whatever the case may be. So emphasizing that it's not just generating, but also editing. That would be my only suggested enhancements.
Great. Thank you very much. All right. Thank you for your testimony. Okay. Next, Dr. Barry Stein.
Good afternoon, Senator Maroney and distinguished members of the General Law Committee. Thank you very much for the opportunity to address all of you on this important bill. My name is Dr. Barry Stein, and I'm the Chief Clinical Innovation Officer, as well as Chief Medical Informatics Officer at Hartford Healthcare, as well as the leader for the recently established Center for AI Innovation in Healthcare. I'm also a practicing interventional radiologist, which is doing minimally invasive image-guided procedures. I really want to thank Senator Maroney for tackling this complex topic, and it provided me enormous comfort to know that our policymakers, like Senator Maroney, had the curiosity and thoughtfulness about developing this bill. Over the last 7 years in my position, I've had the responsibility and privilege to develop a differentiated innovation ecosystem to attract and retain the world's best entrepreneurs, bringing great ideas to the state of Connecticut and impacting healthcare in their way. At the same time, we've recognized that AI has the potential to fuel massive transformation in healthcare, improving access, affordability, equity, as well as quality and safety for our patients. And it's been important for us to do this in a very trustworthy and responsible way. And we've done so using research, governance, education, and a disciplined way of integrating AI into healthcare. So we're in support of the intent of this bill. And we'd like to highlight a few caveats and recommendations to accelerate innovation around AI in healthcare in a trustworthy and safe way, being very patient-focused. As we all know, healthcare is very heavily regulated by agencies such as the FDA and the ONC when it comes to healthcare and healthcare IT. For example, if you want to bring a new drug to the healthcare system, it has to be FDA approved. It's got to go through internal governance. If we want to bring a new angioplasty balloon or stent or a robot, the same thing. And AI has the potential to have the same upside benefit of a new drug or a new robot, but similarly, it has the same potential of having significant downside if not governed appropriately. So when we think about adding new legislation, we'd like all of you to be mindful of the unintentional increased burden without any additional clinical benefit or safety benefit. We also want to be mindful about the unintentional chilling effect that additional over-regulated environment could have on our entrepreneurs coming into the state. So what we'd like to suggest is strengthening verbiage in the bill to request a strengthening of the governance process within the healthcare systems to make sure that any new AI that's going to have potential clinical impact is done so safely through the lenses of privacy, security, compliance, ethics, ITS security, and clinical oversight. So we look forward to working with this committee to improve this bill with the focus of making sure that our patients are safe when AI is used in any clinical environment. Thank you very much for the opportunity.
Thank you very much, Dr. Stein, and thank you for your leadership and Hartford Healthcare's leadership in this space of utilizing AI for healthcare innovation. I think you're right. There's a tremendous opportunity to improve, increase the length of lives and the fullness of our lives, to help us live longer and more fully by utilizing AI. So we do not want to hamper innovation. I would just point you, we do, recognizing that line 481 on the bill, we do exempt AI that is for peer reviewed research through IRBs. But I think that's a great point on perhaps providing safe harbors in the instance where you're using AI that's already regulated. And so I believe you mentioned the FDA. Are there other areas that are federally regulated for healthcare that are utilized for regulating algorithms?
Yeah, the ONC is regulating, and the Joint Commission is starting to regulate as well, or making it a requisite to have the appropriate governance internally to be certified.
Great. And what would you think, one of the goals of the bill is also to spur innovation and look at, as I've traveled around the country, one of the things you've learned is states should double down on where they're already strong, right? And one of the areas I think that we can really lead is in health AI. We have the insurance companies, we have large research universities, we have great hospitals. How can we make sure we're working together? So I think one thought was, is there a way, or what would you think of creating a grant program around solving certain health issues? So perhaps creating a grant program where we would give $25,000 or, just appropriate a pot of money for grants to researchers who want to solve health inequities using AI, reduce health disparities. What would your thoughts of a program like that?
Yeah, we would personally welcome any program that catalyzes innovation focused on solving health equity in the state, in the country, and around the world. So we would welcome any support to do that, to attract the interest and the time of these great entrepreneurs and innovators around AI to do just that.
And one of the things that we hear is an issue for, I think for health businesses specifically, is that a pathway to reimbursement, right? Like we need to know you're going to be able to monetize this or get reimbursed or paid for it at some point. What would you think about authorizing, applying for a waiver, a Medicaid waiver for using, for reimbursing remote monitoring or other potential future uses of AI to improve the health of populations and individuals?
Can you repeat that? I'm not sure that I understood clearly before I answered that.
Yeah, so right now Medicaid would not reimburse if you were to use remote monitoring for lowering blood pressure, or I know there's a company in my town that's looking at research for using Alexa for monitoring post-surgery when people go home. So, but right now, the state through Medicaid, we couldn't reimburse. So the thought is, how do we leverage the power of the state's purse to incentivize innovation?
Well, I think reimbursement's always a factor. I think primarily we've got to always think about what problem we're trying to solve with the technology. And if the technology is going to improve the outcomes of our patients, I believe any support from the state or the federal government should enable that. If we're not, we're unintentionally constraining unlocking that ability of technology like AI to improve the welfare of our patients.
Thank you. And then my last question is, one of the things, again, traveling around, it seems like there are three things that are key to AI businesses. It's access to data, compute power, workforce. So speaking specifically to the access to data, what would you think of the state trying to work to create some form of data sharing for driving those better health outcomes?
I think access to data in a secure, HIPAA-compliant way is critically important to accelerate innovation around AI in healthcare, not only in the state, but the country and the world. And again, if the state is prepared to commit funding to enable that, fully supportive. It is really a critical element to be able to develop the most sophisticated algorithms in a safe way by having access in a secure and compliant way.
And when you say that, integrating in a clinical way, John, one more question. So thoughts about, again, so if we're going to do grants for doing the research to create these algorithms, I'm assuming there is a cost to a hospital system to integrate those algorithms into clinical care. So would creating grants for integration of some of these algorithms or running pilot programs to help bring these businesses or these algorithms to scale, would that be helpful?
Very helpful. There's been no shortage of great ideas in technology and healthcare. The most difficult thing to do in healthcare when it comes to technology is to integrate it to fulfill the promise of the technology to improve the lives. It's rigorous, it's costly on both sides, on multiple fronts. So I think, again, if the state had some funding to be able to catalyze that, support that, we would then definitely attract the world's best entrepreneurs, because it's something that every single one of these companies, solutions require is disciplined integration, which is costly, but certainly impactful.
Thank you. And you're saying there's no shortage of good ideas. It reminds me of one of my favorite quotes. Ideas are free, implementation is priceless. But in this case, we're saying ideas are free, implementation is costly. So we need to help defray that cost. So with that, are there any further questions? Thank you very much for your leadership and for your testimony.
Thank you. You too. Thank you very much.
Next is Terry.
Mr. Chairman, we have
Oh,
Secretary Thomas here.
Yes. Secretary of State Thomas. Thank you for coming to testify.
Thank you for accommodating my schedule. Good afternoon, senators and everyone on Zoom. I'm here to support SB2. And I really do commend this committee for raising this important piece of legislation. The conversation across secretaries of the state around this country for the past year has been about how artificial intelligence might impact our election security. And so far, only a few states have passed legislation addressing this. So I'm proud to be in Connecticut and to be in the vanguard on this important issue. And I'd like to commend you, Senator Maroney, for our conversations in the past and your interest in making sure that this bill touches upon the election system. I wanted to bring two items to your attention just for your contemplation. One is a small matter. Much of the language in Section 11 uses election as the date certain from which something will happen. The definition of election being used is from 9-1. But since the bill also covers ballot referendums, I'm not sure that that would be picked up if you're using the definition of election as the date certain. So just something for lawyers, which I am not, to look at. And just one other thing, the bill is contemplating mitigating interference 90 days from an election. And I just recommend saying 90 days before the availability of absentee ballots. So we don't have a situation that people have already been voting for 30 days before the restriction cuts in. And in addition to those technical items, I just have a few issues I'd like to raise because they are being contemplated by national security agencies and election leaders, not only in the United States, but around the world. And as written, the current bill doesn't include some of the other ways artificial intelligence can impact elections holistically. And I'll give some examples that have come up when we secretaries have congregated together. What happens, for example, if there's a deep fake phone call from a registrar of voters telling voters that a polling location has been closed? Or a deep fake photo of a polling place in a particular district that appears to be on fire and it's circulating on social media, thereby depressing voter turnout in favor of one candidate over another? Or what about the deep fake proliferation of fake media where hundreds of articles can be populated and something seems like a real news source and stories are then picked up and spread by reputable sources, potentially becoming not only part of the training data used by artificial intelligence, but also spreading misinformation at the same time? Election administration is complex and artificial intelligence is even more complex. And we don't have solutions for any of these things right now, but I just raise it for your future contemplation. And perhaps there are a few things we can adopt in this legislation this year that would address some of these issues. Language that expands the target of harm not only to items on the ballot, but election infrastructure, such as a polling location, a voter list, and other elements of election security and administration, and include language that also protects voters, or prohibiting the use of the voter list, which, as you know, is publicly available for just a couple of $100, from using that information to target for the purpose of depressing or changing voter turnout. Our top priority is protecting our democracy, and we are happy to work with you on any of these concepts moving forward. That is all I have, and thank you for your time.
Thank you so much, Senator Kissel.
Thank you very much, Chairman Maroney. Well, twice in 2
Twice,
days.
exactly.
Madam Secretary, it's great to see you again. I was lucky enough to have Secretary Thomas up in my neck of the woods, celebrating poll workers' outstanding work in the town of Granby
Yep.
just yesterday.
Yes.
That's a community where we hope other communities can aspire to their turnout on various election days.
95%,
There we go.
laudable.
So we're pretty darn proud of that, without a doubt. And I very much appreciate your testimony. Again, before you know it, John Goodman will be urging me to vote in a certain election. Who knows? But you know, as much as, and I commend Chairman Maroney so much, and yourself, Madam Secretary. It would be great to be at the forefront of this, but even if we're the first state in the nation blazing the trail, in this area, technology is just racing at exponential speeds ahead of us. So we're just catching up to the bad guys, the people that are manipulating the system.
Mhm.
And you know, as I'm sitting here listening to all the really good testimony, you know, this is like the advent of a new printing press, and it's just as much as people can come up with ideas to abuse something that can be extremely useful, it's our job to try to rein it in. And so I appreciate you taking the time, Madam Secretary. And once again, you're always welcome up in my state Senate district in North
Absolutely.
Central Connecticut.
Hopefully I'll be there to award the Democracy Cup after
right.
November.
Absolutely.
Thank you, Senator.
Thank you. And thank you, Mr. Chair.
Thank you. You have the unenviable task of being the chief election officer as we're implementing both early voting and the first AI election. I shouldn't say unenviable, but it's a big task. I know you're
All
up
the
to it.
fun should not just belong to me.
So as you mentioned, thanks to the great registrars around the state for
Yes.
their work that will go into this. And I think that this year, it's not just an election in the US. From what I've seen, I believe half of the world's population will be voting in an election this year. So it is critical that I wouldn't say get ahead of this, because we've already seen issues with the fake robocall of President Biden and in other countries. Thank you for your suggestions of improving this to go before the ballots, the 90 days before the ballots are sent out, and your other, in making sure we're not targeting polling places and other issues that we can strengthen it. And I think, there are 5 states who have passed this so far. And then, so the good thing is we can now improve on and strengthen what they've been doing. But thank you so much for your leadership.
Thank you. Thank you for your time. Have a good afternoon.
Thank you. Okay. Now Terry. Okay. Next, Terry Clark, Executive Director of CASE.
Good afternoon. Can you hear me? Yes.
Yep, we can hear you. Please proceed.
Good. Thank you. Co-chairs Maroney and D'Agostino, ranking member Ciccarella and Ritigliano, and members of the General Law Committee. My name is Terry Clark, and I am the Executive Director of the Connecticut Academy of Science and Engineering. CASE is in support of General Law Committee Bill 2, an act concerning artificial intelligence. CASE was chartered by special act of the General Assembly to advise the state on issues of science and technology for the economic and social well-being of the people in the state of Connecticut. CASE was asked to serve the Artificial Intelligence Working Group of the Joint General Law Committee by having 2 CASE members serve as voting members of the working group, David Ferrucci with Elemental Cognition and Jimbo Bai with UConn, and 1 member serving as a co-chair of the working group, Nick D'Onofrio, an IBM fellow and former executive vice president of IBM. CASE recognizes each of these CASE members for their service on behalf of the state. Additionally, the working group requested that CASE provide them with an initial overview of AI skills development and use in Connecticut. The research effort is described in testimony with the briefing presentation, written testimony, with the briefing presentation and accompanying document available on CASE's website and can also be found as part of the AI Working Group report submitted to the General Law Committee on February 1st. The briefing included concepts for consideration of policy makers, with some concepts reflected in the proposed bill, including Section 14, Item 17, incorporate training concerning artificial intelligence into workforce training programs. Section 14, Item 18, designing an outreach program to promote access to broadband internet service for underrepresented groups and identify a nonprofit to lead and implement. Section 15, establish a Connecticut Citizens AI Academy. Section 16, Board of Regents of Higher Education establish on behalf of the community colleges certificate programs in prompt engineering, AI marketing for small businesses, and AI for small business operations. Item 17, DECD efforts to make available high-performance computing services to businesses and researchers, establish a confidential computing cluster for businesses, and collaboration and knowledge sharing through an AI, Connecticut AI Symposium. Additionally, CASE supports Section 8, the establishment of an Artificial Intelligence Advisory Council. CASE appreciates the opportunity to serve and is available to continue to serve in support of work related to AI as requested, And special thanks to Senator Maroney for his engagement throughout the process.
Terry, thank you so much for your testimony. Are there any questions? Okay, I have a few questions. First, I just want to say thank you. I think it's been one of the great blessings of the working group that I've been able to get to know you and to get to know Nick, to know Friel over this time. And it's definitely, yeah, I really value the time that you've given and the advice and the friendship. One of the things we were discussing yesterday with regards to the Connecticut Citizens AI Academy is going in steps and looking at, I think initially we need to provide foundational knowledge so people can understand how to use generative AI, AI for efficiency, ethical uses. But this is something I think we were looking at, maybe Case could help us with as we look to going forward, creating pathways to careers through this. And so identifying what are the skills that are needed by companies. And can you talk a little bit to the report that you did for us, where you did survey companies on their use of AI, as well as, would that be something that we would be able to utilize Case for to help us interview companies to find out how manufacturing businesses may be able to better integrate AI and what the state could do to support those efforts?
We could. In our initial survey and interviews, we talked to large businesses with CBIA's support. We surveyed smaller businesses, 100 employees or less, and also with school districts and with higher education. And we were struck by the amount of interest in understanding the benefits of AI more and how it could be used within their businesses, how it could be used. You know, sometimes we think about the AI within the university environment through the computing and engineering areas, but it's throughout operations, not only the operations of, you know, how human resources and admissions function, but also finances and just all areas. And that is also true for public school districts. So the more that we can kind of think about AI and the way that we need to prepare for our students for future work within AI, there are areas much broader than we can imagine, certainly in contracting and finance and insurance and, you know, and that's just the tip. So we'd be happy to support in any way we can.
Great, thank you. And also just to mention that the expertise that was provided by Case to our task force, Dr. Ferrucci actually worked on the Watson project and really from the birth of that generative AI and is still instrumental in the research and really on the cutting edge. So thank you so much, Terry.
You're welcome anytime. And if we can help in any way, please let us know.
Thank you. Next.
Next up on my list, Mr. Chairman, we have Ronald Harichandran. He's online.
Great, thank you.
Good afternoon. Senator Maroney and honorable senators, representatives, and the General Law Committee members. My name is Ron Harichandran. I'm the Dean of the Tagliatella College of Engineering and Vice Provost for Research at the University of New Haven. And I would like to speak with respect to Senate Bill 2. I'm also a member of CASE. I applaud the General Law Committee in bringing forward this bill. It's timely and it is a leading effort, I believe, across states to protect the public and government agencies from things that can go wrong with AI. So I applaud the efforts and I'm supportive of the bill. However, I'd like to bring to your attention perhaps an oversight that appears to be in the current bill, specifically in sections 14 through 16 with respect to the workforce training goals. And there is a restriction in the current language to limit that to the state's community colleges and state universities. But I'd like to bring to your attention that there are many private universities in Connecticut that have ongoing programs that are related to AI and data science. For example, at the University of New Haven, we have offered a master's degree in data science for over 7 years and graduated numerous students who are working in a variety of capacities in applying AI within the state and in the country. And our curriculum is designed, to ensure that our graduates are not only proficient in the current technologies, but also can adapt to the future. So the curriculum is rigorous and reflective of the latest achievements in the field. Now, AI is very dynamic and rapidly advancing. It changes very fast. And our faculty really have to change content in a class even as they teach it, because that's how fast it is evolving. And so faculty who have active research programs in AI are much more better equipped to meet the challenges of this rapidly evolving field and to educate both students and future workforce development programs. And so I would ask that the General Law Committee leverages the expertise that resides at also the private universities in Connecticut in the workforce development efforts that it envisages moving forward. There could be a process by which there is a vetting process of, both for content and curricular delivery, either through the Connecticut AI Advisory Group or by CASE itself. And such an inclusive effort, I believe, would leverage the full range of educational resources available in the state and the expertise that resides in the various higher educational institutions in the state. And I think by broadening the scope of the bill in that way, Connecticut can really position itself to be a leader in AI education and workforce development. So that is my request. Happy to answer any questions, and I thank you very much for the opportunity to provide this testimony.
Great. Thank you very much, Professor Harichandran. Representative Ackert, and then I have a few questions.
Thank you, Mr. Chairman, and Professor, thank you for being here and providing your testimony. You struck on something that was very interesting to me because, I have been looking into AI and the uses of AI in a positive manner. But you mentioned a key that was dealing with curriculum. Before I was in the legislature, I was a trustee for the community colleges, and that was one of my focus was developing, not me developing the curriculum, but allowing the community colleges to move in that direction. They'd present a course. I can't even imagine, it didn't take us long to allow them to do that, but I can't even imagine as fast as AI is advancing, how a curriculum written today and presented, to be approved in a month, the validity of that curriculum. Can you talk a little bit about how fast it's changing?
Yes, I would say that every 2 weeks to a month, the things change that quickly. That's kind of the time frame in which impact is being made. Now, our courses, the curriculum is somewhat flexible. Of course, there's a syllabus and there's a topics to be covered and so on, but there's a great deal of flexibility within that construct for a faculty member to change content on the run, if you will. And in a field like AI, that is really what they are having to do. They have to change content on the run because, as you say, if they just deliver what they did last semester, this semester, it's already old and outdated and may not address a lot of the developments that are taking place or the risks that are emerging.
So not only are the students and faculty learning along the way, they're researching along the way, I would sound like, right?
Yes, and I think that's the important element, that it is only those faculty who are doing research in an active way who really can keep on top of this rapid development. If you're only teaching from a textbook and so on, you're just not going to be able to keep up with that.
Thank you again, Professor. Thank you, Mr. Chairman.
Thank you. And I think that's an excellent point that things are continually changing, and we were talking with Amazon to help us, one of their experts, Rebecca, to help us design a curriculum in prompt engineering. And one of the most important modules is going to be continual learning, knowing how to keep yourself updated and where to find good resources. Professor, excellent point that we need to include the private universities. I do have a question. As you're the dean of the School of Engineering, we cannot graduate enough engineers in Connecticut. I think they're needed for our defense industry. They're needed for ASML. What would you think of the idea of trying to model some program after Newport News Shipbuilding in Virginia has partnered with Old Dominion University to create to create an apprenticeship that leads to a bachelor's in engineering?
We do have a bachelor's program in engineering, which is quite broad, not focused on any specific field. And we have the full suite of engineering programs. We do have mandatory internship requirements for students where they can work at companies, either while they're at school or in the summers. So not only us, but I believe a number of the other universities also afford these kinds of opportunities. I wouldn't call it quite an apprentice program in the sense that they are not working sort of on a daily basis with someone in practice, but those kinds of models could be developed. I agree.
Great. Thank you very much for taking the time to testify.
You're welcome. Thank you very much.
Next, Scott Lowry from Connecticut Health AI.
Good afternoon, Senator Maroney and colleagues. My name is Scott Lowry. I'm the CEO of the Connecticut Health AI Collaborative. Today, I have the privilege to discuss an exciting opportunity that has the potential to revolutionize healthcare research in our state. Imagine if all of our healthcare organizations could speak the same language, share their knowledge effortlessly, and work together seamlessly to uncover health insights. This is not the case today. They can't talk to each other. But it is possible. It is possible through something known as the Common Data Model that is put out by an organization called the Observational Medical Outcomes Partnership. So we are espousing that SB2 include reference to one common data models and that a collaborative be formed to implement it within the state. Let's talk about a simple model to explain the problem. Imagine every hospital, every health system in the state were a library. And imagine you were looking for a book, but every library had a different cataloging system. And in Library A, they did it numerically. Library B did it alphabetically. Library C did a combination of the two. If you wanted to get the information, get that book from each library, you would have to understand how that system approached cataloging their data. That is the case today. One of the benefits we have, and Barry has pointed this out several times, is that the major healthcare providers in the state are all on the same electronic health record system produced by a company called Epic. The good news is they're all on Epic. The bad news is they haven't implemented it in the same way, so we do have this problem. So what are the benefits that would accrue to us if we were able to implement the common data model? Number one, it would accelerate discoveries. With a common data model, researchers can access larger pools of data, giving them insights needed to understand health trends, disease patterns, and the effectiveness of treatments across a diverse population. This could lead to faster development of new treatments and better healthcare strategies. It would also enhance collaboration. It encourages collaboration among organizations. By sharing data in a standardized format, healthcare providers, researchers, and policymakers can work more effectively together. This collaboration can lead to breakthroughs in understanding and treat diseases that we can only dream of today. It would improve data quality and privacy. A common data model not only makes data sharing easier, but it also improves the quality of the data shared. It ensures that data is accurate, consistent, and reliable. Moreover, it supports the protection of patient privacy as data can be shared in a way that safeguards sensitive information. What are the challenges of implementing a common data model? Those challenges end up being concentrated in the governance process. And there are several things that have to be dealt with in the governance process. One is data standardization. What is the standard we're going to use? People have to agree, one, to use it, and then use it consistently as the other members have implemented it. Number two, data privacy and security. One of the challenges when you move towards collaboration is, I don't trust you. I know our organization does this very well, but I don't know how well you do it. Therefore, I'm not going to share anything with you. One of the things that comes out of this is a common understanding of what everybody's doing, and I'll trust you if you trust me. Data access and sharing. Again, if the data is there, if the data is in a common pool, it helps everyone. Intellectual property. One of the things that seems to be in the way of collaboration is I don't want to show you what I'm doing because I intend to make a lot of money off of it. If you look around at the other major health systems around the country, the Mayos, Dukes, Stanford, and so forth, they all have open collaboration programs. They all have these systems in place already. We need to look to them as examples of what we might do. Funding and resource allocation. This doesn't come cheap. One of the things that we, I think, need to do in the state is think bigger. If we sort of think we can get into the AI business in dribs and drabs, it probably won't work. If you look around, New York just put $400 million in AI. Our MD Anderson put $100 million in AI. Duke put $72 million in AI. Real dollars are flowing into this, and we don't seem to yet have a grasp of if we really, really want to do this, it really, really does cost money. So with that, having said that, transforming to a common data model through a collaborative approach.
And I'm sorry, your 3 minutes was up. Could you just summarize and then we'll ask some questions?
Sure. It requires collaboration to do the model. It requires conviction. And let's move straight to questions.
Great, thank you. Does anyone have any questions? All right, I love the library analogy, but for all of the younger people who are listening, that's where we went to do our research before the internet. So
That's
in case you're not sure what it is.
Who was
So
that?
Thank you.
Who was that? Who was Dewey Decimal?
Jack, I'm glad. Yeah. Are you familiar with, so the UC system, UCSF, they all share data through what's called a confidential computing cluster. I'm wondering if you have any
That's
opinions
similar to
on
what
that?
we're discussing. They use that model. Yeah, if you-
Privacy enhancing, and it maintains the IP and protects.
absolutely, absolutely.
Great. Thank you. I mean, you've been traveling around. We've seen each other a lot of different places.
This is not new news.
And it's, but no, for everyone else who's listening. So thank you so much for all of the work that you've put into helping to make Connecticut a leader, right? We may not be the leader, but we can be one of them.
Absolutely.
Thank you.
Thank you.
Oh, sorry, Representative Scott, Representative Ackert has a question.
Please, sir.
Yeah, sorry about that. Just one of your comments in the beginning is that you were mentioning the Epic system.
Yes.
That is, but then you mentioned they haven't implemented it. Like you said, they're in different, silos. Who's they?
Well, they, the individual health systems. So there's something in IT called a schema, which is effectively how the vocabulary you use. Let's use a simple example. One health system could implement time on a 12-hour basis. Another could implement it on a 24-hour basis. So in their computer systems, if you ask for time from one organization, you might get 1700. On the other, you'll get 730. So those differences, it's the same system, it's the same Epic system, but when you put it in, they give you choices in various fields, how you would like that field to be populated.
So if they populate it in what they want to keep private, they could populate it in one way, but if there's something that they want to share, could they implement that in a similar input?
Yeah, absolutely. One of the things that we didn't talk about was the notion of federation of the data. That is the concept of I have my data, you have your data. I can look at yours, you can look at mine, but my data never leaves my organization. and I can control what I'm going to let you see when you come there.
Thank you for that clarification. Thank you,
Sure.
Mr. Chairman.
Thank you very much. Are there any further questions? Okay, thank you, Scott. Okay, next, I believe online. Is it?
Yes,
Neil-
Mr.
Neil
Chairman.
Tilson.
Thank you for the opportunity to testify before the General Law Committee on SB2. I am Neil Chilson. I'm a lawyer and a computer scientist, and I'm a senior research fellow at the Center for Growth and Opportunity at Utah State University. I'm also the former chief technologist of the Federal Trade Commission, where I worked on dozens of enforcement and other actions to protect consumers and competition, often in conjunction with the talented on-the-ground teams in the states, including Connecticut. I read a lot of state legislation, and SB2 stands out as well-written and coherent. Congratulations on all the obvious hard work. Having said that, I have a number of concerns. I recently testified to the United States Senate Committee on Rules and Administration about the role of AI in elections. I pointed to the risk of drafting AI legislation that ends up affecting all software development. As we heard in earlier testimony, AI is algorithms, and algorithms are the fundamental building block of all computer software. I know it's not the goal of SB2, but the practical effect of this legislation may be to regulate a large majority of software development. The line between AI and computer software is incredibly porous. For example, my read is that a decades-old spreadsheet software could qualify as artificial intelligence system under this bill. And if such formulas were used to make, say, lending decisions, such spreadsheets would likely qualify as high-risk artificial intelligence systems, subject to all the requirements of the bill. I don't think that's the intent of the bill, but I think that may be the effect. And you can look to the difficulty of these definitions when you see the definition of synthetic content and generative AI systems, which under the current draft is circular, with each definition referring to the other. These are very hard things to define. Writing an AI definition that doesn't threaten to sweep in all software development is difficult. Fortunately, I also think it's unnecessary. So I urge the Assembly to focus on the harms that you wish to address, not just the means through which those harms are caused. Obviously, unjustified discrimination in housing, lending, medical treatment needs to be addressed, no matter what tools are used to do it. In many cases, such harms are illegal. Companies have incentives to avoid breaking those laws. And when they do break those laws, they should be prosecuted. Likewise, similar for the distribution of non-consensual pornography and for lies in elections communications. Finally, I want to touch on the effect of SB2 on open source AI. Many of the provisions that SB2 applies to developers are, I believe, simply unworkable for open source developers. Open source software is developed by volunteers with no profit motive. It's widely deployed with over 78% of the code in one study that's used across 17 core industries being open source. And it's particularly critical to providing competition against the AI products that are being developed by large companies. Section 4 has some exemptions, but it relies on open source models. Those exemptions rely on where the open source models are deployed, which open source developers have no control over how their open source models are deployed often. So I don't think that exemption offers much relief for open source developers. Thank you for allowing me to comment on this bill.
Thank you for your testimony and understood the importance of definitions. I think one of the warnings I've heard is make sure your definition of AI doesn't draw in a toaster since they sense and other things. So, but point well taken. Next, I think Senator Kissel has questions, then I do have questions for you.
Yeah,
Great.
thank you, Chairman Maroney. Just a couple really quick questions. Who do you represent exactly? Is it private sector, public sector? I know you had good background with the federal government. And B, in those concerns that you raised, did you give recommendations for language change to the committee?
So first of all, I am a senior research fellow at the Center for Growth and Opportunity, which is a nonprofit affiliated with Utah State University. Our goal is to provide both the cultural and regulatory environments that enable technology, especially new technology, to create the widespread human benefits that we think it has the potential to do. I don't represent any tech company on any issue. Second, to your second point, I have offered some in conjunction with I have offered some ideas on the legislation, but I'd be happy to provide in writing further recommendations on how some of these definitional issues could be adjusted, and I look forward to doing so.
Yeah, thank you. That's, first of all, I appreciate that describing your affiliation because it seems very content neutral, and so it's very aspirational. And far be it for me to step on the good chair's toes. He may have that all completely under control as far as definitional, but it seems like we've got a really good product. It may not be totally finished yet, but I think we're really far down the road. And if you're aware of any kind of gold standard as far as definitions, I think that would be helpful. If for no other reason that we can look at that and discuss it. But I'm guessing that the good chair probably has his arms around this already, but thank you.
Thank you. Yeah. So on the point of definitions, I think that moving forward, my thought was to more closely align with the OECD and the EU AI Act definitions. I guess your thoughts on the OECD definitions.
And actually this bill has a number of different definitions of AI across the different sections, and some of them are broader than others. So there are two reasons, there are two challenges here, right? One of which is that a lot of the reason that we're talking about AI right now is because of the generative AI systems like large language models that ChatGPT is. But obviously AI algorithms are a very broad category of computer science. In fact, the history of computer science is essentially one of which, where every time an AI researcher solves a problem, such as say chess games, getting a computer to play chess, we no longer really call that AI. We just call it computer programming. And so that to me is the big challenge here. What we're calling AI today, in 5 years, maybe even sooner than that, we'll just think of as computers. And in that condition, it's very hard to define in statute artificial intelligence in a way that doesn't eventually sweep in essentially all of software development. And that would be quite a reversal from the way that we've done software development, generally speaking, in the US, which is one of low barriers to entry, high competition, high output, high experimentation, and high deployment in a way that has benefited, I think, our economy and made us the leading software development economy in the world. And so that's where I worry about the difficulty in writing these definitions. The OECD definitions are good in talking about today's AI, perhaps, but I worry that in 3, 4, 5, 10 years, we'll just call what is in that definition computing.
And I think one thing that we have to be cautious of is we can't let perfect be the enemy of good. And we know that we're going to come back every year and have to look at this legislation because this is a continually evolving. So we need to look at what is the smallest thing that we can do to provide safety and surety to our citizens so that they feel protected and can more fully embrace, and so we can, as a society, get the full benefits that will come from the utilization of AI. With that being said, agreed on open source. I think open source is the future. That's why, where the small business innovation is going to come from. What are your thoughts on the language from Article 52C of the EU AI Act? I think they do exempt open source. We attempted to look at that, and obviously I do want to make sure that we aren't hampering the innovation.
Yeah, so I have barely looked at the EU AI Act's language around open source. I think they do realize, and they realized somewhat late in the process, but the importance of exempting open source software. I think that they primarily do it based on sort of business model and less on the definition of open source itself. And I think that could be challenging. As you apply it to this particular bill, I think that the key thing will be to ask, like, what is the practical effect? When I say that open source is used and integrated into 78% of the code source across 17 core industries, we're talking about like aerospace and healthcare. This code is everywhere. And so if the trigger for reporting requirements is that somebody uses that open source software, somebody deploys that open source software in a way that the open source developer is not aware of, that trigger just makes it impossible for an open source developer to comply with this, with these provisions, I think.
Well, yeah, I would ask you to look at that because I don't think it's as burdensome as you're making it out to be. I think we do have privacy policies on websites. The exemption is contingent upon making some information transparent, model cards, what you've trained on. And so I do think that is one of the keys is transparency, right? And how these were created, what was used to train it, and accountability. But I would welcome your feedback. I know you said you'll send some written suggestions. If you could do that, we would appreciate it.
Absolutely. Thank you.
Thank you. Okay, Mr. Clerk.
Thank you, Mr. Chairman. Up next, we're going to have Bob Ridgway with Brooks Campion.
Oh, yeah, no, I'm good. Yeah. Hi, Brooks. Okay, Brooks and Bob, if you would proceed.
It's two for the price of one, Senator. I'm Bob Ridgway with America's Health Insurance Plans. We are the trade association that represents the vast majority of health insurance companies in America. And I'm joined today by Brooks Campion, who of course works with the Connecticut Association of Health Plans. And she has given me the privilege of going first. And I'm going to try to be much shorter than perhaps I am oftentimes, because I'm really talking about a very limited point on this bill. This bill is voluminous, as many people have talked about it so far. Certainly there's a lot of credit that is to be given by those of you who've had the courage and the stamina to tackle this issue, because it is a beast and it is very expansive. It is constantly changing. And I think that's admirable that anybody would undergo even the attempt to develop a piece of legislation and to have been at least so far successful at it. However, we have a very limited point, because I'm not going to be speaking on the content of the bill itself. We're concerned that the well-intended language in this bill can easily overlap with and conflict with, potentially, at least to the point of causing confusion among insurance licensees. That's going to make it really difficult to comply with both. I can easily point out to you probably the simplest and easiest way to look at this, and that is this. Insurance companies have for decades been prohibited from discriminating unfairly. Generally, in the insurance world, unfair discrimination means any type of discrimination that is not based on a calculation or an assessment of actual risk. So if there are two people who are pretty much identical, but one of them gets a different rate than the other, we're both the same risk, that would be unfair discrimination. It's not necessarily connected to what we view as protected classes generally, for example. Now, having said that, as I said, insurers have been prohibited from that for years, and that has been most recently manifested by the issuance by the Connecticut Insurance Department by a bulletin on the use of artificial intelligence systems by insurers. An interesting thing about this bulletin is it is not an attempt to put out any new law. Instead, what it does is rely on these existing laws that have been there on the books for years, in a variety, and it's not just a law, it is a variety of laws. It includes the Unfair Trade Practices Model Act, the Unfair Claims Settlement Practices Act, Corporate Governance Annual Disclosure Model Act, Property and Casualty Rating Laws, Life Rating Laws, and Health Rating Laws, and Market Conduct Surveillance Laws. The bulletin very carefully, and I'm not going to bore you with trying to take you through the contents, but I would certainly encourage people, if they have an opportunity, to review the 10 pages of that and see the level and depth at which commissioners who developed this at the NAIC, and now Commissioner Mays has issued it here in Connecticut, to look at the level at which the bulletin goes into the description of how these laws apply in the cases that we're talking about. Now, the good news is, as far as I know, the uses of artificial intelligence by insurance companies does not begin to touch on the range of the various issues you've discussed today. It's usually much more limited. Now, I fully expect it to develop more as it proceeds, as we've talked already about. But you will see that it focuses on auditing the data. It focuses on avoiding unfair discrimination. It focuses on a number of issues like that that are related to market conduct and generally just what is required under the laws of insurance already. I would suggest that there is not only broad state regulation of artificial intelligence for insurers, health insurers, and insurers generally, but there is also, particularly for health insurers, extensive regulation by the federal government, by HIPAA, by Gramm-Leach-Bliley, and a variety of other lesser known federal laws. And I think Senator Maroney, you and I have discussed that before in the context of privacy. And some of those same things would apply now. The law is there. It is pervasive through the world of health insurance and impacts almost everything health insurers do. I would wrap up and go ahead and pass it on over to Brooks here in just a moment by pointing out something that I've heard repeatedly, and it is that one person cannot serve two masters. We would agree with that, and we would say that already we are serving two masters in the insurance business by following and complying with the requirements of state law, and also try to integrate those with the requirements of federal law. What we are asking you, Senator, and others involved with the actual drafting of the bill is, please do not submit us to yet a third master. We think we're dancing as fast as we can to comply with what we have. Brooks, anything you can add, please?
Just briefly to dovetail with what Bob said. My name is Brooks Campion. I'm a lobbyist with Robinson & Cole, and I'm here on behalf of the Connecticut Association of Health Plans, which is comprised of Aetna, Anthem, Cigna, Connecticut, and United Healthcare. And we would just echo Bob's comments and also point out perhaps we should submit it in testimony, but Senator Maroney, given and others, given your extensive work on this area, I'm sure that you've already seen the Connecticut Department of Insurance's bulletin governing AI that was just issued. But in addition to the laws, the model insurance laws that Bob had listed, Connecticut also has the Connecticut Unfair Insurance Practices Act, or CUIPA, which is, a sister law to CUTPA, which they're also subject to. We respectfully ask, just to pick up on Bob's point, that the committee consider granting an exemption for HIPAA compliant entities in the state from this, because right now they're going to have to attest as quickly as September 1st, 2024 to their adherence to the NAIC delegated to the Connecticut Department of Insurance's model bulletin for AI governance. And in order to meet the requirements there for their licensure, they are also subject to enforcement action, surveillance, investigation by the department. And the bulletin's guidelines are pretty exhaustive in terms of trying to regulate the development, acquisition, and use of certain AI technologies systems. And we believe that their compliance with their regulator, the Department of Insurance, which you have enumerated in Senate Bill 2, should hopefully satisfy the spirit and the substance of Senate Bill 2. And if that is not a direction that the committee is prepared to take in terms of exempting HIPAA compliant entities, we would appreciate an opportunity to further discuss how we could align what the insurance industry is obligated to adhere to with what you are asking for in the law. Because even the bulletin points to the very entity that you've cited in the law, which is the National Institute of Standards and Technology, NIST, their Artificial Intelligence Risk Management Framework, version 1.0. So that's insurers' adherence to that is even contemplated in the bulletin as a means to help begin to satisfy what the requirements are for the industry. So it really, our testimony is to dovetail with Bob's, but just to put out there that we would be very grateful for the opportunity to be a resource to you to further discuss how we can not run afoul of what we are obligated to adhere to with the state, our state regulator, but also with what you're contemplating here in Senate Bill 2, because we think that as AI is emerging, as you know, it's not static, it's evolving and dynamic, and we try to use it responsibly. And we also, it is not the ultimate arbiter of decision-making. And that's an important point too. I think that we, in our plans, they are not the sole AI recommendations, AI data is not the sole determinant of decision-making. So there is a human factor here that I just wanted to make sure that that is captured in our testimony.
Great. Thank you for coming to testify. Bob, thank you. You had worked on the task forces in the past. I want to say I do really appreciate you coming to actually testify instead of just submitting testimony, written testimony, asking for exemptions in opposition to the bill and not giving us an opportunity to question you. So I really appreciate you being here. But with that being said, we worked together on the data privacy laws. And one of the things we learned from the data privacy laws was that by giving entities exemptions, it creates huge loopholes. And what happened is in Texas, where they gave the GLBA entity level exemption, now car dealers are claiming that exemption because they have a finance unit, which is subject to GLBA, which is not the intent of the law. And similarly, we gave the entity level exemption in Connecticut, and we saw the Prospect Health data breach. One of the parts of our data privacy law was adequate security. And so now the 109,000 people whose health diagnosis, social security, dates of birth have been leaked have no recourse to our state data privacy laws. There are other laws, but I want to make sure, and I know that you guys are doing the right thing, and that's why we put in safe harbors. But if we give you an exemption, we have no surety that you're doing the right thing versus a safe harbor when you are following other. And again, so I would welcome the opportunity to work with you to make sure that we get that language right. But I don't think in a policy, for a policy decision, an entity level exemption is the right way to go. Data level exemptions, yes, perhaps, and safe harbors, I think, are what we would look at. So,
Senator, if I may respond quickly, what we had contemplated certainly in our comment letter that was offered up and what we've been discussing throughout is an exemption only for those entities that are licensed by the Connecticut Insurance Department. That would call out issues like whether they are just getting a pass and not doing anything because they're under constant surveillance by the insurance department. Not to mention, anytime there's a problem, there's going to be an instant investigation by the insurance department, in addition to the regular examinations, which are like an audit that occur every 3 to 5 years by the department. And this is consistent not only for the Connecticut Insurance Department, but as a nationwide standard. So I would welcome the opportunity to discuss this with you further, as you offered, or I think you did. And for that matter, I was really interested to hear your previous discussions. I was a little intrigued by this concept of library and Dewey Decimal System. What was that about?
thank you.
Thank you.
And yeah, and again, we do have an affirmative defense in there for businesses that follow a recognized. So, but we can work with you on the language going forward. So thank you.
Thank you.
Thank you. Next, Mike Souza. Okay.
Mike, you're on mute.
I had to be the first guy, right? Hello, Senator Maroney and distinguished members of the committee. My name is Michael Souza. I am the Business Development Manager at F&W Equipment in Orange, Connecticut. F&W is a third-generation family-owned business located in Orange, which, as you know, is in Senator Maroney's district, and I'd like to thank Senator Maroney for his representation and letting us have this opportunity to talk here today. I'm joining you today in opposition to SB 3, Section 8. Give us a little break from the AI bill. At F&W, we serve many different customer groups, including the agricultural industry, construction workers of all sizes from small to large, home construction to road construction. We service municipalities and even homeowners. We sell, rent, service, and support a range of machinery and equipment, including tractors and excavators, dirt movers, all sorts of equipment. And we've built our business on a foundation of outstanding service and relationships with our customers. F&W Equipment has been in business for over 85 years. We sell and service Kubota and Devlon equipment. Kubota is a leader in the industry, and they've already signed on to an MOU, a memo of understanding, with the American Farm Bureau Federation, committing that Kubota dealers will support customers in independent repair shops with any needed parts or services. The AFBF also includes many other manufacturers like John Deere, Case IH, New Holland, AGCO, and many others. All of these manufacturers have agreements to support owners and their needs for repairs. If a customer wants to repair his or her own machine, we already support them 100% with parts, with documentation, tools, service, even advice from our experienced technicians. Kubota even provides a free internet-based illustrated parts lookup tool that will allow any owner to look up parts for their machine themselves and even buy them online. Of great concern to us is language found in Section 8 regarding the sale and documentation of parts, tools directly to the public at the same price that our OEMs sell those products to us. This mandate would not only cripple our business, but it would ultimately hurt our customers and all equipment owners. We serve as local experts and parts warehouse for customers that own Kubota or Devlon equipment or many other brands. We have 3 trained, full-time experienced part technicians to help our customers find the right parts, whether it's an original part or aftermarket. We have over $3 million invested in parts inventory. 70% of the time when someone walks through our door looking for a part, we have it in stock and we're able to deliver it immediately. Considering that Kubota's been selling equipment since the early 70s, we're really proud of that statistic. Mandating parts be sold to the public at no profit will eliminate the significant value that we provide, and quite frankly, will force us to find other ways to keep our business viable. It wouldn't make sense for us to continue our investment in either inventory or payroll. We would appreciate the committee amending the bill to remove agricultural equipment and ensuring that language is clear that off-road products would be excluded. If the committee would consider adopting language from Minnesota, New York, or California, we'd be in alignment with such an option. Each of those states have enacted laws which fully exempt non-road industry equipment due to safety and emissions concerns. So we ask that the committee amend SB 3 Section 8 to bring in line with Minnesota's digital right to repair law, which includes our industry's non-road amendment. If the committee were to adopt Minnesota's legislation in its entirety, we'd be very supportive of the bill. Thank you very much for giving us this opportunity to talk about this.
Great, thank you very much. And yeah, the intent is to amend the language to adapt the Minnesota version. So thank you for your testimony. It's good to know that you would be supportive if we were to do that.
Thank you.
Next.
Yes, Mr. Chairman, up next, we have Daniel Fisher online.
Okay, great.
Chair Maroney, Chair D'Agostino, and other committee members, my name is Daniel Fisher, and I'm Senior Vice President for Government and External Affairs with Associated Equipment Distributors. I appreciate the opportunity to offer this testimony regarding SB 3, Section 8 of SB 3. AED is the trade association representing companies that sell, rent, and service construction, farm, energy, mining, forestry, and industrial equipment. Our members, which are predominantly small to medium-sized independent family-owned businesses, employ workers across Connecticut, providing well-paying jobs and serving as a positive force within communities throughout the state. F&W, who testified just before me, is an AED member, as is Monroe Tractor, who will be testifying later. In my written testimony, you can find a list of those companies those other companies who also operate in Connecticut. Our members have significant concerns with Section 8 of SB 3, and we urge you to adopt an amendment similar to what prior witness testified that in which you said you were going to do, similar to Minnesota, in a similar bills, which ultimately became law in Minnesota, New York, as well as California. SB 3 Section 8 application in the off-road industry is based on the false premise that customers are unable to fix their own tractors and machinery. To the contrary, equipment dealers make available diagnostic tools, repair information, parts, and remote customer support. Idle, non-functioning equipment equals lost time and money, whether it's on a road building project or a farm during harvest. We do everything we can as equipment dealers to keep the machine running. In my written testimony, I discussed the complexity of proposing right to repair laws to the off-road equipment industry and the many issues that arise and the impact on equipment dealers in Connecticut. However, for this statement, I'd like to highlight one area, and that's the scope of this proposal. The definition of agriculture equipment is so broad that it would apply beyond what is traditional farm equipment. As drafted, it could apply to construction, material handling, and virtually any type of equipment used in an agriculture setting. The diverse uses and customers of the equipment our members sell would make the application of this legislation significantly more far-reaching than I think it was intended. Given the scope, the negative impact on independently owned and operated Connecticut equipment dealers, the safety and environmental implications, and the lack of need for this legislation because equipment dealers support the ability of customers to repair their own equipment, AAD's Connecticut members urge you to oppose SB 3 as currently drafted and instead to adopt an amendment to Section 8 to exempt off-road equipment, similar to Minnesota. And we thank you for your comments that you're planning on doing that. So we certainly would support that. Thank you.
Thank you very much. Yeah, we are already in the process of drafting that amendment if it's not drafted yet. So
Appreciate it.
thank you
Thank
very
you.
much for your testimony. Next, Chris and Wyatt, did you want to come up together? Okay.
Good afternoon. Senator Maroney, Representative D'Agostino, other members of the General Law Committee. My name is Christopher Davis. I'm the Vice President of Public Policy for the Connecticut Business and Industry Association, joined here by our Associate Counsel Wyatt Bosworth. We'll be testifying on Senate Bill 2. CBIA is the largest business organization with thousands of members, employers, both small and large. 93% of our membership is less than 100 employees. My testimony on Senate Bill 3 is filed under opposition, but it's really just more of an expression of concern about potentially some unintended consequences with the drafting of the bill as current. Section 3 of the bill prohibits all businesses in Connecticut from advertising, displaying, or otherwise offering a consumer good or consumer service to a consumer at a price that excludes any charge or fee. This is broad and all-encompassing language for all businesses across the state. Does not take into account any of the many existing or upcoming regulatory frameworks, both at the state and federal level, that already ensure clear, accurate, and transparent information for consumers, and would add yet another layer of regulation on top of those on otherwise already extensively regulated industries here in Connecticut. Additionally, the terms deceptive and excessive are not defined and could lead to confusion for consumers and businesses alike. In regards to sections 2 and 6 of the bill, Connecticut obviously, and as discussed previously, has a very strong broadband network across the state. Also discussed earlier, there's significant federal funds that have come to address the affordability issues that we have. And the FCC very shortly, potentially in the next few weeks, if not by the end of the year, will have federal regulations and rules in place regarding net neutrality. So we respectfully just ask that the committee refrain from passing that specific framework here in Connecticut until those federal rules can be put into place so that there's no conflict or preemption issues with those regulations. And in terms of Section 8, as you just heard, and I think the committee has mentioned before that you're looking at amendments, we just respectfully ask that the committee continue to work with the numerous industries that have expressed concerns about the language there and continue to work towards that. Likewise, Senate Bill 201, very similar concerns as Section 3 of SB 3 for Section 1 of that bill. And CBIA supports the proposed prohibition of unfair service agreements that's contained in sections 2 through 6 of Senate Bill 201. And with that, I'll hand it over to Wyatt.
Good afternoon, here to testify. I told you I would be back last week when I testified on the licensing bill. So here to testify, commenting on Senate Bill 2, an act concerning artificial intelligence. So we know that AI has the potential to profoundly reshape and improve our society, our industries, And it also presents opportunities for unprecedented advancements in healthcare, education, bioscience, manufacturing, and other sectors. We also agree that it's crucial to address ethical concerns and potential risks associated with AI deployment and development. But we do ask you to exercise caution in this area to ensure that regulation at this early stage does not stifle innovation. We also urge the committee caution in regard to industries such as insurance, like you heard before us, financial services, healthcare, as those sectors already adhere to strict regulatory frameworks governing data protection and consumer rights. Second, we believe that working in tandem with all of you, with stakeholders, with the private sector, is crucial and will lead to policies that will help industry continue to innovate in this space while also ensuring the safety for both employers and the Connecticut residents they serve. That's why we were a proud partner with the AI Working Group and CASE, as Terry explained before, when we surveyed over 2,000 of our members to start to get insight into the types of technologies they were deploying, the problems they were having, the workforce concerns they had. And we're really grateful that 2 of the recommendations that came about from that survey were developed as a result of this engagement. So that's why we're proud to support a number of sections in this bill. Sections 14, which requires OHS to incorporate AI training into their workforce programs, collaborating with our workforce boards and the DECD. Section 15 and 16, which puts a number of requirements on the Board of Regents and the Charter Oak State College to, as you spoke about earlier, Senator, establish the Connecticut Citizens AI Academy. Also, providing courses and credentialing and badging to small employers and their employees who want to develop a career in this field. And then also Section 17, which requires DECD to develop a plan to offer high performance computing services, something that the survey specifically recognized as a major impediment to small employers wishing to innovate in this space. And then we also support Section 8 as well, the establishment of a continuing AI working group. That's important to continue the stakeholder engagement, and we'd love to have a seat at the table there moving forward. So I'll close by, I just want to respond to some of the private right of action comments that were made earlier. It's critically important, and I think the committee recognized that in the draft of this bill, that a balance is struck between redressing harms, but also allowing businesses to innovate in this space. We saw that through the bar on the private right of action, the rebuttable presumptions, the fact that proprietary information and other AI algorithms are not subject to FOIA. Things in that regard are just so important to strike that balance and making sure that businesses are not constantly under the threat of litigation, especially in an industry, in a field where definitions are changing, technologies are changing. Like I said, small employers don't even have the infrastructure or the governance models or the high-speed computing or the broadband access to deploy these tools. So we need to make sure that they're able to deploy these tools without the constant threat of litigation. So with that, happy to take any questions.
Great. Thank you very much. Thank you for your work, right, on the task force. I think that one of the things is we'll need to partner with you going forward as we create the Connecticut Citizens AI Academy. One of the video classes we want to create is around marketing for small businesses, right? How to use AI for marketing for small business, how to use AI for operations for small businesses. But in the survey, I think of the 83 respondents, half of them said they didn't expect to be using AI within the next 5 years. And I think that's just not understanding that they're already using it in their Google Maps and every day. And so that's on us to communicate and reach people. So we would love the opportunity to help you to partner to get that information out to your members. The other thing where I think we could use help is in creating that advisory board in Section 8. I believe that it makes sense for that to be something that is focused on economic development with that advisory board and continuing the conversation between academia, industry, and government. And so your thoughts would be appreciated on where it should be housed. Should it be a DECD, legislative, and then suggestions on what members we should make sure to include. And again, we want to make sure we are including a broad variety of voices in that. And thank you, for your testimony.
Yeah. And Senator, if I may, we're here to work with you. And the survey that we put together and that Terry sent out to our members, and we helped with that. You meant we had less than 100 respondents, right? We sent it to 2,000 members. So there was a tight turnaround in that survey, but I think there is some good information that came about. But that to say, I mean, we have to do a better job at reaching our members on that front. And, you know, if we can do more sophisticated surveying with our memberships or identify certain industries we want to ask these questions to, we're here to do that as well down the line as well.
Thank you. And I'm not trying to say that you're not doing a good job. I just
Yeah.
want to be very clear. I see this as a great opportunity for us to work together. We all need to improve our communication and outreach around this area. So thank you very much.
Yep.
Okay. Hearing no further questions, thank you very much for your testimony.
Thank you.
Yeah. Next.
Up next, I have Kyle Innes.
Hello.
Hi, please proceed.
First of all, I just want to thank you, Chair Maroney, Chair D'Agostino, Ranking Member Rutigliano, and Ranking Member Ciccarella, as well as the rest of the members of the committee for the opportunity to testify here today. My name is Kyle Innes, and I'm representing the Securities Industry and Financial Markets Association. We are an association of hundreds of broker-dealers and asset managers across the United States. And I'm here to raise what I hope is a very discrete and technical issue with SB 3 and SB 201, namely the provisions included in both bills on total fee disclosures. Our concern here is that, you know, as I'm sure you know, the financial services industry in many respects is very heavily regulated, and perhaps more importantly, that regulation is heavily enforced. One of the areas of this is really on the fees and the prices of our products and services to clients, and where there's a concern that there will not be a way to match the total fee disclosure requirements of the two proposals, while also meeting our regulatory and duty of care obligations to our clients. Just one quick example I'll raise here today, right? A client comes in and wants to make a trade of, you know, X shares of Y stock, right? Under our regulatory obligations, regulation best execution, the broker-dealer then has a certain amount of time to identify the most favorable market conditions pursuant to reasonable diligence to essentially secure the best price for the consumer. So while the end pricing of that whole transaction and the fees can be estimated, the total and precise price cannot be known, and is probably honestly often lower than the estimate in many cases. Yeah, there's a few other examples of how just the market functions differently than the traditional goods or services. And I'm happy to, you know, follow up and talk about that more at your leisure or your pace, as well as answer any questions that you might have today.
Great. Thank you. Are there any questions? No, you go first.
Good afternoon. How are you today, sir? Thank you for testifying. I have a question. So you don't know the fee schedule before you place a transaction, a financial transaction? You don't work on percentage?
So you might know the percentage, but as our folks are reading the total fee disclosure, you'd have to come up with like the actual price, right? And so if you say, I want to, you know, I have this number of shares of the mutual fund, right? There is an estimated, you know, there's an estimated ticker price. Then there's also, you know, order flow pricing, and a lot that kind of goes into which clearing firm do you go through at the time. And there's a lot that changes until, you know, once that trade is made, you have the percentage of that total price. But until that trade is made and all of those are known, you won't know that. You will not know that ahead of time. For example, you could clear through one set of operations at one price, but as you're going through the trade, the brokerage firm might identify a second opportunity to clear through a different area to actually save the consumer some money. And we would actually be required to find, again, that most favorable market condition.
But I have to be honest that you had me at the beginning and then you lost me sort of near the end. Would you be comfortable with if the law specifically said that you had to disclose what your percentage fee was to your client before you made the trade?
While that would while that would address the trade issue, like I said, there's a couple other examples that would potentially cause some issues as well, and which is why we're kind of seeking just a general financial services exemption. For example, one of the other options is, things that are priced to an index, right? We will sell you this at X price, but this is a variable rate product based on where the U.S. Treasuries markets is as of close of business at 3 p.m. Right. So that, again, that price is going to change and it would be estimated. I mean, like I said, there's some technical language probably to work around that might be able to meet the variable requirements that we're seeing. But again, just the way financial services in general functions, right? You have the indexed pricing, you have commissions, you have additional fees, you have agreements to where you give the fee schedule that your broker dealer charges, right? But then might be charges from the mutual fund, which is a separate company that is included in that transaction, and it's not really clear that where that one fee, whose obligation that one fee would be placed off of.
I have to be honest, I may turn this over to the good chair because I feel like it's almost intentionally confusing. Most of the time people just could tell you what their rate is. My next line of question was going to be whether or not you thought, like, if there was a performance bonus involved within a financial services account, whether you thought that was a fee that you would have to disclose before the people took the account. I do have a few extra questions about financial services, but I think I'm going to turn it over to Senator Maroney. Thank you.
So I would just say, if you have suggested language, not an exemption, but for some, I get it that there are some issues where you won't know the final cost, but if you could send us some language, whether it's percentage or other disclosure that would fit your example, the examples you've given, that would be appreciated.
Absolutely, we can work on putting that together and getting back to you, and also happy to speak further with perhaps some more knowledgeable market attorneys who might be able to explain in a little bit more detail how each of those kind of fees and charges operate.
Right. Thank you very much. So
up next, we have Anna Lucy with Matt Brill.
Good afternoon, Chairman Maroney and distinguished members of the committee. My name is Matthew Brill, and I'm a partner with the law firm of Latham & Watkins, and I'm appearing on behalf of NCTA, the Internet and Television Association, along with Anna Lucy, who's representing NECTA. I'm here to talk about SB 3, which addresses a broad array of issues, but my testimony will focus on sections 2 and 6, which would impose mandates relating to affordable broadband service and net neutrality. NCTA and its members are leaders in providing affordable broadband services and are fully committed to maintaining the open internet. But we respectfully submit that it is unnecessary and would be counterproductive and unlawful for the state to impose the affordability and net neutrality mandates contemplated by SB 3. With respect to Section 2 of the bill, the proposed requirement for internet service providers to offer broadband plans with state-mandated speeds at $40 or less per month is entirely unnecessary. Connecticut, as we heard earlier, is a national leader in broadband availability, with more than 99% of residents having access to broadband at downstream speeds of at least 100 megabits per second. And even if the federal Affordable Connectivity Program is not renewed, NCTA's members have established comprehensive low-income broadband programs. Through these programs, NCTA members already offer affordable broadband services to eligible households at prices well below $40 per month. But we have serious concerns about the state's proposed foray into rate regulation. Such rate regulation is not only unnecessary, but it's preempted by federal law. Notably, when New York adopted a similar mandate in 2021, a number of parties challenged the law, and the U.S. District Court in the Eastern District of New York invalidated that state law on multiple grounds, multiple different preemption doctrines. New York's appeal remains pending in the Second Circuit, and at a minimum, the state should await the outcome of that proceeding before considering a similar mandate. Section 6 would impose net neutrality mandates, and it is likewise unnecessary and would present significant legal risks. NCTA's members and other leading broadband providers have all made public commitments to refrain from blocking, throttling, and paid prioritization. And we are fully transparent regarding network management practices, prices, and service attributes. Maintaining the open internet is a core aspect of how my clients operate, and consumers would tolerate nothing less. Although we don't believe government mandates are needed, given how entrenched openness has become in the marketplace, the FCC has proposed comprehensive net neutrality requirements and is poised to adopt a final order within the next few months. That eliminates the need for Connecticut to consider similar mandates. The FCC chairwoman, Jessica Rosenworcel, has recognized the need for a uniform legal framework that applies to the whole country. And the FCC's 2015 Open Internet Order similarly recognized that state regulation would undermine the FCC's carefully calibrated regime, in particular, a patchwork of differing state laws, including different prohibitions and requirements, would create significant burdens and uncertainty that would undermine the consensus goals of promoting increased investment, deployment, and innovation. To the extent the state is concerned that a federal court might invalidate the FCC's rules, any state rules would be on equally or greater shaky ground from a legal standpoint. The FCC has consistently held on a bipartisan basis that broadband internet access is an interstate service. And based on that jurisdictional status, which doesn't depend on the classification as an information service or a telecom service, there is no intrastate component that can be separately subject to state regulation. That's precisely what the Eastern District of New York held. Ultimately, there's no need to take legally questionable action because consumers enjoy the benefits of the open internet and will continue to do so. I look forward to answering your questions.
Great. Thank you very much. Senator Kissel.
Thank you very much, Chairman Maroney. During your testimony, you said that New York State, our neighbor state, passed a similar law and that it was challenged in court and that challenge was sustained. I get concerned when the issue of preemption comes up. I think you indicated in your testimony, Mr. Brill, that that was now appealed to the Second Circuit, which has jurisdiction over Connecticut as well. So my radar goes up because I don't want us to pass something that buys us a lawsuit as a state. What were some of the grounds that the district court used in striking down the New York law, if you know? And if you could maybe shoot me or the committee members through the clerk an email or something with the case citation, so in my free hours, I could maybe peruse actually what's going on with this particular case that's now on appeal. But what were the grounds that the district court judge used, or he or she used, in supporting the challenge to the New York law?
Thanks, Senator. We'll be happy to provide a copy. There were two basic holdings under what's known as conflict preemption and field preemption. The conflict between federal and state law arose because the FCC had classified broadband at the time as an information service and specifically held that a state could not impose common carrier rules. And rate regulation was deemed to be a classic form of common carrier regulation. So that conflict between the FCC's holding and rate regulation was one of the principal problems. And I should note that problem will remain even if the FCC, even assuming the FCC goes forward with its proposed reclassification of broadband as a common carrier telecom service. And that is because the FCC has said it will unequivocally forbear from any forms of rate regulation and deem rate regulation unlawful. So that conflict between a state regulation that regulates rates and federal law will remain under the conflict preemption doctrine. The second ground is known as field preemption, and that arose because of the interstate classification of broadband. The FCC has exclusive authority to regulate broadband services, including in particular any regulation of broadband rates. And the court held that under binding Second Circuit precedent, which goes back several decades, a state attempt to regulate interstate communications rates is foreclosed.
Well, I'm digesting that information. And if you could, again, along with the case site, if you could just shoot a copy of that district court decision for our perusal, I think we could find it helpful. But that's the extent of my questions. But again, appreciate your testimony. Thank you, Chairman Maroney.
And Senator, if you wouldn't mind if I just added to Matt's testimony there, just to bring it on a more local level as behalf of the New England Connectivity and Telecom Association, and we represent substantially all the cable broadband providers in New England and Connecticut, that our members follow net neutrality principles. We do not block, throttle, discriminate, or interfere with the lawful online activity of our customers. That is our guiding principle. It's in our DNA. It's bad for business. So just more taking it on that consumer level. That's our commitment to our customers. We're not looking for a patchwork of regulation, which is what Matt speaks to today, but just wanted to make sure for the purposes of who your constituents are today and our customers, we are following net neutrality.
Representative Tigliano.
I just wanted to thank her. Because like you didn't testify after Mr. Brill finished, so I didn't know if you wanted to add something. I just wish you could work this out with the majority leader of the Senate. But anyhow, thank you.
Just for my own edification, because the committee hasn't really taken up the issue of net neutrality before. And I have memories of 15 years ago when this was a topic, but it hasn't come up recently. I was just hoping that you could explain it a little better and exactly what it is and how it works. Either one of you. So,
Well,
yeah.
Matt,
Just
I'll let,
start talking.
Yeah, I'm happy
Matt
to
is our
start.
ranking net neutrality expert, so I will let him hit that one out of the park.
Yeah, the
Basically what the rules are. What are the rules?
The basic principle is one of non-discrimination and ensuring that consumers have the ability to reach websites and services of their choosing without interference from their internet service provider. And our companies absolutely adhere to that principle. We're not going to try to block a consumer from going to his or her chosen website, using an online service. We're not going to throttle speeds to disadvantage one website over another. And we're not going to try to create fast lanes and slow lanes, speed up traffic or slow down traffic. Those are the core net neutrality principles at issue.
So if the state imposes some sort of net neutrality regime, would they be asking you to basically you're going to continue doing what you're doing right now, but in an anti-net neutrality world, do you throttle certain websites or speeds for certain people or certain times a day? What exactly is that policy trying to fix? Because I got to be honest with you, I haven't had an internet issue in forever, so I'm confused.
Yeah, we don't think there's a problem that needs to be solved, Senator. Right now, there are no rules in place.
No demotions for me, please. I'm in the House. At the Senate would be a demotion.
Sorry,
Clearly.
Well, the rules have had a tortured history at the federal level. They were these rules I described were imposed by the FCC in 2015. They were taken away at the beginning of 2018, and we're now on a debate where the FCC is proposing to reinstate them. There's a robust debate around this, and our industry doesn't favor these rules because we think while we absolutely support the principles of net neutrality, the legal framework that's being proposed in support of them could lead to rate regulation and other more intrusive forms of regulation that we think would be very harmful. So we don't think the rules are necessary. But in all events, if there's going to be a set of rules, we think it needs to be a uniform set of rules at the federal level, because differing state rules or differing interpretations, even of identical rules, are going to lead to conflicts, inconsistency, and uncertainty. And ultimately, that's going to impede broadband investment. It's going to slow down deployment, and it's going to hamper the goals that we all share.
So my other question is, how would the government know if you're throttling or blocking, or are most of these companies A, located in Connecticut, and B, are the servers used to access the internet, are they all here in Connecticut, or are some of them located in other places?
Well, the communications are inherently interstate because the servers are not just located out of state, but globally. And so the internet traffic is divided into packets, and those packets are dynamically routed all over the world. So there's not any communication like a local telephone call from one point in Connecticut to another. And that's precisely why the courts have said states can't regulate this type of service and this type of traffic. In terms of how anyone would know, there are diagnostic tools. We've all taken speed tests online with services like Ookla, and there are more sophisticated tools that could detect throttling. More importantly, the FCC, the one rule that's been in place all along is called the transparency rule. And all internet service providers have a duty to disclose to their customers and to the world on their websites what network management practices they employ and whether they block or throttle or create fast lanes and slow lanes. And all of the companies have said they do not. So they're already subject to significant oversight and liability by the Federal Trade Commission, state attorneys general, because if they don't keep those promises, they're certainly at risk of being held liable for deceptive and unfair trade practices. So we have that commitment to openness, and it's fully enforceable today.
I appreciate that answer. So I guess it's fair to say that even if the state came up with a regulatory scheme and maybe found some sort of issue, they may not have the authority to come after any of these companies that might be doing it because they're probably not located here in Connecticut.
Well, we certainly have internet service providers operating in Connecticut, but the courts have held that because this service is interstate under the Communications Act, that only the FCC can impose this type of regulation. And we think ultimately any state rules would be at best duplicative. They would not add any value because this is an area where the FCC is very actively engaged.
And Rep, just to add some local flavor there, you are correct. Our member networks, they do not stop at the Connecticut border. They are regional. I know some are shared between Connecticut, Massachusetts, Connecticut, New York, but all that. So to have one set of rules that operates network operations, how, if Massachusetts starts putting in something different and you cross that border, how does that work?
I appreciate that answer. And just my last couple of questions, I guess, would be on cost, whether you have an opinion about a cost. I was talking to some folks, and they said that there's potential to get internet for some folks around $12 a month or $15 a month. And then if we come in and say we're setting a price at $30, do you think that those lower promotions would go away, or the prices actually, we may actually see an increase because now we're creating a floor? I didn't know if your organization had an opinion. I mean, I know you're probably against price controls. I appreciate that, but an opinion directly, whether there is cheaper internet out there that people are accessing.
Yeah, I can speak to that. I mean, we put in our written testimony some of the price points. Comcast has a 50 megabit service for $9.95 a month. Charter has a 50 megabit service for $24.99, and Cox has a couple of tiers at $30 or $10, depending on the speeds and eligibility. So, I mean, we do acknowledge that this proposed $40 ceiling is consistent with the low income pricing we already have. Our concern is that the government doesn't belong in the rate setting business, and prices are going to change over time. And we heard earlier an allusion to the concern about fixing a broadband speed in legislation. But it's as a matter of principle, rate regulation of an interstate service is not within the power of a state. And when states have attempted to do so, as I mentioned, the New York federal court struck that down, and I'm certainly happy to forward that opinion.
Well, I appreciate that. And it's just my last question, that $9.99 plan that you said, would that be considered high speed, that the number that you?
Absolutely. So the draft bill mandates a speed of 25 megabits per second downstream, and Comcast and Charter are both providing double that. Cox is providing 4 times that speed. So the speeds that our members' low-income plans include are faster than the law requires, and the prices are lower. But again, we don't think the state should be in the business of setting prices or speeds.
And Representative, our companies have had those programs pre-pandemic. They've had a lot of experience with them, and they raised those speeds without being asked, just to accommodate more traffic on the net. What's necessary? What do people need in the homes?
Well, I appreciate your answers. It was an interesting conversation. I feel a little bit more informed. So thank you very much.
Thank you, Representative Brown.
Thank you, Mr. Chairman. I would also like to feel the way Representative Rutigliano does in understanding this better. So my question is, can you define for me throttling? Because it doesn't seem to be clear when I'm guessing throttling isn't intentional versus just having slower download and upload speeds. So could you define that for me just so I understand that?
Certainly. The FCC has defined throttling as an intentional discriminatory act where the internet service provider is deliberately slowing down traffic based on the identity of the website it comes from, or for some anti-competitive reason. That's different from congestion that can occur when the internet is being highly utilized at a busy time of day, if everyone's trying to watch Taylor Swift all at once or something of that nature. But throttling is defined as an anti-competitive practice of deliberately slowing down traffic based on its origin or destination.
And I know, I appreciate that answer. And I know you mentioned that you and your clients are not in the business of doing any of these things. So is there a legal way to throttle someone or use a different term to describe slowing down intentionally internet speeds?
So, our clients have committed not to do what the FCC calls throttling. And again, we've made those binding commitments in our terms of service and they're enforceable. I think this debate gets confusing because we all sometimes use the term throttling a little differently, not in this legal sense when we talk about our wireless services. Wireless companies often offer an unlimited plan that offers you, say, 20 gigabits of data a month, after which they're going to slow down the speed. That is often euphemistically called throttling. It is not what the FCC has prohibited or proposed to prohibit as throttling. So I think that can be very confusing because the word is used in those different ways. But the rule that the FCC has proposed is deliberately slowing things down without disclosure for anti-competitive reasons.
Right. And yes, that's why I brought that up, because I'm a former T-Mobile employee and I know that we offer unlimited data, but they don't tell you at all because it's unlimited technically, but how much is 4G, 5G versus 2G, what they end up putting you on, that ends up being what I'm going to say is throttle, regardless of the FCC's definition. It's intentional slowing down based on your preference or what you think your servers can handle. What about former devices? So there's technology upgrading all the time where they lower you on the spectrum of the internet services you're getting in terms of speed, where if you have an older device, you may have gone from 5G prior to them coming out with this new device and now throwing you back down to 2G, and they'll tell you that your device just isn't compatible with the new towers. Isn't that a form of throttling as well?
Well, not under the FCC's definition. And I think, again, this is one of the reasons we're concerned about state laws entering in this arena, because this term throttling may be used in different ways by different states, by the FCC, and we need uniformity so that there's consistent enforcement of rules and a consistent understanding of what's required. I acknowledge it's confusing. The rules that the FCC has proposed wouldn't apply to a device limitation. So if I have an older generation iPad and I can't receive speeds that are as fast as the broadband provider is offering, that's not throttling under the FCC's definition. But, as a consumer, you may be frustrated. You may not know why you're receiving a slower speed.
Well, I appreciate that answer. I tend to disagree with the FCC's definition. I think you agree with it based on your reference to it, but I do appreciate your answer on that. Thank you, Mr. Chairman.
Thank you. There's a question online. We have a question online.
Thank you, Mr. Chair. I was just hoping that you could expand a bit more about the FCC's open internet order and kind of what effect that has had on broadband investment in general.
Thank you. So one of the reasons that the FCC revoked some of the previous rules, the 2015 rules, was because it concluded that these common carrier mandates, the threat of heavier regulation, including rate regulation, was suppressing broadband investment. We've been fortunate that over the last couple of decades, we've seen enormous investment and constant increases in speeds. I put in my testimony some of the increases that we've seen over the last decade. But after 2015, the rate of investment did slow and the rate of deployment fell off. And after the FCC relaxed these rules and restored the light touch approach that had been in place since the internet's founding, we saw a corresponding increase in investment, an increase in deployment. And during the pandemic, during the greatest challenges that internet connectivity has ever faced because of the spikes in demand when we were all working from home and kids were learning from home, networks held up incredibly well. So those investments paid off. So our industry believes that the light touch approach is the correct one. It has fostered speed increases, greater investment and deployment, and is the right approach. But as I've said in the testimony, in all events, the FCC is putting back rules that are heavier handed. And that is especially a good reason for Connecticut to refrain from trying to duplicate those rules.
Thank you. And I look forward to, seeing more of what you can provide to the committee, just to learn more. Obviously, it's complex stuff, but I appreciate your testimony. Thank you, Mr. Chair.
Thank you. And I have a question in regards to, are either of you familiar with the New York State executive order where the state will only purchase broadband services from companies that agree to abide by net neutrality principles? And if you are, I would wonder your thoughts on that, that policy.
I am, Senator, and we've addressed this. It's in footnote 7 of my testimony. There's a legal doctrine that involves something called the market participant doctrine. And so a state like New York or Connecticut can certainly dictate in its contracts, if it buys internet service for the state offices, you can prescribe requirements in a contract as to how you as a customer or a market participant will be treated. What you can't do under the Supreme Court law and the Second Circuit law is use that as a vehicle to regulate more broadly how that internet provider treats consumers generally. You can't dictate in a contract how other customers outside the contract are going to be treated. And so courts have found where preemption applies that the use of a procurement vehicle does not save the law from preemption.
Great. Thank you very much. And you've submitted the written testimony, I believe, correct?
Both of us have, yes.
Okay, great. Thank you. Are there any further questions? If not, thank you very much for coming to testify.
Thank you.
Okay, Mr. Clerk?
Up next online, we have Kelton Mormon.
Wonderful. Is the technology working okay?
Yep, yeah, we can hear you and see you. Please proceed.
Okay, great. Good afternoon, honorable members of the Connecticut General Assembly. My name is Kelton Mormon, and I am here to discuss an urgent matter, the regulation and ethical deployment of artificial intelligence through Bill SB 2, titled An Act Concerning Artificial Intelligence. This legislation seeks to guide the deployment or the development, deployment, and utilization of AI technologies within our state, ensuring that these powerful tools serve the public good, safeguard our citizens' rights, and foster economic prosperity, and I fully support the bill. The need for this bill is threefold: to address ethical governance, enhance education and workforce development, and align with both precedent and the practical benefits of AI regulation. Our society increasingly relies on AI in various sectors, such as healthcare, finance, and public services. The need for oversight is evident because 27% of executives worldwide are integrating AI into their operations, and an additional 46% are running pilot projects. Without oversight of AI development, it risks perpetuating biases. For example, when lenders use AI, the home denial rate for Black Americans was 17.4%, which is more than double that of non-Hispanic whites, which was at 7.9%. Therefore, by establishing an artificial intelligence advisory council and setting clear mandates against deceptive practices, Connecticut can lead in fostering AI use that is equitable, transparent, unbiased, and accountable. As AI reshapes our economy, we must prepare our workforce for the future. The bill's provisions for AI training and development of AI education programs by the Board of Regents for Higher Education and the Department of Economic and Community Development are not just necessary, but vital for ensuring our citizens are not left behind. With an ever-changing society of AI, we must educate our labor market and ensure Connecticut's hardworking families are prepared for the inevitable changes it will bring. Additionally, Connecticut is not alone in recognizing the importance of AI regulation. In 2022, Vermont passed a bill establishing the Division of AI within the state agency and the digital services to conduct an inventory of all automated systems developed or deployed by the state. It also proposed a state code of ethics on the use of AI. Similarly, Texas passed a bill in 2023 that created an artificial intelligence advisory to study the effects of AI and report findings to the legislature. Since these bills are very recent, the time to act is urgent. The economic benefits of AI cannot be overstated. By embracing AI and ensuring thoughtful regulation that balances innovation with ethical considerations, Connecticut can enhance consumer experience, create new markets, and ensure sustainable economic growth. In conclusion, SB 2 ensures the benefits of AI technologies are realized equitably, responsibly, and sustainably. By supporting this bill, we safeguard our citizens' rights and well-being and position Connecticut as a leader in the ethical deployment of AI. I urge you to pass the bill, setting a benchmark for responsible AI use that can inspire our state and the entire nation. Thank you for your attention and considering the impact of this legislation.
Thank you very much for taking the time to testify. And we'd welcome your input as we move forward. On the data privacy bill, we did have a few students. I think it was Chris DeSantis and Kyle Mayer that had worked with us. They probably graduated by now since that was 2 years ago. But does anyone have any questions? I think we talked about the economic benefits. I'm going to put a question to you. One of the things that we need to do as a state is we have the best and brightest students coming here to study from out of state, coming to Yale, Wesleyan, Trinity, UConn, many of our institutions. what can we do to get you guys to stay here after you graduate to help our economy?
That is a good question. Yeah, I'm not exactly sure on how to answer that question. I've only been here for a year, and I really enjoy at least where I'm staying, and I really enjoy the New Haven community. But yeah, I'm not exactly sure on how to answer that question for you. So
Well, it's a problem we've been working on for years, so I don't expect you to answer it in seconds. But if anything comes to your mind, please reach out. And any suggestions on how we can improve the legislation would be appreciated.
Of course.
Again, thank you for taking the time to testify.
Thank you.
Okay, next.
Yes, next online, we have Alex Spiropoulos.
Good afternoon. Can everyone hear me okay?
Yes, we can hear you. Please proceed.
Awesome. Co-Chair Baroni, Co-Chair D'Agostino, members of the committee. My name is Alex Spiropoulos, and I'm the Regional Policy Manager for the Northeast at the Computer and Communications Industry Association. Thank you for the opportunity to provide comments today on SB2. I've also submitted lengthier comments for the committee's consideration. CCIA is an international not-for-profit trade association representing a broad cross-section of communications and technology firms. Proposed regulations on the interstate provision of digital services therefore can have a significant impact on CCIA members. CCIA's members have engaged in responsible artificial intelligence development through the development and application of their own responsible AI principles, conducting academic research that promotes privacy by design, and the hardening of AI against motivated attackers seeking to extract training data. CCIA understands lawmakers' concerns regarding the potential risks posed by artificial intelligence systems and has published a white paper as a resource to understand how approaches to regulation can balance mitigating risk without creating barriers to innovation. CCIA appreciates several of the approaches that the legislature has included in its proposed legislation, including the adoption of a risk-based approach to regulation, as well as the amendment to Connecticut's existing non-consensual intimate imagery statute language to bring AI-generated images within the scope of the existing law. Our initial concerns with the proposed legislations are focused around the breadth of definitions as well as liability. The AI systems that lawmakers seek to regulate are complex and warrant adequate understanding to reach intended outcomes appropriately. Within the artificial intelligence ecosystem exists a multitude of variations in which AI is utilized, including automated decision-making, machine learning, and machine perception, to name a few. Each of these systems have their own nuances. For example, businesses in every industry sector employ AI to increase competitiveness and enhance their products and services, ranging from routine and low-risk applications such as filtering and spell check to credit scoring algorithms and generative AI models. The use of AI systems has enabled small businesses to effectively market their products to the right consumers at affordable prices and allows for better customer experience and cheaper prices. CCI suggests including a tailored definition to reduce vagueness and to ensure that appropriate oversight is installed without hindering further AI development. Secondly, due to the many applications in which AI can be used, it is important to limit liability to instances that cause harm. It is important to consider different entities involved in a given AI-driven model, including the developer that builds an AI system, the deployer who applies the model to a given task, and the user who ultimately utilizes the system. Each of these entities could bear responsibility for outcomes arising from the use of an AI system, depending on the circumstances, but those circumstances are important to consider. SB2 would place several requirements on the developers and deployers of AI systems to prevent against algorithmic discrimination prior to their distribution and use within Connecticut. Beyond the protections that would be installed prior to the use of an AI system, it is possible that individual users of an AI system could utilize the system in a way that would be harmful to others without the knowledge of either the developer or deployer of such system. As such, we suggest that the legislature include an explicit carve-out for the developers and deployers of general-purpose artificial AI systems so that they would not face liability for user action, provided they are in compliance with their requirements under the proposed law. This is something that we've seen included in proposed Utah legislation that is currently being considered by their legislative body. CCIA appreciates the work that the Connecticut legislature has done in technology policy space in recent years and is encouraged by the opportunity to work with the body again as it takes up the subject of artificial intelligence. Thank you again for the opportunity to testify. I'm happy to answer any questions.
Great. Thank you very much. Are there any questions? Representative Brown.
Thank you. I appreciate your testimony today. You mentioned almost like a shared responsibility between the manufacturer of the technology, the business who uses it, and then the end user. What would that look like in terms of actually you going through the judicial process or to seek some type of, I don't know, relief? What would that look like?
That's a great question, Representative, and I appreciate you raising that point. I think obviously as things are evolving at such a rapid pace, we're seeing these examples play out in front of us as ever evolving landscape. I think it's just important. What we're sort of looking for here is to create an understanding that there are multiple ways in which AI systems could potentially be used with negative implications for others, and making sure that each individual actor who's involved with the creation, the deployment, or the actual use of the AI system could be held responsible, not so that it's only left responsible to either the developer or the deployer. So I think understanding that there are individual users who can be individual bad actors who are leveraging this AI system in a way that would have negative implications for others, and making sure that those individuals are held accountable as well.
So in other words, almost like proximate cause, which user at the end of the day resulted in whichever was the complaint filed. Is that right?
In a way, yes. I think that would be similar to what we're sort of looking at. I think it's just ensuring that there is accountability at all levels of the creation, deployment, and in fact the use, where we can see individuals taking action without the knowledge of those earlier two institutions that have helped contribute to the AI system.
No, thank you for that answer. Thank you, Mr. Chairman.
Thank you.
Thank you. And did you submit written testimony?
Yes.
Okay. And did you reference the Utah legislation in there? I haven't seen that yet. So
yes, there is a link in the footnotes that includes a link to the Utah legislation.
okay. And it sounds similar, I guess, to what the EU was doing in terms of exempting the general purpose AI if there are certain disclosure requirements, model cards, parameters, disclosing data, I guess, summary of the data training. Is that along the lines of what they had done in Utah?
I'd have to go ahead and double check the EU language just to be 100% accurate, but I think, I believe it was drawn from there. There was some inspiration from the EU.
Okay, great. Thank you. And I think, appreciate when you talk about the privacy by design. And I think that's one of the things we're looking at here. And we keep hearing reference to it early on in this revolution, but just making sure that we're, building in the right concepts from the beginning. I think, I heard after going through the data privacy, if we had built things with data privacy in mind, they may have then been built differently from the start. So I think we're looking at correct by construction, right? Making sure that we're integrating good practices. But I really would appreciate, any feedback that you could provide as we move forward.
Absolutely. Would love to be a part of the committee and legislature's process on this legislation.
Great. Thank you so much for your testimony.
Thank you.
Next.
Up next online, we have Grace Gadai.
Hi, thank you. Good afternoon, esteemed members of the committee. I'm Grace Getty, and I'm with Consumer Reports, where I work on behalf of consumers on artificial intelligence policy. Consumer Reports is an independent nonprofit, and we represent 6 million members across the country. I'll be commenting on SB2. Thank you so much to the lawmakers who worked on this, particularly Senator Maroney. It is a massive undertaking to legislate on emerging technology, and we appreciate your leadership. I'll start by highlighting something we really like about this bill. We appreciate that this bill holds developers and deployers of automated decision tools accountable for protecting consumers from discrimination. This is critical. We also think there are some places this bill should be strengthened, and I'll highlight a few today. First, we think consumers deserve specific, accurate, clear, and actionable explanations of consequential decisions made with the help of automated decision tools. We'd urge lawmakers to consider adding that requirement to the bill. As currently written, the bill would require companies to notify consumers before these tools are used to make a decision, but it's also critical that consumers receive an explanation of the decision after the fact. The explanation should, at a minimum, allow a consumer to determine if the decision was based on inaccurate information about him or her. Why? We know these tools sometimes make recommendations based on faulty information. Research cited in my written testimony has identified renters who were denied apartments because a tenant screening company confused them with different individuals who had the same names but had criminal histories. Explanations after adverse decisions is a familiar concept in other areas of consumer protection law. Already, lenders are required to provide specific and accurate reasons when they deny someone credit under the Federal Equal Opportunity Credit Act. We'd also like to see the consumer notice fleshed out a bit more. A second area we'd like to see strengthened is the narrow definition of automated decision tools. Companies can, and often do, say that they're using automated tools just to assist or contribute in their decision-making. Even if that's not an accurate description of how they use the tools in practice, it's not clear how that error of self-determination would ever be discovered. Once companies make that self-determination, they escape the other accountability measures in this bill. Recent research found that a similar legislative drafting issue has hampered compliance with New York City's AI bias law, which went into effect several months ago. And a third area we'd like to bring to the committee for consideration is the responsibilities that companies have that are making and using automated decision tech to protect consumers from harms beyond discrimination. These tools present a range of other potential harms, and this bill creates a broader duty of care for developers of generative AI tech in Section 4. We think the same standard for the same harms should be applied to companies making and using automated decision tools in consequential decisions. These issues can be addressed with minimal disruption to the text of the legislation, and we look forward to working with Senator Maroney and other sponsors of this bill to ensure it fully protects the consumers of Connecticut. Thank you. Happy to take any questions.
Great. Grace, thank you very much for your testimony. And I know you had submitted written testimony and you did have some recommendations in there. So thank you for your help. We look forward to working with you going forward.
Fantastic.
Okay, next.
Next up, Marisa Belair.
Oh, sorry. Sorry, you can tell I'm new here. Good afternoon, Chairman Maroney and other distinguished members of the General Law Committee. It's my privilege to be here today. My name is Marisa Belair, and I am the current president of the Connecticut Trial Lawyers Association. I'm also a practicing attorney in New Haven, Connecticut at the law firm of Lynch, Traub, Keefe, and Arante. As this committee knows, we submitted opposition testimony to Senate Bill 2, and while couched as an opposition, I really want to underscore the fact that we truly appreciate all the great work that this committee has done in trying to get to the forefront in regulating AI, particularly given that our Congress and our federal government has chosen not to act. So I do want to say that we do appreciate all the good work that this committee has put into trying to come up with some regulation for AI here in Connecticut. That being said, I do want to express some concerns that we have with the bill, and it's my hope that this will engender a dialogue between ourselves and this committee to help strengthen the bill to help protect all of the citizens of Connecticut. First, I'd like to talk about Section 7D of the bill. This particular part of the bill removes the right of any citizen to bring a private cause of action. And why is that important? Right now, under the laws that exist in this state, citizens have the right to go to court if they feel that they have been victims of discrimination, emotional harms. There's a whole host of different reasons why someone would want to access our court system. And so we want to make sure that it is, we preserve that right, particularly given that we're dealing with an ever-changing technology, AI. We don't really know what it can do. We don't know what it will do in the future. And we just want to make sure that citizens have the rights that they currently have. Section 7A also poses some concerns to us. And the reason for that is that that section in particular makes the AG the sole enforcer of any violations. And the way I read it, it makes the sole enforcement provision of the AG to be under CUTPA. And as we talked about our concerns with 7D, these two things kind of go together. Individuals currently excuse me, individuals should not have to solely rely on the Attorney General to enforce concerns that they have. And the reason why that's a concern is because resources may be an issue. There may be political agendas. We want to just make sure that there is another arbiter of the enforcement provisions as outlined in this particular bill. The other concerns that I want to express to the committee are sections 2, 3, and 4. Those sections of the bill create rebuttable presumptions in any enforcement action brought by the AG that a developer or deployer may use. As you may know, a rebuttable presumption is a presumption that is true until proven otherwise. It effectively shifts the burden, the way the bill is currently written, to the AG to prove that the developer did not use reasonable care. Currently, consumers and citizens of our state have the right to bring a CUTPA claim or civil claims, and no such rebuttable presumptions exist. So this effectively changes current law under which developers and deployers have such an obligation to use reasonable duties of care. We also want to point out that there is a definition section in section 1, which talks about algorithmic discrimination. The conditions outlined in this definition are the type that currently can be subject to discrimination claims. So we'd appreciate the opportunity to work with the committee to modify that definition in some way so that it isn't so problematic. I see that my time is up, but I'm happy to answer any questions that members of the committee may have.
Great. Thank you, Senator Kissel.
Thank you very much, Chairman Maroney. I'm sure as you've been here all day, Attorney Belair, you heard me championing the trial lawyers earlier today. I took great solace in the fact that it appears that Senator Looney is open to some of the changes that were put forward. I feel pretty confident that you folks can work directly with the chairs of this committee to make some of those changes. I think this bill also, through some of its implications, probably has to come over to the Judiciary Committee at some point as well. But I agree with you wholeheartedly, and I just can't champion the cause of the trial lawyers any higher, because you really do stand up for people's civil rights and the cause of justice throughout the state of Connecticut. And as I stated, I had the great pleasure of serving with our current Attorney General as co-chairs of the Judiciary Committee back in 2018. I was just with him when he made an announcement regarding suing several corporations, I think in excess of 20 on PFAS violations. But I think that we need the private bar to be involved in monitoring this as well. And you're exactly correct when it comes to the burden of proof. That could really work an injustice going down the line. And a lot of people don't recognize that these, I would suspect that these are going to be as difficult cases as some medical malpractice. I mean, I don't see the bar taking these willy-nilly, especially against some of these mega corporations that have just fleets of attorneys to defend themselves. So I appreciate your testimony here today and keep up the good work. And it's great to see you again. Thank you, Mr. Chair.
Thank you, Senator Kissel.
Thank you. Representative Ackert.
Thank you, Mr. Chair, and thank you for your testimony. A question, as many people prior to you that, since you've been here quite most of the day, have mentioned other legislation in other states. Do you represent any of the similar legislation that would be different than what we have in front of you regarding the trial lawyers and their state's attorney generals?
That's a good question, Representative Ackert. I do not reference any legislation that's in any other states. The only real situation that I am aware of is related to the Illinois case involving Facebook, where there was some biometrics used and Facebook was held accountable because it was storing data without participants' knowledge. And so I think what was critical in that particular case is 1.3 million citizens of Illinois were affected. And I think we know that AI is ever changing, which is why I can't say that we appreciate wholeheartedly all the work that this committee is doing. But in that particular case, it was extremely important for the citizens of Illinois to have a private right of action to actually seek redress in the court system, which is a court system that we feel is functional. It works. There would be probably no real way for an AG to have undertaken securing justice for 1.3 million citizens. But to follow up on the other aspect of your question, I'm not really aware of any other legislation in other states, certainly that we're citing, because I do feel that Connecticut is on the cutting edge of this issue.
Well, I thank you for that response. You know, I have seen, sounds like there are other states that have some type of legislation that people have. New York was cited earlier. So I think that's something that, you know, we could look at. And I know that senators probably looked at all of them more than once, Senator Maroney and others. And so I do appreciate your testimony. Thank you for being here.
Thank you.
Thank you, Mr. Chair.
Thank you. And thank you for pointing out, I think it was in section 7 where we said in any other law, right? There's not an intent to take away existing rights for anyone. So we need to make sure that that's clear. Just a question, you know, right now, a lot of our discrimination cases are handled through CHRO. What would your thoughts be of adding CHRO as part of the enforcement mechanism?
So Chairman Maroney, that is actually a good suggestion, but I don't think it's a workable one. And the reason why is there are so many different types of discrimination, civil rights being one main one, and that I do think it's important for citizens of our state to have the right to go to courts to seek redress. While the CHRO could be used as an additional resource, changing the way our citizens access justice is not necessary simply because we're talking about AI companies. But again, I'd be willing to work with you and other members of this committee to discuss our concerns in greater detail and to come up with a change that I think our overarching goal collectively is to protect the citizens of our state.
Okay. Representative Brown.
Thank you, Mr. Chairman. How are you?
Good. How are you?
Good, thank you. You mentioned in sections, you said 2, 3, and 4.
Yes.
Where it talks about rebuttable presumption. And for the non-attorneys, which I am not one, that just means innocent until proven guilty, essentially.
I
right?
couldn't have said it better myself.
Okay, so in this section that you reference, it says that if the producer has followed essentially everything listed within these statutes, then we deem that to be, you know, rebuttal presumption. So what's the issue with saying that if they followed all of our guidelines and sections and they did everything to the letter of the law, why wouldn't they be innocent until proven guilty?
I understand what you're saying, but I think the concern here is that since this is such an ever-changing technology, simply assuming that someone meets certain criteria, what are the enforcement mechanisms for ensuring that they do act in the ways identified in the statute? And that's why I think it's extremely important that we make sure that we preserve the rights of action that our citizens currently have to exercise justice in our court system. So I do applaud the committee for, you know, really diving deep and inundating very specific circumstances and obligations by which these developers and deployers need to comply. But, you know, I'd like to say I am an optimist, but being a lawyer, I've seen so many harmful cases that it really strikes me as I have to be somewhat pessimistic. And I just really want to make sure that we are protecting our citizens, which I know is what your goal is.
Yeah, and thank you for clarifying that because I didn't understand it. Usually I like to say innocent until proven guilty for all things, but I get that the laws will change, technologies will change. And even though they follow these specific rules, there may be things that we're not thinking of down the road and that they would be free of any charges because we didn't list them in this.
Right.
So I appreciate your answer. Thank you very much.
Thank you.
Great. Thank you very much.
Well, I do appreciate your time. And again, the offer is our hope that we can continue to work with you. Thank you for your time and your work on this issue.
Thank you. Next.
Up next, I have Aiden Hiskias.
Good afternoon, Chairman Maroney and members of the committee. My name is Aiden Scass, and I'm here on behalf of Chamber of Progress. Chamber of Progress, a tech industry coalition promoting technology's progressive future, urges you to amend SB 2, which would hinder the adoption of innovative AI technologies without addressing the panoply of discriminatory harms. Our organization works to ensure that all Americans benefit from technological leaps. Our corporate partners include companies like Google, Meta, Snap, and Amazon. But our partners do not have a vote on or a veto over our positions. AI has tremendous potential for improving education, enabling creative expression, and creating new business opportunities. So it is critically important that public policy promotes the broad and equitable distribution of these innovations. Accordingly, policymakers should avoid policies that would counterproductively slow adoption of AI technologies. SB 2 defines artificial intelligence as technology that uses data to train an algorithm or predictive model for the purpose of enabling a computer system or service to autonomously perform any task, including visual perception, language processing, or speech recognition. A long definition, I know, which would encompass many everyday consumer software products while ignoring offline real-world sources of potential discriminatory conduct. The sponsors of SB 2 are justly concerned about civil rights abuses, particularly discrimination in housing, employment, or lending. Historically, marginalized communities have faced repeated discrimination in these areas and many more. And as such, we applaud the sponsors for their attention to these critical matters of social justice. However, pinpointing the source and catalyst of discriminatory outcomes of an AI system is not always possible, nor is it consistently determining who or what is responsible for the act of discrimination. The roots of bias may be in the data used to train a model, which could be laden with human-created biases, or the human who rubber stamps the outcome of an automated decision tool, or from any number of other sources. Regardless of origins, there must be avenues to address circumstances of discrimination that are consistent whether the abuse is online or offline. Unfairly biased outcomes are problematic for developers, deployers, and end users alike. Tech companies are increasingly investing in internal teams for proactive bias detection and mitigation in their products. Google, for example, has implemented their responsible AI practices. The initiatives encompasses detailed guidelines for evaluating training metrics and machine learning models, including a thorough examination of the training data itself. Google's practices also emphasize a human-centric approach to AI development. Prioritizing safe and inclusive user experiences remain a top commitment for the tech industry. In light of the substantial private sector work to advance responsible AI development, we appreciate the authors including a safe harbor provision. SB 2 is designed to address potential discrimination from artificial intelligence systems, including automated decision-making in employment, housing, and other areas. To reiterate, we agree that discrimination is wrong, but focusing exclusively on AI systems ignores offline discrimination. A better approach is to strengthen existing civil rights laws protection in the Connecticut Code to ensure that the most vulnerable members of society are protected online and offline. For these reasons, we encourage you to amend SB 2.
Are there any questions? So I guess I have a few questions. One, are you going to send specific language to request to amend it, or is that just a broad amend it?
So the amendment is reconsidering and clarifying certain definitions in section 1, including reasonable care, that standard, and the consequential decisions. Another concern for a potential amendment has been spoken to quite a bit today, which is the section 7 disclosure requirements. We are happy to discuss it more in detail and write it up for you guys and follow up. Both those are sort of the main areas of concern.
Okay. Yeah, if you could send specific language requests, that would be appreciated.
Absolutely.
Representative Acker.
Thank you, Mr. Chair, and thank you for your testimony. I guess I want to ask, similar to the last question I asked the last speaker, is there legislation that in the other states, obviously you run the gamut of states that you work in or that you represent. Is there legislation in those areas that you would have us look at in different states?
Yeah, so I'm here to see you guys from Washington, D.C. I would have to refer to research and my colleagues, but I'm happy to include that in the summary to bring up to you guys.
And maybe encourage people in DC to get on board here and do some work. So thank you, Mr. Chair. Thank you for your testimony.
Great, thank you. And the one thing I'll say, being in DC, all of the tech companies went down to DC saying, please regulate us. Now we're putting forward meaningful regulations. They're saying, don't regulate us. So I would appreciate, if they happy to work together with them. So thank you.
Absolutely. Thank you. Thank you for your time.
Okay, next.
Next up online, we have East Peckdill.
Good afternoon. Thank you, Chairman Courtney and esteemed members of the General Law Committee. My name is Edge Pumphrey and I'm the senior.
Excuse me, could you get closer to your microphone? We're having trouble hearing you in the room.
Oh, I apologize. Are you able to hear me better
This
right
is
now?
good. Yeah, now we can hear you.
Okay, thank you. Good afternoon, everyone. My name is Edge Pumphrey. I'm a senior at the University of Connecticut and an advocacy intern for Live Girl, which is a Connecticut-based nonprofit that provides young women and girls with leadership development, mentorship, career readiness, and advocacy. Today, I will be advocating on behalf of Live Girl to support Bill 2, an act concerning artificial intelligence. The bill in question today is an important step towards protecting young girls and women from the dangers AI can bring when it falls into the wrong hands and gets used for a purpose that is no longer fulfilling the initial goals of its design. With the constant advances made in technology, AI will continue to become an integral part of our society and more accessible. Bearing this in mind, it's important to understand and recognize the scale of harm it can bring to individuals' livelihoods, particularly in regards to generation of deepfakes and explicit non-consensual sexual content. To strengthen the protections in Section 9, which deals with the production of pornographic media produced without the consent of the subject, I urge you to broaden the scope of protections for women and girls in this section to also include images generated or modified by AI. Also, to deter the proliferation of non-consensual deepfake pornographic images, liability should extend not only to the initial sharer, but also to subsequent individuals who knowingly distribute or share such images without consent. Victims should be empowered to seek civil remedies against individuals who share these images and may include injunctive relief, monetary damages, and restitution, providing victims with legal recourse and holding perpetrators accountable for their actions. In talking with the Live Girl Leadership Council, the members of which are all high school students, it seems that most young women have either been victims of this matter or know someone it happened to. There's an abundance of cases where young women's and girls' bodily autonomy and agency is taken from them, violating them on a threefold level, emotionally, physically, and psychologically. Even after their images are taken down from one website, there is no guarantee they were not downloaded before, and increasing the chances of them getting circulated through other websites and domains, which further violates these women and amplifies the trauma they went through and threaten their reputation and future prospects in education and career fields. According to the MIT Sloan School of Management, 96% of deepfake videos and images are pornography, and nearly all of those involve women and girls. To call this alarming would be a gross understatement, and is all the more reason for Section 9 to address this issue within its framework. AI is a multifaceted tool that has vast implications for the future of our society. We must acknowledge both its benefits and its potential for creating unimaginable horror to ensure the safety of everyone who may become the victims of its misuse, especially young women and girls who are the most vulnerable to this harm. Thank you for your time, your service, and your considerations of my suggestions to enhance the AI bill.
Thank you very much for your testimony and for your advocacy. Are there any questions? Thank you again for hanging in there to testify for us. Okay, next we are going to go out of order. I believe Chief Gentile, I think you have to be somewhere at 5 o'clock. So
Thank you. I appreciate the consideration. Good afternoon, and thank you for having me. My name is Mark Gentile. I'm a deputy chief in the Rocky Hill Fire Department, and I'm here to testify in opposition to Senate Bill 3, specifically Section 4, the product that deals with the drones. I provided written testimony, and I urge you all to look at the written testimony because it does have specific visual aids that the drones do utilize. Banning foreign-made drones at this time would cripple the public safety industry in the state of Connecticut.
The Rocky Hill Drone Unit is comprised of members of both the police and fire departments, and we operate on the DJI platform. Our primary drone is the DJI Matrice 300, which has capabilities far beyond any program offered in the US at this time. Current US manufacturers, while they do produce similar capabilities, do not have the camera specifics or weather-related items that our drones currently use. Our drones are able to fly in rain and snow and produce thermal imaging capabilities much better than the US manufacturers. It's not basically just a cost perspective, but it's also knowing that you can protect your community even in weather that's working against you. We respond to over 5 to 7 calls for service each month. These tools provide our incident commanders situational awareness on every scene we fly, and situational awareness saves lives. As an incident commander in the fire service, I never want to meet the family of a firefighter, police officer, or resident and tell them that we did not have the tools to save their loved ones' lives. There are also security concerns, and we do realize that. The security concerns really don't impact public safety, however. The public safety portion of this program only utilizes pictures and visual aids that basically you can get on any mapping service or Google Earth. We're not taking pictures of military bases. We're not taking pictures of structures, military structures or infrastructure. We're basically taking pictures of motor vehicle accidents, buildings that are on fire, or the woods where somebody is lost. So using the drone for these capabilities is very important for us, but honestly would do China no good. Could China affect our internet security? Not exactly. Our drones work off of a Wi-Fi system based off of an iPad hotspot. The iPad is also built in China. So if you're going to ban the drone from using the internet, we're going to have to buy iPhones and iPads as well. DJI also employs added safety for our drones and our infrastructure. They have what's known as a geofence. And a geofence is put around all infrastructure in the state of Connecticut and across the country that is registered with the program. So for instance, all airports have got a geofence around them. The approach patterns have geofences, power plants have geofences. So these geofences can only be opened under application purposes. So you have to register specifically to open up this geofence. The US manufacturers of drones don't use geofences. As a matter of fact, they dissuade the use of a geofence because they think it's more of work for the drone provider to actually open. These geofences allow us to operate in a safe manner, keeping us away from manned aircraft, and only DJI produces this geofence for their drones. So in closing, yes, we would prefer to purchase American-made drones, but not at the cost of the capability of the DJI products. We don't want to spend 2 to 3 times the amount of money on a drone program that's less capable right now. Municipal budgets are already tight. We already have established drone programs. And while the bill does not specifically say we can't fly them this year, it does specifically say we can't fly them after next year. And I can't imagine losing our entire drone program just because you think China is going to be looking at our pictures of motor vehicle accidents and fires. I thank you very much for this opportunity, and I would welcome any questions that you might have.
Great. Thank you, Representative Acker.
Thank you for your testimony. What was the estimated cost that you've invested in your program?
So far in just the drone equipment, it's $70,000 in drones and probably an additional $50,000 in batteries, controllers, televisions to monitor, and accessories for the program.
Do you know if most of the drone programs in Connecticut have similar equipment to you and similar costs, I would imagine? I've worked with the town of Vernon. They're a pretty impressive drone that has the infrared sensing. So they do, I'm not sure where.
The town of Vernon uses 2 of the same drones that we utilize. They use the Matrice and they use a Nevada. A Nevada is a very small drone. It's about 7 inches square. And we use those drones for entries into barricaded subjects so that we can get reconnaissance before we send the police department in. It gives them the necessary information so that if a police officer breaches that door, they know it's already on the other side of that door, which is incredibly important for their point of view. We also use it for fire investigation. If we have a structure fire and the building is compromised and the fire marshals can't get in to investigate the cause of the building, that Avata can easily fly through a window, fly through a roof, get into where we need to be, take all the pictures needed, fly out, and we never put one person at risk.
Yeah. You also have one that's larger. I know that they use for a senior alert because if somebody was lost, it has infrared detecting. and that was an impressive piece
That's
of
the
equipment.
Matrice. The
Okay.
Matrice has got infrared technology. It's actually got a four portion camera system. So it's got a wide angle lens, a zoom lens at 200 power, infrared, laser range finding. So it's a multi-capable camera system. And it basically, we have that drone, and in Rock Hill, we also have a Mavic, which is a little bit smaller of a drone, but it also has infrared capability. And we use those on lost people searches constantly throughout the year. We can actually employ multiple drones in town just to search for lost people, people that walked away from their home with Alzheimer's, children lost in the woods. You know, there's several instances where we can use those drones on multiple occasions.
Thank you. I appreciate that. Do you know of any other legislation or concept like this that in other states that are doing something similar?
Absolutely. Florida implemented a very similar ban approximately 2 years ago. They grounded over 90% of the public safety fleet. Right after they banned the drones and the drones were grounded, I believe there was a hurricane that struck, and people complained that it took too long for the fire departments to actually go and find people that were in danger. And the exact cause was that as they could fly the drone to go search the neighborhoods and find out which neighborhood was more impacted. So they had to do a ground search. Anytime you put people on the ground, it's going to take much longer for you to accomplish that job. In the town of Hebron, we responded to a structure or a brush fire covering 16 acres of land. It was getting late at night. They had to clear the zone around the fire to make sure that it wasn't going to spread through the night and impact houses. If they put people in the woods to do that, it would have taken them hours to finish the job. We completed that job in less than 45 minutes.
Thank you. Thank you for your testimony, and thank you for your service to the community.
Senator Kissel. Thanks.
I appreciate the questions just made by Representative Acker. Yeah, I have a concern financially with this impact to the 169 communities in Connecticut, but also I really see the value of the deployment of the drones so far. Search and rescue, you've got lost children in woods, you've got fires, you've got criminals holding up in behind buildings, in buildings. The utilities, they utilize these for microbursts and where's the power out, and if it's like not accessible easily by transportation like a truck, you send out the drone to see where the damage is. So we've got this. Yeah, okay, maybe it just sounds to me that the free marketplace, these Chinese companies, one of which is affiliated with their Defense Department, just builds a better mousetrap, a better drone. And really the trick to this is America's got to get on board with better product. But I agree with you that, you know, let's say there's a direct link between the drones in Rocky Hill and Beijing. What the heck? I mean, you know, are they going to sneak attack on Rocky Hill? I really think that's not top of their list.
If they can
And
find a
what
better way
kind
to
of-
fight a structure fire, I welcome them to share the information.
Yeah, help us
because we'd be
out.
happy
You know,
to
bring your
take that
trucks.
information.
Right. So I guess what part of it is, I think my gut feeling is this is a little overbroad and a little ham-fisted. Has there been a discussion regarding this issue with any statewide groups, post police officer standards and training, the Police Chiefs Association of Connecticut? Has our state police, who I'm sure have drone? I mean, I just can't see knocking out a bunch of already acquired assets that we're using for public safety purposes, and we were not going to have anything lined up to fill that gap. Is this just your testimony on behalf of your town, or has
This
there
is
been
just my
discussion?
testimony. You will hear later on from this Connecticut Municipal UAV Task Force personnel. I believe the Connecticut Police Chiefs are also filing written testimony, as well as the Connecticut Fire Chiefs.
Okay, great. I appreciate that. And I have the utmost respect. I've loved working with Bob Duff, represent the Senate Majority Leader, Senator Duff, and Senator Looney, and I appreciate where they're going with this. But it just strikes me that this is overbroad, and if the drone is being used in a sensitive area, maybe we need to pull back on it. But certainly, I don't want to cripple our ability to fight fire, stop crime, and find lost children.
We
So-
were actually invited down to Electric Boat for one of their drills to fly over the drill just to evaluate the drill. And the first question we asked is, are we authorized to fly in your airspace? And they investigated. They immediately came back with a, nope, we screwed that up. So we're public safety. We understand where we can and can't fly. We're not going to fly over something that's going to basically jeopardize the United States.
And I think this is a worthwhile discussion. I think it's definitely timely. But myself and Representative Carpino, back when there was program review and investigations, we tried to get our arms around the emerging drone technology. And so we had a demonstration right outside our Capitol building. And guess what? The person that came in to demonstrate it for us had to get clearance from Brainerd Airport right here in the city because there was it would be a violation to get into their airspace. So complicated area. I think that we can work it out when we all pull our minds together. But thank you for testifying and raising these really important points. Thank you, Mr. Chair.
Great, thank you. Are there other questions? So, agreed, it's a complicated issue, right? Homeland Security did issue warnings in their statement. Other concerns are that an organization is susceptible to data theft if the drone is transmitting unencrypted data, or more broadly, that a drone could increase the risk of a network being breached, right? So it's not that there's zero risk, right? There is some risk, but we need to find a way to work
So what
going
we did was we
forward.
put the drone on its own separate network.
Yeah.
The drone doesn't connect to the Rocky Hill municipal network. It connects to a hotspot on an iPad that's in a car. We don't fly next to our buildings, so we can't hit the infrastructure of Rocky Hill. So therefore, since we're flying on a separate network, the only thing they can infiltrate is an iPad.
Great. And what is the lifespan of a drone? Like when do you have to replace it?
It all depends on maintenance and honestly depends on the manufacturer. As new drones come online, the drones either get dropped down a level and they are no longer supported, or they might actually give you support for that drone. For instance, the Matrice 300 we're flying there's a new version of it out actually this year, the Matrice 350, but we were able to update our drone to the 350 standard. So we're probably going to get another good 3 to 4 years out of that drone. If they drop the standard, and I know they came out with a M30T, if they drop the Matrice program from the 300 level, then we'd probably only get another year out of it. But I'd say on average, you're looking at 5 to 6 years, maybe 7.
Okay, thank you very much. Are there further questions?
Sorry, I know you got to go. Thank you for your time. Thank you for your service. Just one quick question. Of the folks in your department, how many of them have access to the videos, and talk to me about storage of those?
So it all depends on what type of videos we're dealing with. If it's a structure fire, we can put them up on a shared drive where any member has access to it because it's a training video. However, when it's an accident reconstruction, that falls into the evidentiary procedures of the police department, at which point nobody has access to those photos. They get locked in the police department. The police department has access to them for investigative purposes only, and they never go to the public.
Okay, and I think you roughly estimated what it would cost to buy an American-made drone similar to the standards of the one that you have now. Could you roughly give me a price?
It's interesting because I actually addressed the price points of the Parrot versus the Matrice earlier, and that was actually a pretty accurate description. The Parrot was only like $300 more expensive than the Matrice. That's without payloads. That's the drone itself. The drone can fly around, but without a payload, it's not going to do anything. The Matrice drone, complete with the 4-camera system that we operate with the thermal imaging, spotlights and everything else, you're looking at close to $35,000 for that drone.
For one?
For one.
I'm in the wrong business. I should be in the drone business.
Well, you should, because the United States equivalent of that is probably twice that amount of money. And it's less capable. The drones that they're offering us today are much smaller than the Matrice. They're more equivalent to our mid-sized drone. And they're still 2 to 3 times. So that drone is actually over the price of the Matrice, but only gives us the capability of our mid-sized drone. So it's not just about the price. This is about capability. We need the drones to save lives. And if you strip that from us, we're losing that tool in our toolbox.
Thank you, Chief.
Thank you very much.
Thank you very much. And I appreciate the time.
Okay, next, I believe, is it Jacqueline Cushing?
Hello, Senator Maroney and distinguished members of the General Law Committee. I submit this testimony on behalf of the Center for Children's Advocacy, the largest children's rights legal organization in New England. The center provides individual representation, education and training, and systemic advocacy in the areas including juvenile justice, child welfare, special education, immigration, and public health. I'm a student legal intern with the center, and I'm graduating from UConn Law this May. As you can see in my written testimony, the center supports SB2 subsection 9, which expands intimate images actionable under Connecticut General Statute 53A-189C to include synthetic images. On a personal level, I recently learned that someone I know is creating images that look like me using a generative AI program. While I'm hurt and deeply upset by what that person is doing, as a law student, I can somewhat square this with my understanding of free speech and privacy. But if this had happened to me when I was in middle or high school, I would be devastated. And yet this is what is happening. During my time as an intern with the center, I have heard so many heartbreaking stories about bullying and cyberbullying. From one mother about her daughter who had attempted suicide multiple times because she was bullied. And from a sister who's, from another girl whose sister was facing expulsion because she had brought a weapon to school to defend herself. These are just two examples, but there are many more. A common theme among all of them is that children who are being bullied do not know where to turn for help. One place to start would be by taking away the bully's tools. Making fake images and distributing them with the intent to harm someone is an unacceptable use of artificial intelligence. 5 years ago, you could generate deepfake pornography for $30 by combining a 15-second Instagram video with a free video posted on an adult website. Now it's even easier and less expensive to do so. Under the statute as it stands, an ex-boyfriend would be penalized if he sent a nude picture of his ex, obtained in confidence, to that person's mother or posted it on social media. But if that same ex-boyfriend created a deepfake pornographic image of his ex and similarly shared it, the victim would have no legal recourse. Is the harm not the same? Possibly worse? Often the best someone can do is report a violation of community guidelines to the platform, which only results in having the content removed and in some cases the user banned. In the post-pandemic world, we are seeing more children regularly online than ever before, and more sophistication with advancing technology and social media. This statute was initially created to respond to the negative consequences of the evolving technology of the time. Adding synthetic images to the statute would continue to do just that and provide the victim with real legal recourse that would disincentivize the bully from even creating the image to begin with. The center thanks the committee for considering this critically important issue for the people of Connecticut, and especially the children who are the victims of bullying, and urges the passage of SB2, Section 9. Thank you.
Great. Thank you very much for your testimony. Does anyone have questions? Okay, Senator Kissel.
I just want to thank you, and I know that you respect free speech rights, but if anybody's like, bullying you or bullying someone else, anyhow, I just thought it was very good testimony. I appreciate it.
Thank you.
Representative Acker.
Yeah, thank you for your testimony. Recently I met with Attorney General Tong, and we had a meeting with some high school students talking about the hazards of the social media and the addiction of the social media and the reels. Is your group doing anything in promoting and supporting students or encouraging students to, take different actions or different habits with their social media platforms?
I can follow up with you on some of those specifics.
What's that? Yeah,
I can follow up with you on the specifics.
that'd
of
be
those.
fantastic. And good luck with your graduation.
Thank you.
Thank you very much for your testimony. I do have some questions, so I will, and thank you for your advocacy. I think, mentioning the bullying, unfortunately, last year, 13 children across the country died by suicide because they were the victims of sextortion. And in a case in November in Michigan, the boy had sent a photo. He was tricked into sending a photo to men in Nigeria, and then they blackmailed him, and he ended up not knowing what to do and taking his own life. So my concern is what happens when you don't even need to send that picture, right? When someone can just, for free, as you mentioned, create these videos or pictures, right? Images and spread them and blackmail you. Now, one of the things I would ask, as a law student for your help in researching, once these are put up on platforms, and so in the law it's specific, the platform, it's not their fault if someone takes this and puts that on there, so they're not liable, but a way to compel them to take down the content. If you would have recommendations of how we could do that in law, that would be appreciated.
Oh, absolutely. Appreciate that question. Or that
Okay.
prompt.
Thank you very much. Okay, any questions online? Nope. Okay, thank you so much for your testimony. Okay, next, my friend Chris.
Thank you, Mr. Chairman. I'm going to set my timer here. Thank you very much, Mr. Chair, members of the committee. My name is Chris Gilrain, representing TechNet in the Northeast. We are an industry association made up of about 100 companies throughout the innovation ecosystem. Here to testify on as much as I can get in 3 minutes. Starting with SB2, I was honored and privileged to be a member of the Connecticut AI Working Group established by Public Act 2316. Sincere thanks to Leader Candelora for my appointment and to Chair Maroney for leading a very wide-ranging and very, very informative process. Our charge as the working group was to investigate ethical state use of AI, assess ongoing federal action on the subject, and to make recommendations regarding further state legislation. The final recommendations to the legislature of that working group included a strong emphasis on workforce development, because make no mistake, it doesn't matter where this technology is invented or developed. The states that are going to lead in applied AI will be the ones that have a diverse and prepared and educated workforce. This included the creation of a Citizens AI Academy, aligning higher ed curricula with industry needs and producing industry recognized certificates, incorporating AI into existing workforce programs, and making sure that we have trained teachers to provide this kind of instruction in our entire education ecosystem. We also recommended further exploration regarding the use of AI in state government, including through the creation of a permanent advisory board. If I'm not getting too far ahead of myself, I'd like to just preemptively put my hat out in the ring. And I'd love to continue my engagement in this front.
We'll see how your testimony goes from here.
And finally, we recommended expanding existing statutes to address the immediate and known risks of the use of AI to produce election misinformation and non-consensual intimate images. As such, TechNet is very strongly supportive of sections 8 through 17 of SB2, which encapsulates the recommendations that I outlined above. Sections 1 through 7 are novel provisions which the working group did not advance, which would establish state-level regulation of AI systems, setting standards for transparency, explainability, and bias, which, as we were told by several presenters during our working group, that these are the subjects of ongoing federal work streams mandated by the White House executive order, and they do have deadlines for concrete action later this year. To Rep. Ackert's point earlier, how often do we find ourselves here saying, you know, ideally this is something that the federal government would deal with, but alas, it's up to us. We have a rare opportunity here to watch a federal process unfold that does have clear and concrete guidelines and deadlines for action. And perhaps we come back next session and fill in any gaps that we see at the state level. If I have time to turn quickly to SB3, there's another issue that the federal government has graciously offered to take off our plates in the disclosure of mandatory fees. TechNet has some concerns about Section 3 of SB3 and SB 201 as written, particularly as it relates to things like dynamic pricing structures and other things on via internet platforms. But fortunately, this is the subject.
Mr. Gilrain, just a heads up, you're at the 3-minute marker.
Thank you very much. So additional comments regarding SB3 will be forthcoming in writing. I did submit my written testimony on SB2 and happy to take any questions.
Great. Thank you very much. Representative Acker.
Thank you, Mr. Chair, and thank you for your testimony. Yeah, when I look at it, AI, we were doing with this with the, throttling of the internet. And it's like, we're a little state and our borders aren't that far away, but the network is everywhere. It's, international. So when you start making laws in a little state that, okay, you can only do that here, that's how we're going to run it, but it should be taken on more of a global aspect, a global component. And I think you kind of mentioned that DC is doing some work on it.
Yeah, it's nice to be able to, you know, come in and say, we would love to see a federal standard and there actually be some rubber meeting the road on that front. And that is not to dissuade the committee from advancing the specific regulatory issues that we did address in the working group, specific to the non-consensual intimate images and election misinformation, which we do think that, you know, you have the statutory structure already existing in the state, and we do hope to see that advanced as part of this legislation.
Thank you, and thank you for volunteering and offer to volunteer again.
Thank you.
Thank you, Mr. Chair.
Great. So as part of the task force recommendations, we did recommend legislation around transparency and accountability. So what are your recommendations then of how we should approach? Because we do require disclosures in this legislation, accountability through impact assessments. So I guess what are the ways that your organization would recommend we achieve transparency and accountability?
You know, to be fully transparent, the recommendations said we should explore things like transparency. We are, so my testimony, my written testimony that was submitted today kind of largely reflects sections 8 through 17. I will be following up with more specific testimony on the other transparency and accountability issues in the future.
Okay, thank you. And I think a lot of people have said that, you know, there are already laws against discrimination. But if you don't know that an algorithm is making that decision about you, how would you know if there was algorithmic discrimination? And if you're not testing, right, what gets measured improves. If you're not looking for that and testing ahead of time,
Sure.
I mean, how are we going to mitigate this issue of, you know, algorithmic?
Yeah, and we do hope that, you know, that'll be addressed at the federal level, and we do hope to work with you, you know, with this legislation, and I'll have some more specific recommendations from the members on that in very short order.
Great. And with all due respect, we don't even know if the federal government is going to be open next week. So I'm
Fair
not,
enough. Fair
I
enough.
am not necessarily, and right.
Yeah.
And a lot of the work, yeah, I mean, you referenced the executive order. A lot of that is in developing definitions, right? Not necessarily in specific recommendations. It's in tech sprints. It's in what different agencies should be doing, right, around that. You know, many of your members are participating in the voluntary agreement, correct?
Yeah.
And so a lot of, I think, what we're discussing is part of that voluntary agreement. So that's something that I would, you know, like to point out there.
For sure. And I think to the extent that, you know, there's participation in that, those are kind of ongoing and evolving agreements, and they are kind of a joint effort between kind of industry and industry experts in the government and NGO space. And so I think that to the extent that we are talking about something that is kind of being enshrined in statute and static, as this is a evolving technology, I do think that it's not exactly, you know, apples to apples.
Right. So having to comply versus volunteering to comply is what you're saying is the.
Well, and I think the fluidity of one versus the other, right? You know, the kind of changing nature of kind of a voluntary commitment that is kind of co-led by industry and NGOs and government versus statute with penalties for noncompliance.
And we do recommend input from from you
And
and
you will get
from
plenty.
your members. As you know, specific red lines are always appreciated. So are there any other questions? Okay, thank you very much, Chris.
Thanks, Mr. Chair.
Next, Ed Hawthorne.
Good afternoon, everyone. Senator Mulroney, Chairman DiAgostino and other distinguished members of the General Law Committee. My name is Ed Hawthorne. I'm proud to represent 250,000 working people here in the state of Connecticut as the president of Connecticut AFL-CIO. I'm here on behalf of SB2, an act concerning artificial intelligence. First, as many have done already, I have to commend Senator Mulroney for taking the lead on this. I was fortunate enough to hear your talk in front of the AFT Legislative Conference, and it was informative, well thought out, and you're just a wealth of knowledge on this. And the state can be proud of your efforts as you are nationally recognized on AI. So the introduction of AI or artificial intelligence into the workplace it brings forward a number of serious concerns, including potential employee discrimination, surveillance, suppression of the right to organize, lower wages, job loss. Workers are concerned they may be monitored. But let me be clear up front that labor unions and the members we represent are not opposed to artificial intelligence at all. But if it has the potential to unleash prosperity that improves working conditions and lifts everyone up. And I think that's what we're all here to do. But if left unchecked in the hands of corporate profiteers, it will increase the economic inequality, curtail our rights, undermine our democracy, as we've been talking about here today. Our members want to have a voice in how this technology is designed, implemented, and improve the jobs and work products and do not undermine them. In fact, the national AFL-CIO down in DC has partnered with Microsoft to do exactly this and be at the forefront of that. With that being said, we respectfully suggest some changes that is present in my written testimony. In section 1, we strongly suggest that controlling factor be substituted with contributing factor in the definitions of automated decision tool with high risk artificial intelligence. It should be an assistive tool and not a determining factor. We also urge the committee to include the right to opt out of the use of AI in making high risk decisions, as we believe it's not reliable enough to make the determination in those applications. Section 7, we've covered about the private right of action, the rebuttable presumption. Also, in addition, the enforcement of the AG as the sole enforcement is also concerning without sufficient AI expertise for that enforcement. So we'd ask that the committee consider hiring additional assistant attorney generals who can lead that work and be experts in the AI as well. And in section 8, in an effort to provide a broad variety of voices to the council, please add a worker's voice to that council. I know I'm actually supposed to be, it's still going on now. I'm looking at the clock. I'm supposed to be at the Governor's Workforce Council right now, but nevertheless, I'm here in front of you all providing testimony. I guess I pulled the wrong number today, but we can identify and anticipate issues as workers and should not be excluded from the council. Please consider adding a bargaining representative as voting members of that committee so that AI is going to revolutionize the workforce and is going to make the workforce better. And I think having a worker's voice on that council is very important to make sure that we have a say as workers on how we interact with AI. Also, section 12, to make it a mandatory point of collective bargaining so that we may share our experience with AI-generated agency efficiencies in the public sector. And also section 13, we urge the committee to establish a statewide labor management committee with equal input of labor and
Mr. management. Hawthorne, just a heads up, get the 3-minute marker.
Almost there. To equal input in the development of the state employee AI trainings and how to improve the effectiveness of those issues over time. Thank you all for your time here today, your patience throughout this process, as always, and I'd be happy to answer any questions the committee may have.
Thank you, Representative Ackert.
Thank you. Ed, it's always good to see you and testify. I thought you pulled the right number. If you're here with us, it's got to be.
Absolutely.
Yeah. So
This is my meeting though.
yeah, I'm going to be short. So you kind of came out pretty strong in terms of something that you fear about with the AI and discrimination and other comments. Have you seen that or heard of that, or you just it's more of a concern factor that you're worried about?
I mean, there's always stuff in the news. Nothing specific comes to mind, but we can definitely circle back on that and get you some specifics.
No, I was just more of a thought. I was more thinking, is this what you projecting from it, or that's all. I was kind of.
It does have the potential, and we heard the examples earlier. AI is obviously not human-based, but input by humans, so it has the potential to discriminate folks, and not intentionally from the input, but as it teaches itself, it has that potential, and that's one of our concerns, especially with the high risk as addressed in the bill.
And how you put the algorithms in, correct? Yeah.
Yep.
So thank you for being here again, and thank you, Mr. Chair.
Thank you. Are there other? Questions? Okay, so good news. In Connecticut, you do have the right to opt out of processing for solely automated decisions. So that was part of our Senate Bill 6 in 2022, our data privacy bill. Again, I think to your point on the definition, that means that it would only, if it was completely automated, which there aren't a lot of decisions that are necessarily completely automated. So there is probably work to do on that. And then again, well taken that your point that we need to lift everyone up, right? And as we look at this with AI, you know, over the next 10 years, right, they're saying it could cost 85 million jobs, create 97 million new jobs, but there's a saying that AI is not going to take your job. Someone who knows AI is going to take your job, but that ignores the fact that there are careers that will disappear, and that we do need to be cognizant about providing opportunities to uplift those people and make sure that people who are working in the jobs, which a lot of them would, Indeed did a report for their hiring lab of the top 25 careers that are listed on Indeed and the percentage of them that can be replaced by generative AI. Two of the tops were customer service representative, administrative assistant, which a lot of times are jobs that have been done by women, specifically women of color. So we need to make sure we're providing the opportunities and training for everyone to succeed in this new economy. So thank you.
Absolutely. We'd love to partner with you and work with you on that. And we're so thankful that, as you said earlier, you went down that rabbit hole and became a national expert on this. And we have someone right here in Connecticut able to do that.
I wouldn't go that far, and flattering gets you no extra time. So Sam will still call you at 3 minutes. So thank you very much. Next, is Kevin available online? Okay, Kevin. Cox.
Thank you. Thank you so much for allowing me to testify today. I wanted to join the conversation in support of the proposed bill number 2. As a physician, I trained at Yale, and similar to all medical training programs, including UConn and Hartford Healthcare, the concept of the Hippocratic Oath was drilled into every trainee's head, including mine. So the concept of first do no harm is an oath that underpins our healthcare system. And when I read the first part of this legislation, I was so happy to see that it directly aligns to that oath. In addition, it extends the first do no harm oath to AI more concretely. So it's not ambiguous that it also applies to AI as well, and makes it clear to someone that's developing AI that someone is watching to make sure it's implemented correctly. My Connecticut-based provider organization currently serves about 20 states nationally. That's part of the reason I'm not there in person today. I also have a software development and implementation company that incorporates AI into many of our projects supporting large federal agencies. When we implement those projects at other clients and in our own clinics, we already do many of the tasks promoted in the bill. For example, we review our approach to ensure that we don't inadvertently discriminate against certain populations. Unfortunately, there's a reason that we do that today. The reason is that I've personally seen the adverse outcomes that can happen when others don't put those reviews in place. For example, I've seen healthcare companies utilize AI to streamline the claims processing process without validation of algorithms being used under the hood of the software. It is often done in the concept of innovation. But if you're the patient that's on the bad end of that innovation life cycle, it can cause harm when it's not done responsibly. There was a time when we could have accurately said that we did not know AI could do harm inadvertently, but now we do. And because we do, we need to take action in supporting this bill. Thank you so much for your time. I'm happy to answer any questions.
Right. Thank you very much. Does anyone have any questions? And now, which of your businesses are located in Connecticut?
So we have Trusted Medical, which is a provider organization, and then Compass Innovations is a software company that's in the process of relocating to Connecticut as well.
Great, thank you. And do you have recommendations for what we can do as a state to incentivize more health tech businesses?
Yeah, I think one of the things as a local business that would be extremely helpful to me and others that are promoting job growth within the state of Connecticut is continuing to focus on the small businesses that are innovating and growing in this particular area. And so anything that the state can do to help promote that, either contracts the state's already spending money on to drive that so that we can continue to be the leader and grow the local economy, that would be extremely helpful.
Great. Thank you very much. No further questions? Anyone online? Okay, great. Thank you very much, Kevin. Okay, next, Andrew Zhu.
Hi. Okay. Good afternoon, Chair Maroney, Chair D'Agostino, and esteemed members of the Committee on General Law. My name is Andrew Zhu, and I'm a first year at Yale University and also a member of the Yale College Democrats. And I've also lived and attended public school in Cheshire, Connecticut for my entire life. Today, I'm testifying of SB 3, Digital Equity for the Residents of Connecticut. Since, as you all probably know, since the pandemic began in 2020, Connecticut has risen to become one of the fastest growing technology hubs in the country, technology-related jobs rising 5.3% in 2022 and just overall completely outpacing national growth. The digital world is an increasingly significant part of everyone's lives and Connecticut's economy as a whole. However, as Connecticut advances in the world of technology, I think we must also make sure not to leave anyone behind. The digital divide in Connecticut is just as significant. As of 2021, there were almost 400,000 residents that lacked reliable, affordable, high-speed broadband internet access, with seniors and people of color disproportionately affected, as well as rural. And my own home internet in Cheshire has seen drastic changes in the past 1 or 2 years, just in terms of affordability and speed, with previously Cox held a area and our Wi-Fi was both slow and expensive. But as new providers such as Frontier and GoNet Speed have trickled into the area, our Wi-Fi is now extremely fast, extremely reliable, and actually cheaper than it used to be. And I believe that SB 3 will be able to help this process spread to all families in Connecticut by declaring broadband access a fundamental right and ensuring its affordability. This lack of broadband access and the fact that specific groups of people are much more disadvantaged than others in terms of access marks more significant issues in terms of life quality and accessibility. Digital skills are now a necessity in navigating things such as health and the workforce. And me personally, growing up in and attending Cheshire Public Schools, I have had much firsthand experience with the integration of technology into the education system. Specifically, I remember when Chromebooks were first introduced in 4th grade. That was way back in 2015 or 2014. And my reliance on technology in school has increased to the point where by the time I graduated high school this past May, I could go to school every single day without bringing anything but my laptop. And so technology has become such an integral part of education in the public school system that lacking an affordable and reliable internet access at home can have a significant detract from one's ability to receive a good education. I believe that Senate Bill 3 is a significant step towards every Connecticut resident can thrive in the digital age. And now, more than ever, we need to ensure digital equity for all people before the digital divide hinders disadvantaged communities. For the future of Connecticut's economy, education, and prosperity, I believe we need to pass Senate Bill 3.
Mr.
Thank
Shu
you.
just had
Thank you, representatives, for hearing my testimony, and I'll be happy to answer any questions.
Great. Thank you so much. Right on time at the 3 minutes. Are there any questions? Okay, hearing none. Thank you very much for your testimony.
Thank you.
Next. Vanessa Michelle?
Hi, can you hear me all right?
Yes, we can hear you. Please
Okay.
proceed.
All right. Hi, Senator Maroney, Representative D'Agostino, Senator Fonfara, Representative Brown, and the members of the General Law Committee. My name is Vanessa Michelle, and I'm a member of the Center for Youth Leadership at Brian McMahon High School in Norwalk. I'm speaking on behalf of the 137 members of the Center and the Mayor Youth Leadership Council, which is our partner in Stamford. We support Senate Bill 2, especially Section 9, which updates state law to prohibit the dissemination of synthetic images that are partially or fully generated by a computer system. Thankfully, none of our current members have been the subject of a deepfake. However, several graduates of our programs have had dating partners distribute their intimate images without their consent when relationships ended. They told us the harm they experienced impact their physical, emotional, and academic lives and pushed them to the outskirts of hope for months. We were reminded of their experiences when we read about the high school girls in New Jersey who were victims of deepfakes last year. Although we've read several stories about online sexual exploitation of people our age, one worse than the other, we were stopped in our tracks when we read about the death by suicide of 13 children in 2023 due to sextortion. That's why we are grateful for Connecticut's response as drafted by this committee, with input from the General Assembly's AI Working Group. You will hear later today from my friend from the Mayor's Youth Leadership Council in Stamford. She will thank this committee for acknowledging that the Connecticut Department of Education has a role to play in teaching students about the responsible and ethical use of AI. I want to thank this committee and the working group for the time they devoted to researching laws in Illinois, Virginia, California, and elsewhere that address digital forgery and deepfakes. Your attention to this issue, which is very important to our 137 members, gives people our age a path to respond to the non-consensual distribution of computer-generated intimate images, a path that is much stronger than reporting a violation of social media's community standards. Thank you.
Thank you so much for your time and your testimony and your advocacy. Are there any questions? Hearing none, thank you again.
All right, thank you.
Okay, next we have, did they want to come in together, the Enfield student, Senator Kissel, or? Sam, do you want to just let them all in to the room together? And we'll give them more than.
Yeah, was it
3 minutes.
was it Izzy and Jakai?
Izzy, yeah, and then is Alicia and Nicolina also, looks like they're all from the Enfield Youth Council.
Jakai, you should be able to speak. Is everyone with you?
Hi, can you hear us?
Yes, we can hear you. Please proceed. Thank you.
Good afternoon to the co-chairs of the General Law Committee, Senator Maroney and Representative D'Agostino. Thank you for giving us the opportunity to speak today. My name is Alicia Lazat. And I'm JC Martinez Estrada. We are both Enfield Youth Council members. Youth Council is a youth-led adult guidance substance misuse prevention group for high school students. We are here today in support of the proposed raised bill number 199. In Enfield, we see a growing issue with underage nicotine use and how underage teens are accessing these substances. I can recall back to 7th grade, every day I saw smoke rising from the bathroom stalls, and I wondered how teens so young were able to access nicotine. Today, as a junior in high school, it is the same teens I see every day vaping in the bathroom. By now, these teens are developing potential lifelong addictions, but it all roots back to where they got these substances in the first place, and who let teens so young access a substance so dangerous and life-altering.
Whether acquiring nicotine vapes starts with the retailer/dealers. For example, I participated in a shoulder tap compliance check conducted in partnership with the Enfield Police Department on a nicotine dealer. One young woman I approached after informing her of the purpose of the shoulder tap had confessed to me that she was underage. and that this nicotine retailer slash dealer did not check IDs. When she had come out of the establishment, she said they had this time asked her for her ID. The only plausible reason I could come up with in my head was since the dealer knew what we were doing that day, they wanted to be on their best behavior. Who knows how many more nicotine dealers in this state are selling to underage minors without notice? This is a serious problem and people need to start noticing it. In my town last year, there was a need for an educational presentation to 5th graders regarding nicotine vaping because they were accessing nicotine vapes. This bill needs to be passed for the sake of the adolescents and kids in this upcoming generation. I don't want to live in a world where I continuously see more people my age and younger develop these lifelong addictions that could possibly lead to their death. These dealers need to understand the legal repercussions and especially the physical and emotional effects of nicotine vapes on minors. This isn't a simple business transaction to gain these dealers more money. We're talking about the lives of adolescents put in danger due to retail access of nicotine vapes. In 2019, the age to purchase nicotine vapes was raised to 21. Connecticut legislatures recognize how serious of a problem these products are. The passing of this bill will help strengthen the legislation on nicotine vapes by educating these dealers on the repercussions of selling nicotine vapes to underage minors, and in turn, allow less adolescents, even as young as 11 years old, acquire them and develop lifelong addictions. Adults say our generation is the future, so help us save it. Thank you, council members, for hearing our testimony.
Thank you. Senator Kissel.
I want to thank both of you and the Enfield Youth Council. I think there's 2 other speakers as well. But I just wanted to say you're in good company because your number was about there with the head of the AFL-CIO here in Connecticut. So that's not so bad company. But the fact that you care so much about the young people coming behind you and you're just sophomores and juniors and you know, in high school, that's extraordinarily commendable. The fact that you went on a sting, Chief Fox and everyone else in the Enfield Police Department deserve great credit for using you guys, and you guys volunteered to do that to see if these stores would sell to underage minors, and they did ID them the one time, but you figured they were onto your sting, so that was they must have got tipped off. But you know, when Representative Hall and I just met with you about a month ago, I was incredibly impressed with your public spiritedness. And I really appreciate you being with us all afternoon to testify this afternoon right now. And I'm looking forward to your 2 colleagues testifying as well. And I also want to thank the leadership of this committee for raising this bill. And it might actually have a little bit of legs because, you know, folks that are found in violation of selling to minors are absolutely flaunting and not obeying the public policy that this legislature struggles with. We do not pass bills lightly. It's very hard to get a bill across the finish line. And if we think tobacco and vaping and nicotine is that addictive and that detrimental, we mean business. And what you're testifying to, that you've seen these kids in the bathroom doing this year after year, they're hooked. And so I'm glad you're doing what you're doing. And I thank you, Chairman Maroney.
Thank you.
Thank you very much. Thank you for bringing this concept to Senator Kissel, and thank you, Senator Kissel, for bringing the concept to us, and we look forward to working with you. So thank you, as Senator Kissel alluded to, thank you for hanging in there. It's been a long day. We're, as Bon Jovi would say, we're halfway there. You're probably going to have to Google that, but thank you so much for your testimony. Yes, and Sam, Mr. Clerk, if we would let in Alicia
They
Nicolino.
should be on.
Alicia Nicolino, can you hear us? And hopefully I'm pronouncing
Good
it.
afternoon. Can you hear me all right?
Yes, we can hear you and see you. Please proceed.
Okay, good. Hello, co-chairs of the General Law Committee, Senator Maroney and Representative D'Agostino. Thank you again for having us today. My name is Izzy.
And my name is Nikki. We are here representing the Enfield Youth Council, a youth leadership group focused on preventing substance misuse. We are here today in support of the proposed raised bill number 199. According to the Enfield Youth Voices Count survey results in 2023, the average age of first-time nicotine use was 13 years old. For most kids, this is in middle school.
Addiction to nicotine is starting before high school, and most kids will continue throughout their adult lives. The legal age for nicotine use is 21 years old. Kids are obtaining nicotine/vapes 8 years before the legal age. If it is illegal to vape underage, then how are they getting these vapes?
The same survey found that 44.3% of Enfield students say they had easy access to vape products. This all leads back to vape and nicotine product retail/dealers who don't follow laws around selling to underage customers just for business purposes. These retailers/dealers clearly don't understand the mental and physical damage that nicotine and vape products cause for minors. This is why we need an act requiring an online prevention education for electronic nicotine delivery systems.
This online prevention education system will create a learning opportunity for these vendors and will spread awareness throughout Connecticut about the dangerous power that these vendors hold over our future generation. Education is a powerful compromise to an ongoing issue that Connecticut has dealt with for years.
This act will greatly reduce the number of teens able to easily access these deeply damaging products. Vape and nicotine products are extremely addictive substances. The vaping industry targets teens, and with the help of vape product suppliers, this industry gains a lifetime consumer. No wonder the vaping industry is worth billions of dollars. Thank you again for having us.
Thank you again, Senator Kissel.
Thank you very much, Chairman Maroney and Izzy and Nikki. Thank you so much for being patient all afternoon. Your testimony was compelling. I want to also thank, we have one of the Senate Republican counselors here, Melanie Dykes, who helped me craft this legislation along with the leadership of this committee. And you did a great job, because if there's that much of a difference, 13 to 21, the law is being flouted and it's not being obeyed. And you're saying there's huge consequences to these businesses just selling these products to young people. And I think requiring, if found to be violating the law, required to take an online course as to the ramifications of their bad behavior is not that much to ask. And so I really appreciate both of your testimony and your initiative, and the entire Youth Council and Town of Enfield should be very proud of all of you. Thank you, Mr. Chair.
Thank you. Representative Ackert.
Thank you both for testifying. Question for you. If a student is caught using an illegal product to their age in school, what is the ramifications?
Some ramifications at our school would probably be suspension or detention. It depends on what they have on them, depending on if it's a vape product or if it's another substance, but usually suspension or detention. Honestly, though, it doesn't usually involve the police, not that I'm aware.
Yeah, I was just more thinking, thank you for that answer. I was thinking more along the lines of what take place in the action of school. So if I imagine if that take place, the parents are notified. And I would hope that there's some ramification that the parents reach out to whoever's selling these illegally to them. So thank you very much for your answers. And again, thank you very much for staying with us and testifying.
Great. Thank you very much. Okay, Mr. Clerk, next, I believe, is it Angelo Ziotis?
Good afternoon. Thank you, Chairman and members of the committee. I'm Angelo Ziotis, and I'm also here on behalf of the Connecticut Trial Lawyers Association. I'm going to not repeat any of the testimony that our organization's current president, Marisa Belair, gave earlier today. I wanted to start by acknowledging what a hard act that is to follow. Senator Kissel's constituents did a wonderful job. But I was the president of CTLA over 10 years ago and have been testifying before committees at the General Assembly for over 20 years, at a time when Senator Kissel and I were much younger men. And I'm testifying today just to express our concern about Senate Bill number 2. It's a bill that, in our read, eliminates private causes of actions inappropriately and sets a new framework for Connecticut law where you're defining appropriate care and reasonable care in this very complicated area and eliminating private causes of action. I don't want to in any way minimize the admiration I have for the chair and the other members of this committee in tackling an incredibly important issue and doing so with a great deal of expertise. My firm is litigating data privacy issues and technology issues in Illinois and California, and I'm aware of all of the complexities involved in this issue. But it is really important that this committee and this body stay consistent with the bipartisan way that Connecticut has always balanced sound public policy with allowing consumers to protect themselves in the courtroom. And that's what this bill doesn't achieve the right balance for at this time. And so I'm certainly open to continuing to work and communicate with anybody on the committee, and the CTLA will continue to work with you. I thought I would take the last couple of minutes of my time to just answer a couple of questions that Representative Acker asked about other claims as well as other states. We really do understand Connecticut to be in the forefront of this issue, and we found no states that are eliminating private causes of action in a way that would give the AG the right to enforce these rules. And there is an example of an age discrimination case pending right now involving AI, where a company used AI to eliminate, in an age discrimination case, men over the age of 60 and women over the age of 55 using AI to screen out applicants. And that case is currently pending, so I am aware of that case. But with that, I'm obviously happy to answer any questions that the committee might have.
Senator Kissel.
Thank you very much, Chairman Maroney. I'm glad you stuck around with us, Counselor. Attorney Ziotis is a great guy. Worked with him, as he indicated, back when he was president of the Trial Lawyers Association. Now working with Attorney Belair. And again, I think they're champions for our civil rights, for protecting them in our court system. It's right in our Connecticut State Constitution that the court shall remain open for the redress of grievances, and our civil litigation bar, as well as the criminal defense lawyers and state's attorneys in Connecticut. I'm just very proud of everybody who's an attorney here in the state. And I have concerns with this legislation as far as it impacts the right of individuals to seek redress either under long established common law principles or other statutory grounds, or as a private attorney general under things such as CUTPA. But Attorney Ziotis, I just want to thank you for your advocacy and doing the research to address Representative Ackert's concerns. If it's age discrimination over 60, I'm in deep trouble. So I want to make sure that there's viable rights of action out there. But I took heart from the comments made by Senator Looney, and Senator Maroney has been nothing but open-minded regarding all aspects of his legislation up to the final moments that it passes the House and Senate. And I think this bill will be no different. So thank you so much for your testimony. Thank you, Mr. Chairman.
Thank you, Senator.
Are there other questions? So again, we want to make sure we're not removing any existing rights. And thank you. You did point out some issues. What I would point out, though, is as far as comprehensive consumer data privacy laws go, of the 13 states that have them, I don't believe any offers a private right of action. And ironically enough, the one state that 12 of us are based off of, Washington State, Senator Carlisle, who really started the framework that we all ended up using, it never passes in there because of the private right of action. There's one house that wants it and one house that doesn't, and they can't find a compromise. So, and so we'll need to find a compromise. But
Senator, if I may?
again, thank you for.
May I respond to that, Senator? I apologize. And I've been at this rodeo many times where one house in Hartford does one thing and the other does the other. But I do understand there is a private right of action in Illinois. I mean, my firm is litigating that right now.
That's their biometric data privacy bill, which is
correct.
So they don't have a comprehensive. So the comprehensive data, and so you're right, that one last year in the algorithmic discrimination bill, AB 310 in California, there was a limited private right of action. That bill did not pass. This year it's AB 2930, and they've removed the private right of action. So again, it is something we cannot take away existing rights, but we have to be mindful, of going forward that does create more obstacles in some ways, but understood, the argument that there are no rights without recourse. I fully understand that argument. So I do think that we need other ways of enforcement in addition to the Attorney General, possibly adding CHRO. And I believe in the testimony for DCP, they normally also have some CUPPA authority, so they would also like to be part of the enforcement. So I'm sorry, Senator Kissel, you can't read my mind. So in my mind, I said, please proceed.
Thank you, Mr. Chair, for the second time. And I'm sorry, but clearly you know your stuff like the back of your hand. So including all the states that do or don't, or what variations of private rights of action. To Attorney Ziotis, though, if we find ourselves in some sort of compromise situation where the Attorney General is the only one authorized to bring suit, the language that would sort of inadvertently knock out current common law and other statutes that individuals could bring a case on, would you still say that we should not have the language that changes the burden of proof? That's sort of like an isolated issue, whether there's private right of action or not. Do you still feel, as Attorney Belair testified, that burden of proof switch, especially in responses to questions from, I believe, Vice Chairman Brown, that it's such a fast moving technology that what we put in statute is probably going to change so much that giving them the benefit of the burden of proof, if they follow what we put in statute, really would ultimately work an injustice down the road? What's your opinion on that?
Yes, Senator, thank you. And it would. It's as much respect as I have for this committee and its ability to understand this issue at a very, very deep level, and it's obvious. Predicting all the ways that this would evolve and therefore be presented in a courtroom 5 years from now is impossible. What I think a statute should do, and always has done in Connecticut, is create some sense of what reasonable care means. And then once you've done that, then it's up to our legal system, our courtrooms, our ability to have judges and juries decide whether corporations have done things in accordance with those statutes. It's really, really hard, if not impossible, to write a bill that covers every scenario. And so, yeah, the burden shifting would not be sufficient, and it really would be a mistake to try to define everything in a statute that way, and to give all the authority to these incredible state agencies that are overworked and don't have the people to enforce what they're working on now. I just don't see how it would be workable.
Thank you very much. Thank you, Mr. Chair.
Great. Thank you. Are there further questions? Are we okay online? Okay, great. Thank you very much for your testimony.
Thank you.
Okay, next, Tatiana Rice from the Future of Privacy Forum.
Good afternoon, everybody. Members of the committee, thank you for the opportunity to provide testimony on Connecticut Senate Bill 2 on behalf of the Future Privacy Forum. I want to specifically thank Senator Maroney for his ongoing work and commitment to crafting policy that addresses both data privacy and algorithmic discrimination. My name is Tatiana Rice. I'm a senior counsel at the Future Privacy Forum. In my work, I lead our legislative engagement and analysis on U.S. policy on AI. I'm here today to provide general comments on SB 2 with a focus on sections 1 through 7 regarding high-risk AI systems, emphasizing the importance of this bill and offering some considerations to enhance the goals of this groundbreaking legislation. Connecticut has played an influential role in shaping privacy rights and protections across the U.S., and SB 2 is poised to be a leading framework for private sector artificial intelligence regulation in the U.S. and is likely to influence other policymakers as well. As complex and important legislative proposal, SB 2 must receive the attention commensurate with its role in shaping the future of our digital society. So today I have two considerations for this committee to further enhance the goals of this legislation, which is described in greater detail in our written testimony. First, as a lot of folks have already said, is to clearly define the scope of artificial intelligence subject to regulation. FBF welcomes the risk-based approach to AI regulation here, focusing on high-risk AI systems. However, there are areas to strengthen the bill's consistency and effectiveness. A few examples are: one, SB2 defines both automated decision tools and high-risk AI systems to describe similar AI technologies used for consequential decision-making. But the definition of algorithmic discrimination is specifically limited only to automated decision tools, which is a little bit more limited than the high-risk AI system definition. Second is another example is how the bill approaches generative and other AI systems. Though the majority of SB2 focuses on high-risk AI systems, the provisions regarding generative and general purpose AI do not follow a risk-based approach. Like many tools, AI systems may be able to be used in different ways and carry different risks based on those uses and other factors. Accordingly, many generative AI tools may only support low-risk activities, such as autocomplete features in a word processing program, which may not warrant the same level of regulatory requirements as high-risk use cases like systems capable of creating non-consensual intimate images. My second consideration is to suggest that this committee engage with civil rights attorneys to understand how SB2 engages with existing civil rights law, which has already been thoroughly discussed tonight. I am happy to discuss more about how other states are approaching this issue, because there are a couple different approaches. But as what has been noted, AI does not exist in the Wild West right now. Areas protected by existing civil rights laws, such as employment, housing, and credit, apply regardless of whether a task is performed by human or AI. The largest issue that a lot of folks are trying to grapple with legislation like SB2 is, what does it mean to measure algorithmic discrimination? What kind of rules and guardrails need to be in place? So SB2 aims to address those questions for both individuals and businesses alike. However, its overlap with civil rights law could unintentionally conflict with existing discrimination rights, resulting in any kind of legal disputes and uncertainties. So Senate Bill 2 definitely should have a level of collaboration with civil rights experts, as this committee has already heard time and time again today, and Senator Maroney has done a ton of work already in this area regarding collaboration across different industry experts, technology experts, privacy experts, and I'm happy to answer any kind of questions that this committee might have.
Tatiana, thank you so much for coming up from DC to testify, and for your help and the Future Privacy Forum's help in convening the multi-state working group. You guys have been a tremendous help to us as we're working on this legislation, and I know you're helpful to many legislators around the country in their privacy legislation. So, okay, all right. So now I'm gonna now I'm gonna ask questions. So here we go. Yeah, excellent point. And we've reached out to the CHRO, to the Human Rights Organization for enforcement of the algorithmic discrimination, and making sure we tighten the definition of high-risk AI. Again, a good point. They focus on 4 areas there. I mean, would you suggest, since we're going to have them as part of the enforcement mechanism, further tightening the definition of high-risk AI to those 4 specific areas that they allow for filing the complaints?
Yeah, I'll say I am not a civil rights attorney, so take everything I say with a grain of salt. Just generally understanding the structure of how these claims are brought. Certainly that's a good starting point, but also acknowledging the many other areas already covered by civil rights laws. Potentially looking at all those other areas, how those enforcement mechanisms already exist, and potentially amending those laws or including some kind of provisions that link back to those laws in SB2.
Now, so again, on the high-risk AI, is it your opinion that generative AI or the general purpose AI is included within high risk, or should we add? Does that need to be specifically added in to the definition if someone is using a generative AI system to make one of those consequential decisions?
Yeah, I think the definition of generative AI is inherently within the definition of high-risk AI system. If you look at the general definition of artificial intelligence system in the bill, I would say that that generative AI systems generally fall within that definition, and therefore they inherently are part of the high-risk AI definition as well. I think there is a lot of questions around kind of, like I said, differentiating the different kind of use cases that carry different types of risks, and making sure those obligations are tailored specifically to the kind of risk profile associated with those generative AI systems.
Now, you mentioned like the autocomplete and other things. It actually, in the EU AI Act, they do specifically exempt that. So are there ways, I think it makes sense to specifically exempt that to make that extra clear, but are there ways that we can tighten definition so that other low-risk uses like that do not inadvertently fall under the, potentially be interpreted as falling under the scope of the bill, even though they're not intended?
Yeah, absolutely. Looking at the EU AI Act is a good place to start, absolutely, in terms of looking at the language there of the exclusions. Another place you can look is Virginia's House Bill 747. They also have some exclusionary language for low risk processing. I don't have it specifically in front of me, but I do remember that they do have that.
And is that Delegate Maldonado's bill or is that another?
Yep,
Okay.
yeah.
So are you familiar with the Utah bill that it was discussed before?
If we're talking about SB 149, I'm familiar with that one. That one is very specific, I'll note. It's not as broad as SB 2 is, but it does have
Okay.
to do with generative AI systems.
Okay, great. What other, are there other models that we should be looking at, other state legislation that we haven't looked at yet?
I'll to the questions about how other states are approaching the algorithmic discrimination issue. One model that actually hasn't been discussed today is just amending existing civil rights statutes to explicitly include algorithmic discrimination. I believe Georgia has introduced a bill on that. I think maybe one other jurisdiction. I'm happy to get back to you on those. As well as Washington State had a bill. I think it's still in action, but I don't think it's made movement. That links back at a violation of this bill that looks a little bit similar to yours, Senator Maroney, links back to the civil rights statute, basically. So a violation of this bill is a violation of the civil rights statutes, and therefore you follow all the existing procedures under the civil rights statute. And then, as you already noted, California, again, has a kind of similar approach as you do. Last year, they had the algorithmic discrimination have a private right of action. As you noted, that was also taken out this year or this legislative session. But that was only limited to the algorithmic discrimination section, not the entirety of the bill.
And so just a comment. I initially had looked at just adding algorithmic discrimination into our existing civil rights law. I guess the issue was the approach I was looking at. We were going to pick the areas of significant concern and look at the laws there. The concern that was brought to me, or significant, what do we call that? Decisions that have significant legal consequences is in our data privacy law, but those consequential decisions. We were just going to look at the areas within consequential decisions. The concern that was brought to me was that if we just only did it specifically in the 4 or 5 statutes, then in other areas where we didn't put it, they may feel that then algorithmic discrimination did not count because we mentioned it some places, but not in all places. So that, but I do, as a way for enforcement or linking back, it is something I'm definitely will look at and consider. The California bill, right? And so I think one of the things they do is they have an exemption for businesses with less than 25 employees or algorithms that don't impact more than 999 people. What are your thoughts about including something like that in terms of protecting? And so I'll just say I go back and forth because the Washington version of the bill, which is very similar, did not have those thresholds. It seems like a low threshold, but in some ways discrimination is discrimination. But again, we don't want to, how do we not harm small businesses? But that balance there.
Yeah, absolutely. And I do certainly see the potential where there are a lot of startups that need to be able to operate and innovate, and you don't want to unduly hinder that ability because they just do not have the same level of resources as a lot of these larger companies. And at the same time, they do have the capability, especially if they're dealing in high risk systems, such as, let's say they're creating a facial recognition system that is being used by law enforcement. That has huge implications, and there would be, in my head, no reason that they shouldn't also be regulated. So I think, especially when you are thinking about what types of entities are creating high-risk use cases, it would have to have some kind of exemption to the exemption if you are dealing specifically in those areas.
And you mentioned the exemption to the exemption. That's another interesting thing, the UAI Act, that they exempt open source general purpose AI unless it's used as high risk AI.
Yes, exactly.
And so it is something to consider. And I think looking to UAI Act where they're dealing with the general purpose AI in more of a disclosure manner, I think would be something, and then with more requirements on the higher risk activities. So are there any questions? Thank you very much for coming to testify and for all of your help.
Yeah, thank you all.
Okay, next. Daniel Hinkle.
Thank you, Chairman Maroney and Chairman D'Agostino and members of the General Law Committee. My name is Daniel Hinkle, and I'm here to speak on behalf of Senate Bill 2, on behalf of the Connecticut Trial Lawyers Association. I work for the American Association for Justice. It's the national trial lawyer organization and tracks state legislation around the country on AI and 1,000 other issues. There's obviously a lot of very thoughtful consideration that went into this bill, and I thank you for raising some serious and important issues. This is a big bill, and I'm only going to try to address two parts of it today. First, on subsection 9, criminalization of deepfake pornography is an important step, and we believe this should be strengthened by including a civil right against this practice and ensuring that the developers of the AI products who knew or should have known that they were being used to generate non-consensual deepfake pornography are held accountable as well. These tools are exploding online. They're being built and used to target both women and children. We need every tool in the toolbox to fight this obviously terrible use case for artificial intelligence, and we are more than willing to work with the committee to provide models on how Connecticut can be a leader in addressing this. The second point is we have serious concerns with sections 1 through 7 and the exclusive AG enforcement that would prevent consumers and employees from holding AI product manufacturers accountable. Senator Wong, Marissa Belair, D'Angelo Ziotis all addressed this and did a terrific job of explaining the key issue. And I appreciate the chairman's willingness to address this issue as well. With that in mind, I want to make a bigger point here. The goal in this legislation through 1 through 7 seems clear. You see the risks and harms, as well as the benefits of artificial intelligence. To protect the benefits of AI, you want companies to act with reasonable care to protect against risk. You want companies to take steps to make sure their systems are safe. You want them to provide notice when these systems are being used and critical decisions. You want them to comply with risk management frameworks. All of these things are great, and thank you. That's terrific. It's the method that is the problem. It preempts private claims, and it shouldn't. It should not have a rebuttable presumption. It should not have affirmative defenses that get around these requirements. There are other approaches you can use. If you believe these specific protections are necessary to protect Connecticut consumers, then I recommend you make them requirements for operating in Connecticut and let people hold the companies accountable if they don't. But at the very least, I recommend a do no harm approach to ensure that consumers and employees can hold companies accountable under existing laws. Now, Senator Maroney, you talked about balance. Our civil accountability system is designed to strike a balance between freedom and safety. There's no pre-market burden to slow down innovation, except the right for consumers to hold companies accountable for the harm they cause. This is a fair principle Companies who cut corners, discriminate, or cause harm should pay for the harms that they cause because it makes them less likely to cut corners, discriminate, and cause harm. But this fair principle is not a principle that the big tech industry is used to. And I fully expect
Mr. Hinkle, just
that-
heads up, you have the 3-minute marker.
I fully expect that there's going to be outrageous, unreasonable, and self-interested claims about the need for immunity here. We cannot and should not live in a world where the high priests of AI are considered beyond reproach, especially when their systems cause harm or discriminate. And I welcome the committee's questions.
Thank you very much. Are there any questions? Okay. Thank you for your testimony. And yeah, I'm sure we'll be in touch as we move forward on the legislation. Okay, next, Chris Pulaski. Oh, no. Okay. Next, in person, Tim Phelan. From Woodmont?
I know, this is one of my state senator. I gotta be in my best behavior. Good afternoon, everyone. For those of you that don't know me, for the record, my name is Tim Phelan. I'm the president of the Connecticut Retail Network. Some of you may remember us as the Connecticut Retail Merchants Association, but we've changed our name recently. And I just wanted to make a few comments. Our association represents retail businesses, both large and small, across the state. There are roughly 42,000 retail establishments in Connecticut. In total, the retail industry produces approximately 14% of Connecticut's total GDP. Retail businesses are an indispensable part of Connecticut's economy, supporting more than 470,000 jobs and contributing more than $34 billion to our state's economy. More than 98% of the retail companies are small businesses employing fewer than 50 people. Today, we'd like to share some comments related to Senate Bill 2, an act concerning artificial intelligence. First, I'd like to say that we continue to appreciate the thoughtful leadership of Senator Maroney here in Connecticut and beyond, and the efforts of the working group, as well as interests of the Connecticut legislature in this rapidly unfolding technology. It's important to take steps to safeguard our citizens and industries, and to also understand how this technology is being provided to businesses in many fields, including retail, by the technology industry. At this time, our members are still continuing to review and fully analyze the numerous components of the bill and potential ramifications. We look forward to sharing the results of that review with you and as you consider this proposal. We realize that AI is here in a growing presence. As Connecticut residents and Connecticut businesses, we're quickly becoming aware of the degree of which AI is a double-edged sword, presenting all of us with potential and possibilities that could be helpful in our lives, and at the same time offering realities that can be detrimental in many ways. Without a doubt, technology companies are increasingly providing products that are AI enabled, and retailers, like other businesses, are navigating this new landscape with the best interest of consumers in mind. And so as with so many industries, technology is an inescapable component of the retail industry. So much so that that any retail industry convention, like the NRF Big Show in New York, that's held in New York City every year, can often resemble a consumer electronics show. That's true for many industries today, as it is in our daily lives. There will likely be a need to be a balance struck that allows for the benefits to be used and effectively and responsibly, while the potential harms are prevented from adversely affecting our fellow citizens. And we are confident that, like we work together on the privacy debate, Senator Maroney and other members of this committee, that we will find that right balance between all the parties involved. So that's why we want to continue to work with you as you craft this legislation to make sure that it's done carefully and to avoid any unintended consequences that unnecessarily impinge the best interests of either retailers, or in addition to the retailers, but most importantly to us, our consumers. So we'll continue to work and analyze the bill. We'll get back to you, Senator Maroney and other members of the committee with our comments, but we just wanted to go on record today to make sure that you understand that this is a very, very important issue for the retail industry. So thank you for your time.
Great, thank you. Are there questions? One thing I would say is we definitely would like to partner with you, as you heard me say before, that customer service representatives, there's a high percentage of those skills that could likely be replaced by generative AI.
Yep.
And we want to make sure that we're making your employees aware of any free training opportunities that we create so that they can upskill and reskill themselves to either become more valuable within where they're working, or to help them in the event that they may lose their job at some point to get a new job.
Well,
and
that's
have those
terrific,
skills.
Senator. We look forward to working with you on that. But most importantly, in addition to all of that, the language of this bill and how we can all operate under it, it's really important for us to stay close on that as well.
Great, thank you. And since you have a number of members who are in New York City does had enacted legislation in regards to algorithmic for hiring.
Yeah.
Algorithmic
You know-
discrimination in hiring.
Yeah.
Whatever feedback you can get from how it's been for your members to comply would be appreciated.
Okay, we'll do. We'll
Great.
make sure we had that.
Thank you very much.
Okay.
Okay, next, is it Anissa Reed?
Hi, good afternoon, Chair D'Agostino, Chair Maroney, and members of the General Law Committee. My name is Anissa Reed, and I'm here to testify on behalf of CTIA, the Trade Association for the Wireless Industry, to respectfully express our opposition to Section 6 of Senate Bill 3, legislation aiming to implement state-regulated net neutrality laws. CTIA and its member companies support an open internet. To further that goal, we support a bipartisan federal legislative solution to enshrine open internet principles to resolve this issue nationwide and once and for all. We oppose, however, piecemeal state regulation of the borderless internet and mobile wireless broadband, a truly interstate service like this legislation. With the FCC taking action in the first half of 2024, we urge Connecticut not to move this legislation, which would be ripe with preemption. Since 2018, under the current regulatory framework, U.S. wireless investment has increased for 5 consecutive years, with a historic $39 billion invested in wireless networks in 2022. The wireless broadband marketplace is providing tremendous consumer benefits. In the past 7 years, median download speeds have quadrupled, while wireless prices have decreased 11%, despite near historic general inflation increasing 26%, according to the Consumer Price Index, and it is paying off in times of need. When the COVID-19 pandemic hit, America's networks handled an unprecedented surge in voice and data traffic almost overnight. Of the 10 countries with the highest populations, only the United States did not experience any download speed degradation in April of 2020. Wireless networks delivered more data faster than ever as median wireless speeds in the US increased from 2020 to 2021 by nearly 50%. We must work together to ensure investment continues while protecting the flow of information consumers expect. Thus, we support federal legislation to ensure there's a uniform national framework for the open internet. We welcome Connecticut calling on Congress to resolve these issues at the federal level, but must oppose state-by-state legislation. Connecticut should not add any further conflict and confusion by passing this bill. We've seen this bill introduced in Connecticut since 2018, and it has continually failed to gain full support from the General Assembly. It was unnecessarily in 2018 and is certainly unnecessarily in 2024 as we await the FCC taking action. Accordingly, I respectfully urge you not to move this bill. Thank you for your consideration.
Thank you for your testimony. Are there any questions? Okay, hearing none. Thank you so much.
Thank you.
Okay, next, Donald Janelle.
Thank you, Senator Maroney, and committee members. My name is Don Janelle. I'm a deputy emergency manager for the town of Manchester. I'm also a drone pilot. So you guess what I'm going to be talking about. The first thing I wanted to do is that a lot of drones have claimed to do the same thing, and some do and some don't. We have flown them all on our team. We're very familiar with them. But I'd like to make one point that might help people that don't know about the drones and these technical wizards that they are. And that's this FLIR, forward-looking infrared cameras, which is a technology that all emergency managers and all emergency service responders use to help find lost people and monitor fires. And the best way I can explain it is on the ANFI, their technical spec is 320 by 250 lines of image. That's how their detail is. And the standard right now is 640 by 516. What does that mean? It's the same as a 2K versus a 4K television. Okay, it gives you twice as much image, twice as much detail on the same screen size. So the 320 versus 250 is a blur. It just shows blobs of color. You can't even tell a dog from a human being. Or if that human being has a gun or a pack of cigarettes in his hands. The 620 will allow you to do that. So by comparing the ANFI with the 320 versus the Matrice with the 640, it's apples and oranges. They're not the same. And I'd just like to clarify that so we're all understanding what's going on. And I also would like to echo everything that Chief Gentili said. He's spot on everything he did. I couldn't agree more with him. And in sake of brevity, I'm going to try to brief mine up a little bit. But it's not just the cost of the drone that we have to replace. Every one of those drones responds and works differently. So the pilots have to learn how to fly them. You also have to buy the additional infrastructure so that there are other things that go along with that, just not the drone. The drone is the engine, but it's not all the other pieces and parts that have to come together. So there is an additional cost. I heard a number, I can't substantiate it, but in Florida, they banned drones, about $10 million plus worth of drones. But I think the figure was $1.3 billion for the infrastructure and training and lost manpower. So that's a huge amount of money that's going to fall onto the municipalities. And a lot of them can't afford to do it, especially nowadays with budgets being tight. We use DJI and Autel drones, not because we like them, but they're the best tool for the job. And they give us the most cost-efficient piece of property that we can use to do that job. And we're trying to be as frugal as possible. And I would, myself or any one of the pilots over there would be more than happy to come out at night and we can demonstrate what FLIR does and what the capabilities are of these drones. If you're interested to see them, we'd gladly come out and fly for you anywhere, anytime. And I'd just like to leave you with one question. If a family member of yours or a loved one is missing in the woods in the middle of December, or along the Connecticut River, or along the shoreline, wouldn't you want the search teams to have the very best tool possible to help locate your loved one as quickly as possible? And with that, I thank you for your time, and I'm happy to answer any of your questions.
Thank you very much. I do have a question, if you wouldn't
Yes, sir.
mind clarifying. So the earlier testimony, Chief Gentili had said that when we were making the comparison, we were doing it without payloads. Can you explain what exactly that means by
Yes,
payloads?
Easily. The drone is the platform that flies. Hanging off the bottom of the drone or in the front is the camera module. That's a payload. Some of them have additional capabilities where they can put a floodlight on there, a speaker system on the payload. These are all things they can carry. A package release. So like if down at the shore, if like at Hammonasset, they can have a drone that has a life preserver hooked up to it. They could fly that out to the person that's in trouble in the water. That's a payload. So they're different payloads for different jobs, but they're not interchangeable with companies. So a payload that works on mine won't work on theirs, but it's the same. It's the payload, and DJI has probably the most robust payload system out there.
So it sounds then like a lot of the value of the drone is the payload, right? If
Oh,
the
absolutely.
camera, the spotlight, the other.
A zoom camera is probably $3,000 or $4,000.
Okay.
The FLIR camera is about $5,000 or $6,000. So they're not cheap things. They're not toys. These are tools.
Okay, great. Yeah, Senator Chicarello.
Thank you for coming to testify today. So when you talk about the cameras, I think that's the concern. And that's why it's in this bill is the camera and capturing the data. As you said, part of the cost is not only the device, but how to use it. My understanding, can you swap out the camera so the camera could be manufactured here in the States, but the actual device itself, the drone itself, could be continued to be used? Would alleviate some of the concerns.
They're proprietary. As a matter of fact, a payload with the camera on a DJI Inspire, which is an older version, will not work on the newer DJI 300s. They're not even cross compatible within their thing. And that's their marketing. Really, they're just not making them to be compatible with each other. It's like a Nikon and a Canon camera. Their lenses are not interchangeable. It's the same thing with these payloads. They're not interchangeable.
Thank you for clarifying that.
Great. Thank you very much for your testimony and for hanging in there all day with us. So
Okay.
go enjoy the outside and tell us what it's like. All right, next, Mr. Clerk. Robert Weissman from Public Citizen, and he is online.
Hi, thanks for having me. It's great to be with you, Chair Maroney and members of the committee. I'm Robert Weissman, President of Public Citizen, a national consumer and democracy advocacy organization. I'm offering comments on SB 2. 3 quick comments. First, we just want to appreciate the seriousness of this bill, the recognition by Connecticut and you all specifically of the promises, but also the perils of AI, the need to promote it, spread the benefits of AI, but also impose important safeguards. I think that's reflected in both the substance of the bill, the process by which, and the consultations by which it's been developed, and the care and thoughtfulness of this hearing, including your stamina in conducting this hearing, which I wanted to acknowledge. Second thing, I think in terms of sections 1 through 7 of the bill, really want to appreciate the need to be forward thinking about harm, some of which are happening now, some of which are very foreseeable and almost certain to happen, and to impose specific standards to address discrimination, to discuss some of the threats that generative AI poses, and to do that in really careful and thoughtful ways as you do. I do want to echo the concerns that have been raised on the issue of private right of action. We would strongly favor adding a private right of action to enforce the standards that are articulated in sections 1 through 6. But the most important thing for sure is eliminating just that small clause in section 7D that I think reasonably is being interpreted as stripping away existing causes of action that might relate to the sets of conduct that are being discussed in sections 1 through 6. That would be the single most important thing, I think, to make sure that existing rights aren't being taken away. And I think it's been a very good conversation to indicate that that's not been the intent and that people are excited about moving forward to correct or adjust that provision. Third thing I wanted to do was focus on the issue of political deepfakes in section 11. I can tell you that at Public Citizen, we are working very hard to have federal rules in place before the 2024 election on political deepfakes. And I can tell you, I am not optimistic that we're going to get there, which makes it that much more important that Connecticut and other states take the leadership on this issue. And we're very pleased with the provisions that are included, which I think get to the right balance, prohibit the practice of deceptive and fraudulent deepfakes being imposed on voters, give a cure of having disclosures to tell people that they're witnessing something that's fake and not real. One recommendation we would have to strengthen the language in that section is to take out and replace the language on preliminary injunctions and temporary restraining orders to actually affirmatively allow for preliminary injunctions. This is an issue where you need really fast action. If the problem is not solved quickly, it's sort of not being solved at all. So we would recommend changing that language and explicitly establishing a right for preliminary injunctions to issue when the requisite showings have been made. That said, we're very excited about your leadership. I think other witnesses have been correct in saying this is going to be a template for other states across the nation. We just, again, really appreciate your leadership. Looking forward to doing what we can to work with you to strengthen the bill and get it across the finish line.
Thank you very much for your testimony and actually for your leadership in working with states around the country on the election issue specifically, but many issues. And I just wanted to, I guess the spirit of disclosure, there are changes we do need to make, and thank you for pointing them out to us, Robert, that we pulled from your model legislation that will be added, namely that we do need an exemption for satire to make sure that we're maintaining the constitutionality of the bill, and that we are looking to not put blame on the platforms that would share this if it's not their fault. So again, putting in some form of surety for them. And yeah, if you have language you could send around the preliminary injunction, that would be appreciated. And then I may need to set up a follow-up discussion with you on that point, if that would be okay.
We will for sure send that to you. And of course, we're available for as many ongoing conversations as you want to have. Again, we really appreciate what you're doing. We want to be supportive and get this thing as strong as possible.
Right. Thank you very much.
Thank you.
Okay. Next. Mir Jain.
Yes, hi. Good afternoon. Good evening, Senator Maroney, Representative D'Agostino, Senator Fanfara, Representative Brown, and the members of the General Law Committee. My name is Meher Jain, and I am a member of the Mayor's Youth Leadership Council at Stanford High School. You heard earlier from my friend from the Center of Youth Leadership in Norwalk. Both of us are speaking in support of Senate Bill 2, an act concerning artificial intelligence, especially Section 9, which updates state law to prohibit the, quote, dissemination of synthetic images that are partially or fully generated by a computer system, end quote. I'd like to acknowledge that the bill does not outline recommendations for the Department of Education in K-12 schools. However, the report of the General Assembly's AI Working Group does, which we greatly appreciate. For example, we support recommendations of the Connecticut Academy of Scientists and Engineers for students in K-12 schools, especially those that address, quote, ethical dilemmas and bias, equity, and digital access, project-based learning, teacher professional development, and partnerships with universities and technological businesses, end quote. We appreciate the group's use of the term, quote, digital citizenships, which the International Society of Technology Education defines as, quote, the ability for students to recognize the rights, responsibilities, and opportunities of learning and working in an interconnected digital world and model ways that are safe, legal, and ethical, quote. Schools need to get ahead of the increasingly sophisticated technologies so students can learn responsible applications of AI. It is appalling to think about the lack of education, not just around AI, but technological safety in general in K-12 schools. The use of AI grows in schools every day, and the education needs to grow with it. I personally feel more vulnerable into the growing age of technology, as more of my personal life and information is online whether I want it to be or not. And I can really feel the lack of knowledge that we are given on it. There is unfortunately have not been a proportional growth in education on digital citizenship in comparison to how much of our lives have moved online. My own parents continue to ask me about things we learn on digital safety in school, and it's regrettable that I'm not able to provide any new or hopeful answers. We deserve to learn how to protect ourselves on all fronts, especially in the new digital world. We hope that this bill will bring more awareness to our lack of education on these issues and lead to eventual change in the K-12 level, as this is urgent and necessary. I want to thank Senator Maroney and other members of the AI Working Group for recommending that, quote, as many voices as possible should be included in drafting a model AI policy for school districts. We will be sure to highlight these recommendations when we testify before the Education Committee. On behalf of our 137 members in Norwalk and Stamford, I want to acknowledge that Senate Bill 2 gives people our age an important option to respond to the non-consensual distribution of computer-generated intimate images. Thank you for looking after our online safety, and I'm open to any questions the committee may have.
Very well done. Thank you for your testimony. I do have some questions. So one, I would say thank you for testifying to the Education Committee. The education recommendations that we had made in regards to AI are included in Senate Bill 5. So hopefully you can look at those and help us make recommendations on how we can improve them. when you mention your parents asking you questions, that is a thought, and actually one of the things that we were looking at. And so I want to get your opinion on this. You know, as a parent, I know at the start of the school year, I used to be required to sign off on policies and procedures that were emailed home. Knowing how busy it is in the school day and how much that you already need to do, again, we are a little concerned about making requirements of things that you would need to do as a student within the school day. So the thought was to create a video course on responsible AI that would be sent home, that both the parents and the student would take. So they'd watch an educational video and answer a few questions. I'm wondering your thoughts on that approach.
Yeah, I think that is definitely a great start. I believe that any kind of education that we can further on AI education is crucial to being able to bridge that divide between students that don't really have that education. In terms of the fact of where you can like fit in that education within the school day, obviously, I know that's a little bit concerning, especially if it feels like there isn't enough room for these requirements. I know that at our school district in Stanford Public Schools, or at least at my middle school, there is we had a technology class for 2 years up until COVID. And my brother, who is in middle school, his school is very revolved around technology. They also have a technology course. In terms of my personal technology course, the course was not really up to par with what technology should be. I felt we weren't really doing anything that was really progressive in terms of technology, but it was a required class. Like we had that there. It wasn't developed at any sense, but it was there. So there is definitely room, especially in middle schools where that kind of development age is kind of happening. We believe that there can be room, especially in some of these schools. The courses just need to be updated to reflect the changing in the AI. In terms of the video, I think it's a great start. And I do believe that we should also move towards much more comprehensive education, especially for our younger children who are going to need to be able to accommodate to this.
Great. Thank you so much for your response and for your testimony. Hearing no further questions, again, thank you. And we look forward to hearing your testimony to the Education Committee. Next, James Brogel.
Yes, that's me. Thank you very much. Thank you, members of the General Law Committee, for allowing me to offer some remarks on SB2, this very important legislation related to artificial intelligence. My name is James Brohl. I'm a senior fellow at the Competitive Enterprise Institute, a think tank in Washington, D.C., and I commend your efforts to put together this ambitious legislation on AI. I just have a few concerns which I wanted to voice as well. First, on some of the heard a little bit about this already, like high-risk AI system, consequential decision, intentional or substantial modification. These terms are likely to sweep in a vast array of activities and software, not just advanced systems posing dangers. Second, the extensive documentation requirements on the high-risk systems may not be feasible given the constant need to update software and the nature of some open source systems. Third, expecting developers to foresee every risk and use case of their systems sets a very high bar and a difficult standard to comply with, again, especially for open source systems. On the authenticity tracking and enforcement, I think that watermarking is a worthwhile initiative, but it's not clear whether the technology really is there yet for that. And I suspect many companies will adopt these sorts of technologies on their own. I have concerns, fifth, about the authority granted to the Attorney General. It just seems very sweeping. And then finally, just the law as it's written is very ambitious. It covers a vast array of territory, ranging from watermarking to high-risk foundation models to algorithmic discrimination. And I think that a more piecemeal approach that addresses discrete problems as they arise on a case-by-case basis may take a more targeted and efficient and welfare-improving approach. But again, I'd like to commend the legislators for their ambitious efforts in this area, and I'm happy to answer any questions.
Thank you. Are there any questions? I would just push back on, when you say waiting till problems arise. we're often criticized in government for only being reactive. And so now we're taking an important piece of legislation to be proactive. And so it would be, I would say we know we need to incorporate many voices, but I think that, we are trying to be proactive here. We've been criticized for only being reactive and waiting until things happen. And if we can foresee harms, we have seen things that have happened. There's been instances of hiring algorithms that have been discriminatory, instances of lending algorithms that have been shown to discriminate. And we know there are these risks. So I don't know how much longer we need to wait to address them.
Sure, I think those are all excellent points. And I come to these issues as an economist, so I tend to focus on the costs and the benefits. And so I just think it's important to balance the risks with the benefits. There are already anti-discrimination laws on the books, anti-fraud laws on the books. And so where possible, those can probably already be used under existing authority. But in cases where there are problems that are demonstrated to be real, then it could make sense to target solutions at those areas. And discrimination may very well be one of them. Thank you.
Yeah, thank you. And I was an economics major in college. I wouldn't call myself an economist because I really haven't studied economics for a while. But the one thing I remember from that is, what would you get if you laid all of the economists in the world? What would you not reach if you laid all of the economists in the world end to end? A conclusion. So I think that reasonable people can disagree, but I do agree that it is important to look at risk to reward and cost benefit on there. So,
Absolutely.
And to focus more tightly on higher risk uses. All right. All right. Thank you. All right. Thank you very much for your testimony.
Thank you.
Next, in person, Dr. Rocco Orlando.
Good evening, Senator Maroney, Senator Ciccarella, Representative Bertigliano, and distinguished members of the General Law Committee. I'm Rocco Orlando, and I serve as the Senior Vice President and Chief Academic Officer at Hartford Healthcare. I oversee all of our university partnerships, our research program, and a number of years ago, along with my colleague, Dr. Barry Stein, who you heard from her earlier today, we established an innovation platform at Hartford Healthcare. And during the last 7 years, we've been working very actively to use artificial intelligence to improve healthcare outcomes. So I thank you for the opportunity to testify regarding SB 2. First, I want to recognize Senator Maroney for your incredibly diligent efforts and leadership in bringing this effort to the forefront of the legislative agenda. And my remarks tonight are really going to focus on the introduction of AI in healthcare. So I'm going to focus on healthcare. And while I'm generally very supportive of the goals of the bill, I believe that there are several opportunities to make some improvements that would keep patient safety at the forefront. So I'm going to address 4 points briefly: governance in healthcare AI, assurance of patient safety, AI as a vehicle for economic development, and finally, the use of AI to actually achieve better outcomes with respect to health equity. With respect to governance, I would respectfully suggest that the bill include language that would require healthcare systems and provider organizations to develop a governance process to inventory the increasing use of AI in their organizations. These things are coming at us as fast as can be, and to assess the potential risks of these applications and to put in place processes to monitor the outcomes associated with their ongoing use. This approach would be consistent with emerging requirements from the Joint Commission to ensure safeguards in the use of AI. And of course, the Joint Commission regulates the activities of all of our hospitals. In terms of patient safety, these systems do have the potential for harm. And so this needs to be enhanced with appropriate and thoughtful deployment of AI systems. And I would offer that there are, at the federal level, 2 agencies, the Office of the National Coordinator for Health Information Technology, ONC, and the FDA will be providing, in the case of FDA, have already provided regulatory oversight about certain forms of health AI. I would suggest that the AI approved by the FDA and ONC be excluded from the requirements of SB 2, since there is in place sound and strong federal regulation. And then on the safety aspect, it would also suggest that there is much research going on in Connecticut in our healthcare systems and our universities with AI. And I would suggest that AI research conducted under the auspices of an institutional review board to really protect patient safety, that might be something else to consider exempting from this regulatory process. Just one brief comment. AI is certainly can be a potent driver of economic development in Connecticut, and Connecticut is well positioned to be a hub for the development of health AI with our universities, both public and private, and our large healthcare systems. And so we do have to be cautious about those regulations that could serve as a disincentive for companies, and particularly early stage companies that wish to locate in Connecticut. We really want to encourage them to work here. My final point is really around health equity, and certainly all of the cautions that are being raised about bias in AI and the elimination of bias are certainly there. But I'd like to suggest that we can actually use AI to improve health equity. And so in a society where bias—
Dr. Orlando, just a heads up,
Thank
you're
you.
off the 3-minute marker.
Yeah, so I will summarize. It is possible that one can use AI techniques, and we're doing this at Hartford Healthcare, to actually identify health inequities and then to develop interventions that address them. And so AI becomes a tool that can be used to actually improve and ameliorate those current deficits. Thanks for the opportunity to speak here tonight, and I'm open for questions.
Great. Representative Acker.
Thank you, Mr. Chair, and Doctor, thank you for being here. You mentioned the two federal areas. You mentioned, is ONC, you said?
ONC is an agency of Health and Human Services. It is the Office of the National Coordinator for Health Information Technology. And they regulate the things like our electronic health records and the laws that govern that. And so they do have oversight. Now, they are in early going, but in their work in regulating AI, and there is already in so much of our electronic health records, AI, it's not coming, it's here. It's in these tools right now. So they have the authority to regulate that. FDA has the authority to regulate the use of AI that is associated with the use of any medical device, and they've already published guidelines, and there are many AI technologies currently approved by the FDA, and there is a regulatory process to do that.
Thank you. Earlier today, a gentleman, Neil, spoke about Epic.
Yes, so Epic is an electronic health record. It is the largest of the vendors of electronic health records, and actually here in Connecticut, we are actually the most heavily penetrated state in the country with Epic, because Hartford Healthcare, Yale, Trinity, UConn, Connecticut Children's, Middlesex all use Epic. So about 80% of the citizens of Connecticut have an Epic record.
Thank you, and that's what I was getting at, because we're talking about sharing information, and that like each of the probably hospitals use their own inputs. And so they don't really talk to each other. They don't share information together from what he had mentioned. Is that something that is in the future that we
No,
would?
so I would disagree with that. So for the purposes of patient care, we actually share information fully among the different healthcare organizations in Connecticut. When we introduced Epic and when Yale introduced Epic, I was actually chief medical officer at that time of Hartford Healthcare. And I brought together all of the chief medical officers of the health systems that were using Epic. And we agreed at that time, in the interest of our patients, we would share all of that clinical information. So, and I'm a practicing surgeon here in Hartford. So if I'm caring for someone who's had care at Yale or across town at St. Francis, I can see what their care is. So it is fully open. Now, what it is not open for is all of that data is not aggregated into a single large cohesive database that can permit innovation and research. So I think that's what the previous speaker was really alluding to. But in terms of the provision of care, if I'm caring for someone, I can see their data wherever they've received care.
Thank you. And I appreciate that. And I think that's I like that clarification or that correction from the understanding of that, but also that second piece that you mentioned, if you could not share personal information, but, things that you found, that you worked on in one health district to another, hospital to another, where innovation that you found something and that was put up into that information, that AI information out there that somebody could access, you know, in a different hospitals, in a different hospital. So that's kind of what I was hoping that if we're gonna use this for, you know, the intellectual component of it, that we can share that information and help that next doctor and that other patient down the road. So that's what I was hoping you were going to mention in that discussion. So.
Yeah, and Senator Maroney has actually been talking and about creating computing clusters. Those powerful, you know, large computing clusters that's really the place, the vehicle through which you can aggregate these data from multiple health systems to really learn and create new knowledge.
Thank you very much. And thank you for your testimony and the work that you do.
Thank you.
Senator Ciccarello.
So just to clarify, maybe in layman's terms, so we have MyChart Plus. What would those be called?
So MyChart is simply Epic's nomenclature for its patient portal. It's the functionality within Epic that allows patients to communicate with their doctors.
And so MyChart and MyChart Plus would be within Epic, if that may.
Yes, though the MyChart, whether you brand it as MyChart or MyChart Plus, it's simply a module within Epic. It's part of the overall Epic suite of services that becomes available to patients.
So in Connecticut, all of them are under Epic. So Hartford Healthcare, Yale, you said you could do a surgery on someone at Hartford Healthcare, but if they were being treated at another hospital, you're able to see all of their records.
Correct.
And is that using
I can see all of
Epic?
their records. Yes, that's using Epic. There's a functionality in Epic called Care Everywhere that brings together the data from all of the disparate health. We all have a different instance of Epic because we all have a different contract, and we've implemented it with some minor variations. But the basic data, I can see the operative notes, I can see the X-ray reports, I can see all of the laboratory data. That all flows across this entire Epic ecosystem, which is why, you know, I can see all of that clinical data for my patients wherever they've received care.
So then what is the AI needed? If it's able to collaborate now, what is needed in the AI? Because maybe about 2 years ago, Gaylord Hospital had a problem because their systems couldn't read all of the different forms of communication or systems that were in each individual hospital. So they had to get a grant to be able to digest that information and provide the proper patient care, have all the notes and have all of that history. What am I missing? I apologize.
I'll give you an example of what the data that we share is simply the sort of the facts, the basic facts. You know, what's your blood count? What kind of operation did you have? The AI really provides clinical insights to assist the clinician. An example of AI that would sit on top of Epic that would then use all of that data might be an algorithm that would help doctors predict sepsis, you know, a severe condition that can occur with overwhelming infection to hospitalized patients. Suggesting to the clinician that someone might be at risk for sepsis, that doesn't come out of basic Epic. That would come out of an AI application that leverages all of the data within Epic to then provide that as something, and we call that clinical decision support to inform them. That's where the AI uses the data that is in Epic to provide those insights and suggestions.
Excellent. And that was great in explaining to me how we would utilize the AI capturing the data for all those systems. Thank you for clarifying that. That sounds extremely beneficial and helpful for doctors, especially with so many doctors treating the patients. Thank you.
Thank you. Thank you very much. And just, I guess to go back to, we talked about the health equity issues and designing grants. Do you think that would be beneficial if we were to create some grants in some way? And I believe we spoke the other day and you said you had run a similar program through Hartford Healthcare.
We've done that at Hartford Healthcare, and we actually, I was able to put together some funding for some pilot grants that would be available to our clinicians to identify areas of health inequity. And I like to think about it as health inequity, not health equity, where we actually know that within our communities we have problems with the way we're caring for folks in our communities. And so we have done that, you know, some small seed grants and done a number of initiatives. We've, you know, published over 22 publications on that. And that seed work, that's preliminary work, is leading us to apply for grant funding from federal agencies and foundations to really further advance this work in addressing the health inequities that we discover. So I think that a small program that might encourage that kind of activity would be of greatly beneficial.
And I think we had discussed, so the small program initially, right, to incentivize some of this research, kind of building the funnel, right, of potential, and then next, some sort of a fund with grants to clinically implement. And is
Yeah.
that what you're in the process of
Yeah, it would
applying
be
for now?
it would really be a two-tiered program. One would also, there's an economic development play here as well in terms of, looking at companies that are wishing to solve some of these important problems. About a year ago, we actually sponsored a health equity accelerator. We were specifically looking for startups that were interested in addressing health equity problems. Those are very exciting opportunities, and some of those companies are Connecticut companies that we hope will be growing here in our state.
Great, thank you. And, just back to the point of exempting AI for research, Section 7 does have an exemption for research subject to an IRB, but also discussing, when you say exempting AI approved by FDA and ONC, so it would be that specific, there would be an exemption for that specific algorithm, that specific device versus for the hospital overall.
No, I'm suggesting it would be for the particular algorithm or device.
Okay, and that definitely makes sense. So, and thank you very much. Thank you for that and for all that you've been doing.
Thank you very much. Thanks for the opportunity.
Have a great day. Okay, next online, is it Jeremiah Quinlan? Okay, Christopher. Okay, Chief Vangile.
Is that Chief Shabina she looking for?
Yeah, it is. Please go ahead.
That's okay. All right, I'm Chief Shabinas from the Dayville Fire Company. 37 years of service to the town of Killenly. I'd like to, say it's been a great day. Listen to everybody gaining all the information. I'm not a big tech guy. I actually had, when this came about, I was into purchasing a new drone to replace our older drone, which is the DJI One. At that point, when it was brought to my attention, this bill, I did ask my personnel. I said, especially my tech people, I said, why aren't we purchasing American drones? We're using taxpayers' money. Almost everything we purchase is American through, our Scott packs, our vehicles, everything. So I had them go out, do the search, and what the two other people ahead of me said is the capability is not there with them. We'd be basically wasting taxpayers' money. So at that point, I'm backfeeding here for some reason. I don't know if you guys can hear me.
Yes, we can hear you.
Oh, I'm sorry. I apologize. I had a little technical glitch there. So I did have my people look into purchasing an American made one. It just didn't make sense to me. They can't do the same things. They have half the battery life. The cameras don't work as well. And then kind of sitting here tonight, listening to people talk about the drones, and it kind of makes sense why the federal level did what they did. Because if you let our Navy base purchase a drone, where are they going to practice with it? They're going to practice with it right over the Navy base, areas where we cannot fly. We're not allowed onto those areas. We can't go on to General Dynamics. We can't go over Navy bases. We're not allowed to any of that. So I get why the feds did it. It makes perfect sense. But when it comes down to us, we're first responders. We're trying to help our neighbors out. When we had that mill fire in the Quiet Corner a couple months ago, and you could see the fire from the Google satellite. It was on all the weather channels, all because of all the heat. But When we used that drone, it helped us find hot spots of how the fire was spreading throughout the woods, possibly spreading to people's homes. It was really an essential piece and it helped out a lot. These drones are just, they're great. They're great to use. They do just like what we do is we have a separate computer. So when the iPad comes back, it goes onto that computer system. The information is downloaded on that computer system. Only 3 of us have access to that, me and the 2 other tech people. And that is it. The only way that is ever accessed is if the fire marshal or state police or somebody asks us to have the information. Then, of course, we're going to help out and oblige. We have, like I said, used this drone to locate citizens. And for our area, being the quiet corner, it helps out. That drone has gone into Rhode Island. It's gone into Thompson, Connecticut for fires, Pomfret. It's a great regional tool, which we all talk about regionalization. So this is something that promotes training together, working together. It's just such a great tool in the toolbox. I can't explain it enough on how well it is. And like I said,
Excuse me, Mr. Shabanis, just a heads up, you're at the 3-minute marker.
okay, and like I said, the last thing I'd say is if the American drones were ready to go and they were just as capable, just as good, that's what we'd purchase. That's what we would do. If you have any questions, I'm right here.
Thank you. Does anyone have a question? I guess I have a question. So you said you're replacing your old drone. How long did it take before you had to replace the drone?
We've had that drone for 5 years and we've been pushing it. My drone tech guy who been asking me for actually probably a couple years to start looking at it because of the change of technology. Just so much. Right now he has to bring it up and change cameras to bring it down. So he'll fly it up. Then if he has to switch to the infrared, he lands it, switches cameras. The new one will have all that built in and just makes it all one unit. And it's tough when you look at, we're a taxing district, so we have our own budget. But when you're trying to explain this to taxpayers, the new drone we're looking at, I think if, don't quote me to the T, but I want to say he said it was a little 18 and change. And then I don't think I could get one by for 35,000, but 18 I probably can. And it's going to have everything we need, extra batteries, extra everything. And, we understand, using these things the appropriate way, the proper way. I mean, that would be, even if this wasn't brought up, I have rules, that we train, we do flight plans. He does everything by the book. So.
Thank you very much. Okay, Mr. Clerk, next.
Go. Please.
Hi, Chief. Please proceed.
Hi, thank you very much for having me. I appreciate the time you're here, especially this late hour. My name is Chief Chris Vangeli. I've been a police officer for 31 years. I've been a chief in Plainville for over 2 years. Prior to that, I spent 28.5 years with the Newtown Police Department. I'm testifying in opposition of SB 3, specifically Section 4, which would effectively ban police departments and other entities from purchasing and using drones made in China. Simply put, and this is not hyperbole, this will take life-saving tools away from our department and significantly hamper our ability to do our jobs to protect the public. It'll place officers and citizens alike in life-imperiling danger. Our department has had a drone program for the last several years. We use drones for a variety of reasons, from locating Alzheimer's victims who have wandered off into the wooded areas, locating bodies of persons in certain areas where the heat signature from their body is immediately picked up by the infrared technology that we have on our drones, which allows us to quickly locate them using GPS and save their lives. It also helps us locate criminals who run away from us and pose a danger to our community at large. And it's a valuable tool that acts as our eyes and ears in extremely dangerous, life-threatening situations where the knowledge of whether a suspect is armed or not can save our officers' lives and that of the suspect and innocent victims. Over the past year, in and of itself, I have 2 instances that I'd like to share with you. One is 2 of them were individuals who fired weapons inside their homes we were dispatched to these. Obviously, we got any people that were innocent outside of the homes, and we had to get our SWAT teams out there. Now, in the past, without drones, the SWAT teams would have no idea what the suspect is doing and whether or not they were armed. They'd have to make entry to determine whether or not the person was armed, and that puts lives in danger. In these two situations, the drones were able to fly outside of the home. I was watching this on a large screen TV. It was feeding live images back to the SWAT commanders, and it was showing the person inside the home, and was able to give information to the SWAT teams of where the person was located, what they were doing, and whether or not they were armed. It allowed the entry team to go in at the exact time when that person did not have a weapon and could be taken into custody with no danger posed to the officers or to that person. If we didn't do that, God knows what could happen. In addition, we just used it last week. We had a vehicle crash off of a cliff, and we didn't know if we were looking for people that were thrown out of the vehicle into a wooded area. We deployed the drone, which uses the infrared technology to search for a heat signature. Thankfully, this was a car where it was pushed off the cliff and there was nobody inside of it. But if there was, obviously getting to that body as quickly as possible to get them medical life-saving care is something that you would not be able to do with just walking out there and searching with your own human eyes. The drone is indispensable. We have
Chief Angeli, just a heads up at the 3-minute marker.
Okay, thank you. We have invested at least over $20,000. I just bought a brand new drone. I wasn't looking to buy a drone from a certain country. I bought the best that was available. It just so happens it was made in China. The last thing I want to do is tell a family member that we weren't able to use certain technology to find their loved one because it was banned through a legislative process. So thank you so much for your time, and I'll be here for any questions that you may have.
Thank you very much for your testimony. Are there any questions? Chief, thank you very much for waiting and for providing your testimony today.
Thank you for your time. Thank you.
Peter Swanson?
Had to change afternoon to evening. Good evening. Appreciate you, the honorable chairpersons and honorable members. Senator Ciccarella, I think, was the only one that wasn't here for one thing I might say that's not beating a dead horse, because there's been a lot of drone talk. Real quickly, also Senator Kissel, shout out from Windsor Locks. How are you? My name is Pete Swanson. I'm a lieutenant, or I'm sorry, I'm a retired lieutenant from the East Hartford Fire Department. After 34 years in the fire service, I wound up my last year with a back injury, and instead of painting hydrants and counting nozzles, the chief offered me the job of getting the drone program started. They had tried 6 years ago. There wasn't money in the budget, and they decided to table it. So he asked me if I was interested. I'm a tech nerd. I'm a geek. I've got my own little drone, so I decided that I would take over the program. Got interest from some of the guys who were willing to be drone pilots. The chief was willing to invest some money, and we were off. The first thing we had to do was buy a drone. So we started to look around and found that we had some options that were American drones, and we had a lot of options that were Chinese drones. We didn't have a bias one way or the other. If you know firemen, we all drive American pickup trucks. Every guy has a flag on his helmet, the back of his pickup. So it's all about America. But when we looked at the drones, it was all about China. Not because they're Chinese drones, but because the American drones, many of them weren't available. They were back ordered. The one that we could afford to buy is the one that I believe it was Senator Duff that was speaking earlier. He mentioned a drone called the Anafi, the Parrot Anafi. It is an American-made drone. It offers a lot of the things we wanted. The problem is it doesn't have some things we need. And one of those for us in East Hartford is the ability to carry an extra payload. Not payload camera, carry something on it. So we have the Connecticut River. We do a lot of calls for overturned boats. People decide to jump off the bridge for whatever reason and land in the water, and we have to find them. So a thermal imaging camera is what we need. And we also would love the ability to carry a PFD. If we can put a life vest on a drone and fly it to somebody, we've done it in training. We haven't, thank God, had to do it in person, but we know it's coming. And when it happens, it's going to justify every penny we spent for the drone. If we can save somebody's life in the river or somebody through the ice by bringing them a life vest, bringing a rope to them, that's really what it comes down to. So without going into what everybody else talked about, we're at the point, we're at end of life on our first drone. We bought it 3 years ago. Our program's 2 years old. The batteries are at the point, we know it's time to start looking for a replacement. So we looked at American Drones again, and we found one we really liked, $38,000. The chief kind of balked at it a little bit, but he's going to try and push the town council to see if he can get the money because it has a few features that are pretty cool. But when we look at the Chinese drone, the same drone we have now has a much upgraded model. It would cost us $10,000 maximum to replace what we paid $8,000 for 3 years ago. So that's a pretty good return of investments. Plus, we can use that as a training drone. We don't have to get rid of it unless we had to get rid of it. If suddenly we have to get rid of it because it's a Chinese drone, first we're out all of the equipment we bought. Much of it's proprietary to that drone. It isn't like we can take that drop system and put it on an American drone. It's not going to fit because they're different drones. So we'd have to start from scratch, start all over again. And when I talk to the company, there's a company, Skydio, that is an American drone company. They're licking their chops right now because they see what's happening across the country. Connecticut's not the only one. There's a whole drone nerd subculture. We get the news from other states. We hear about bills that are being sponsored to take away the Chinese drones. And when I met with a Skydio rep, I love their
Swanson,
drone.
just a heads up, you have the 3-minute mark.
Just about done. Thank you. I said, I really love your drone. Give me he said, it's $38,000 for what you need. I said, all right, more than I want to spend, but it's not my money. If I can get the chief to go for it. He said, the problem is it's going to take a while to get it. And if you need other stuff for it, it's going to take a while to get it. And I said, why? And he said, because Florida is buying all our drones. There's a back order now. So that brings me back to where we were when we first looked. What can we get today? We got our drone. It was shipped to us in 5 days. When it broke, it crashed. Not my fault. It actually did have a problem that it was covered by the warranty, but they got us a new one in 3 days. So there was no waiting time. When you have a drone and you need it, and suddenly you say there's a back order, you wait 8 weeks for one, there's going to be a fire the next day. Someone's going to fall through the ice. Someone's going to fall out of a boat, and we won't have a drone. So I ask you, please just really consider that there's so many agencies in the state that are using Chinese drones. They don't spy. We only fly them when we fly them and where we fly them. And we know the rules. We have to be licensed pilots by the FAA. So we're pretty good on strict rules, and the data management, it's impeccable. Everyone already talked about that. We're the same way. We hold the data. It's secure. It's locked away. The Chinese aren't getting it.
Mr. Swanson, you're past 2 minutes.
Okay. Thank you. I appreciate you all. Thank you. I have no idea you guys have to stay this late too. I'm impressed. Thank you for all your work. Much appreciated.
Thank you very much for coming. But actually, I think we do have a question. Representative Ackert would like to ask you a question.
Just a quick one. You brought up a question when you said when your drone goes down, what are you going to do? There must be collaboration between the departments, I would imagine, right?
Speaking regionally, some people talk about regionalization. That's not so big in the fire service, but yes, I happen to know Don. Don was one of the first people who mentored me when I started getting into this. And I know that if we were in a pinch, I could probably borrow one of Don's drones. But all his drones are Chinese, so that all really is kind of contingent on what happens in Connecticut.
Well, I'm more thinking about, and forget, I get the whole regionalization piece, and I got to have my own drone, but no disrespect in terms of affordability. Vernon, I saw Vernon's display of drones on there, and they've got the infrared technology. It's really good. They're not that far from any Eastern Connecticut town to say, yes, we can bring that drone over there and support it. I want to say cost factors. How many times do you think in a week a drone is up in the air for service?
Depending on the service, some weeks not at all.
Yeah, that's what
But what we need our drone to be on the scene 24/7. That's where we're aiming to always have it there, because when it's needed right then. If we had to call somebody else, we don't know their availability. In East Hartford, we're fortunate to be a 24/7 fully staffed fire department. But if it's somebody that has to come from home and get a drone, those minutes that go past are the minutes between a 5-year-old child being found in the water or near the water. or somebody in a car crash on Route 2 that was ejected out of the car, we're finding them right away or waiting for a drone to come from somewhere else. So, yeah, I mean, we can borrow from each other, but just very similar to having a fire engine a block from a fire, making a huge difference if somebody's trapped in that house. If they had to wait for another town to respond,
Yeah.
those are the
I
times.
appreciate that. Thank you.
Right.
Thank you. And thank you
Thank
for
you.
your service.
Appreciate it again.
Thank you very much. Next, Professor Ghosh.
Hi, good evening. Thank you, Senator Maroney and the members of the committee for giving me this opportunity. Just a quick introduction, my name is Tirthankar Ghosh. I'm an endowed chair professor at the University of New Haven and the director of their Connecticut Institute of Technology. My specific area of research and education, my experience is in cybersecurity and the interplay between cyber and AI. I have over 18 years in cyber and AI research and education, worked in Minnesota and Florida for almost 17 years before moving to Connecticut. I start, first of all, thanking you for proposing this bill. It's very timely and it addresses an extremely important issue that we are all facing today. And I just wanted to give you a little bit of a context of the importance of AI from the cyber perspective, and which kind of I'm preaching to the choir here. As you all know, the AI's integration with cybersecurity is in the forefront of keeping our country safe, as we are seeing an increasing adversarial techniques, what we call tactics, techniques, and procedures, TTPs, that are using more and more AI or integrating AI into these attacks. And all of you know, we are seeing more and more nation state involvement in all these sophisticated attacks, which are becoming, they are scaling them up using AI techniques into that, and also at the same time making them more sophisticated and difficult to detect. Now, from the education side, as we are educating AI professionals for future workforce, for existing workforce, and at the same time, as we are educating more and more cyber professionals, there's a huge interplay between the two. There's this overlap between AI and cybersecurity. It's just getting bigger and bigger. And also, when we are educating this workforce from the AI perspective and also from the cyber perspective, we have what we have seen from the education side. We have shifted from teaching them the defensive techniques to teaching them more offensive techniques. Now, having said that, and you have my full support for this bill. This is it's a very important initiative that you have done. Thank you so much. I cannot express my thanks in just mere words. But at the same time, there's only one concern that I wanted to express that I mostly over the process, and it is for sections 15 through 17, where you are proposing to establish Connecticut Citizens AI Academy on behalf of Charter Oak State College, and also building a robust AI workforce with the regional community and technical colleges. What I am seeing missing in here, that the private universities in Connecticut, they are not getting the opportunity to contribute to this important initiative with their expertise, with their resources they have. And for example, at University of New Haven, we have a very strong portfolio of AI, data science, and cybersecurity programs, both at the undergraduate and graduate levels, where we are teaching hundreds of students. We are using very rigorous and relevant curricula. We are continuously changing the contents in the classrooms.
Mr. Ghosh, just a heads up, you're past 3 minutes.
Oh, I'm sorry. And so just wanted to use this opportunity to say that, we also from the private universities wanted to contribute to this important initiative. So we would like to get that opportunity as well. Thank you. I'd love to have questions.
Thank you so much for your testimony. Point well taken that our private universities are a great asset to our state and graduate a lot of our tech workforce. And So we do need to make sure we are including you, as well as any, I guess, any suggestions you would have on helping us to further our cybersecurity workforce. That's another issue where we see great needs. But if you could send those along, that would be appreciated.
I will. Thank you.
Thank you. Okay, I am going to go out of order because there's only one last person in this room who is waiting to testify. So I apologize for those who are waiting at home, but we will have Jennifer Yaxel please come testify.
Jennifer Yaxall, and I am co-chair of the Connecticut Municipal UAV Task Force. UAV stands for Unmanned Aerial Vehicle, so you know why I'm here. So I'm co-chair, and Don is from Manchester's Emergency Management, is the other co-chair. So obviously I'm here to testify against Section 4 of SB 3. Our group consists of nearly 250 people, mostly public safety, involved in existing drone programs or interested in starting one. They come from 68 towns across Connecticut, as well as the state police. This bill will drastically impair their ability to continue existing programs or start new ones. Conservatively, it will ground at least $500,000 worth of taxpayer-funded drones, and from what I've heard today from some of our members, probably more like upwards of $1 million. I understand the security concerns motivating this bill, but it's really important to weigh the benefits of these tools against the risks. I am not going to go into the benefits because, first of all, it's really late, and you've heard from our members who could say it much better than I ever could. As far as the risks, I'm just going to really quickly summarize. So obviously, one risk is the concern about the videos. Our first responders aren't flying over anything that can't be seen from Google Earth or from satellites. Another concern is that an adversary could use the drone software as a backdoor into a department's computer system. Just standard cybersecurity best practices, which you've heard some from our members, that can protect against that risk. And I think it's really important that we not lose sight of the fact that our agencies are not the United States military. They're not guarding state secrets that would be of value to a foreign government for the most part, as far as I know. So the benefits of allowing the use of these Chinese-made drones of Connecticut far outweigh the risks. And it is not in our state's interest to follow the federal government on this. The next thing I was going to talk about is why Chinese drones are just more capable than American drones, but I think you've heard your fill of all of that, so I won't go into that. But the only thing I would say is if you or any members of your committee have a question about that, before you would conclude otherwise, I would ask that you talk to our group because you can talk more in depth to any members of our group who can help out with that question. There are hundreds of thousands of Chinese-made drones in this country that can be flown by any member of the public, including children. Under this bill, the people who can't fly them are the ones specifically using them to keep us safe. If you pass this ban, knowing what you've heard today, including the limited scope of risk and the fact that it can be mitigated, how would you feel if there were a school shooting, a major fire, or a natural disaster, and your town's public safety people or your first responders said to you, we could have done a whole lot more, a whole lot quicker if you hadn't taken the tools out of our hands? So I'll leave you with that, and I'm happy to answer any questions that you might have. And please consider using our group as a resource if you have any questions on this issue going forward.
Thank you so much. And I believe Representative Ackert has a question.
I think you heard my question earlier, and and I respectfully appreciate the testimony of the gentleman before you regarding the drone issue. But when I started thinking about each town having to have their own, many of them have their own drones, it seems a little expensive to me when I drive 25 minutes to come to Hartford, and I pass through 6 towns. So when I mentioned to him about, because they seem to be expensive, and do we need to have each department to have a drone setup if you can collaborate with others?
So probably our members are better at answering that than I am, but let me just give you from my perspective. For one thing, there are all different kinds of programs that these drone programs can have. For instance, they can have a drone as a first responder, which means that when a call comes in, you just immediately send a drone out. You're not going to do that, I don't think, by using another town's drone. Also, different, like, there are different capabilities for different drones, and perhaps some towns may want something different. But I think I think as Pete Swanson said, it's really that you want it there right away. It's like the jaws of life. Do you want your fire department to have the jaws of life, or do you want to have to borrow somebody else's? It just
Yeah, I appreciate that. I don't compare the two at all. A jaws of life is compared to a drone that is, I don't, and I appreciate that comment though. Just made me think about, the quite a bit of expense. And I'm not saying that I agree with your position on the legislation in terms of, this is what we can buy and it's a better product. It just seems to be, an expensive item that a lot of, we try to get the basic stuff in our community to buy. I don't think a couple of my towns, I don't think any of my towns have a drone at this. I think Tallinn may have a drone just because they're a little bit bigger facility. But just to throw it, because you mentioned you got 68 towns. That's why I asked you, as opposed to an individual, just my own town. So
I think that if you would like, I could speak to our members. I think that they would have a good answer to that, much better answer than I could give you on that.
Yeah, I was just curious, when I think about the expense of it and really the items that we need in our fire departments. I know, jaws of life, but drones are new.
You know what? I guess the reason I said jaws of life, because Don actually made a point a long time ago. He said, you know what? Drones are like the jaws of life. When they came out, nobody really thought they were that important. And today you can't imagine an emergency service without it.
No.
And so I think that's what made me think about it.
I appreciate that. That makes sense. I appreciate that. Thank you for being here and sticking with us and your testimony. Appreciate it.
Thank you so much for letting me.
Oh yeah, of course. Thank you so much for staying in here all day. So, all right. With that, Kip McGuire. Okay.
Good evening, Chair. Can you hear me?
Yes, we can hear you. Please proceed.
All right. Good evening, Chair, members of the committee. Thank you for having me on to testify here. I'm Kip McGuire, the Director of Government Affairs for the North American Equipment Dealers Association. We're an international trade association representing farm, industrial, and outdoor power equipment dealers across North America. I've submitted written testimony in opposition to Senate Bill, specifically Section 8 of that. And I'll just say that we stand on our written testimony, especially in lieu of your comments earlier today that you are planning an amendment to mirror Minnesota's right to repair law, from what I understand, including the non-road exemption. So if that is the situation, I'll just stand on our written testimony and take any questions if there are any from the committee.
There's thanks from the committee for cutting your testimony short. We do appreciate. But yeah, no, the intent is to follow the Minnesota legislation. So the new language should be out next week. So please feel free to reach out when you see that to let us know if you still have any issues with the language.
All right, perfect. Thank you.
Thank you so much for your time. Okay, next. Sarah Lynn Geiger. Okay. Next, Rory Whelan.
Thank you, Mr. Chairman, members of the committee. I'm Rory Whelan, Regional Vice President for the National Association of Mutual Insurance Companies in the Northeast. We represent nearly 1,400 member companies, including 7 of the top 10 property casualty insurers. At this late hour, I will be brief. On artificial intelligence bill, I would submit that property casualty insurers are in a unique position to be exempted from this bill. Why? Because just yesterday, Commissioner Mays issued a bulletin regarding artificial intelligence. The ink is not yet dry. I really suggest and recommend that the committee exempt property casualty insurers. Let us live in this regulatory regime with the department before you change the statute that would affect property and casualty insurers. And then secondly, with regards to Senate Bills 3 and 201 regarding consumer protection, the current law properly empowers the Connecticut Department of Insurance to regulate property casualty insurers and products. That is where this regulation should be. Virtually everything required in this bill, the department has purview over my members. So having a duplicate regulatory regime, a duplicate regulator is unnecessary and could lead to confusion. And lastly, I would say this, and really kudos to the department, to the commissioner and his staff. They have deep knowledge and expertise in matters and are uniquely qualified to oversee and enforce these regulations. It really is not appropriate for the Attorney General to be a second regulator in these matters. With that, I'm happy to answer any questions and commend the committee for a very long day.
Are there any questions? I mean, we do provide safe harbor for those who follow the bulletin. I mean, the issue is that a bulletin doesn't necessarily have the same enforcement mechanisms, right, that policies and procedures or law would, but we are working with the insurance committee or with the insurance commissioner on the language.
Thank you, Mr.
You know, I
Chairman.
would say that we're not going to give you, unfortunately, we have seen with exemptions, we need to make sure that people are complying with the other regulations and not just.
I heard your earlier remarks, and I did want to mention that I will be submitting written testimony on all of the bills that I discussed today, including some very specific comments around safe harbor. But I appreciate the efforts, Mr. Chair.
Okay, great. Thank you very much.
Thank you.
Okay, with that, Kara.
Hi,
Hi, how are you?
I'm doing well. I'm glad to see everybody still hanging in there. Good evening, Senator Maroney, Senator Cigarella, Representative D'Agostino, and other honorable members of the committee. My name is Kara Gandel, and I'm the Senior Director of Public Policy for the Engine Technology Forum. In addition to this testimony, we've submitted written comments that are more extensive, but out of respect for time, I'll be very brief in my remarks here. The Engine Technology Forum, or ETF, is a national not-for-profit educational association headquartered in Frederick, Maryland. We represent manufacturers of internal combustion engines and equipment, emissions component suppliers, and producers of petroleum and renewable fuels. Initially established in 2000, we were called the Diesel Technology Forum, and we have a long history of working with wide range of government and other stakeholders with the goal of reducing emissions from various sources of power generation, industrial, farm equipment, and other forms of transportation. For the sake of keeping this brief, the citizens of Connecticut and everyone else across the country benefit from the advanced technological innovations in the form of cleaner air. However, we are concerned with Senate Bill 3, Section 8, and its ability or potential to put users, bystanders, and the environment at risk because it does not provide protections or flexibility needed to prevent illegal tampering of safety and emission features. Since I just followed Kip McGuire, I will skip over the majority of the specifics as I'm aware of the Minnesota amendment language, but our primary concern is regarding the ability to access and tamper with emission controls, and that can happen intentionally or inadvertently. Either way, it results in emission control systems that are not in compliance and could possibly add harmful pollutants to the air quality. In fact, Connecticut over the last 3 years has experienced an average of 21 days that exceed the EPA ozone ambient air quality standard. And by enacting legislation as it's presently drafted, we believe the potential to tamper with emissions controls would be increased and ultimately result in higher emissions and contribute further to Connecticut's poor air quality days. I'm happy to answer any questions, and thank you so much for sticking with us and allowing us the time to testify.
Thank you very much. And so you've submitted written testimony that we could reference here.
We have, and the links to the air quality studies and tampering violations within the state are included in that.
Great. Thank you so much.
You're welcome. Thank you.
Okay, next, Jennifer Porcari.
Good evening, Senator Maroney, Representative D'Agostino, and members of the General Law Committee. My name is Jennifer Porcari, and I am the National Director of Public Employees for the AFT in Washington, D.C. The AFT represents 30,000 state employees, healthcare, and education members in Connecticut, and 1.75 million members across the country. We are following AI legislation across the country. I rise today largely in support of SB2, an act concerning artificial intelligence, which seeks common sense fixes to many of the foreseeable ills of generative artificial intelligence. And we commend the senators on their admirable and thoughtful work on this sweeping package of reforms. However, there are a few places in which we believe additional guardrails are needed. And before you ask, my written testimony provides suggested language referenced in my oral testimony. With respect to the first 5 sections, we suggest that there should be a legally enshrined right to opt out of the use of AI to make high-risk decisions. Generative artificial intelligence is not reliable enough to make final determinations in high-risk applications. Importantly, the logic of how a generative AI makes a determination is inaccessible when the AI is constructed using an artificial neural network, which is predominant machine learning model used by generative AI. This means that we cannot interrogate an artificial neural network about why it made a particular decision. Unless a right to opt out of AI decision-making in high-risk applications is preserved in statute, we risk damning ourselves to a society where due process does not exist. Additionally, this bill makes an exemption for open source AI deployers that is inappropriate and essentially serves to create a huge loophole for Meta, the company whose technology is responsible for the teen mental health crisis and the 2017 genocide in Myanmar. For the uninitiated, Meta often refers to its Llama models as open source, a designation disputed by the Open Source Initiative. The tech giant then attempts to claim that unless innovative open source projects like their Llama model are exempted from regulation, innovation will suffer. If this bill were to pass as currently written, it appears that the regulatory burden would actually be shifted from a company like Meta to the developers who train and modify open models, often small and medium-sized businesses. Meta does not deserve a loophole here. Meta has shown itself to be one of the most careless and destructive tech companies of the modern age, and they deserve enhanced scrutiny. They may have lobbied the EU for this loophole, but that doesn't mean we need to continue that in Connecticut. Shifting gears a bit here, we thank the authors for requiring consultation with public employees in the development of AI technologies used in public agencies. We'd suggest that it is also appropriate at this time to amend SARA and MIRA to designate use of AI in public work as a mandatory subject of bargaining. Finally, I would like to turn to Section 11, the restrictions on political deepfakes. I know there's been some conversation about this. We understand that there are First Amendment concerns which have caused legislators to take the route of restricting rather than banning political deepfakes. We would suggest that the First Amendment battle is one worth fighting because it is so important for our country that we get this right. We'd also suggest modifying the language requiring an audio disclosure of deep-faked political content in Section 11C3 to be read every 60 seconds. We are concerned that an audio disclosure at the beginning of, say, an hour-long deepfake of a candidate appearing on a podcast would be insufficient warning in today's digital age. Again, we offer these tweaks as friendly suggestions and with respect and admiration for the thoughtfulness evident throughout this text. Thank you for taking the time to draft this bill and allowing us time to comment.
Great. Thank you very much. One thing, with the disclaimers in the audio, I believe Colorado legislation is 90 seconds, but then the public citizen who had testified earlier today, their model legislation is at 2 minutes again, so that it's the beginning, the end, or at least every 2 minutes. Is that something?
Yeah, I mean, I think Colorado's legislation or their thoughts about this are great, but we'll take something every every few 62 minutes. We're worried about the longer podcast.
Okay, great. No, thank you. And again, we do plan on making the that change. So are there any other questions? Okay, great. Thank you so much for your testimony.
Okay, thank you.
Okay, next, Matthew Shearer.
Thank you. Can you hear me?
Yes, we can hear you.
All right, thank you. Co-chairs Maroney and D'Agostino and ranking members Ciccarella and Ritigliano, thank you. I'm Matt Scherer, Senior Policy Counsel for Workers' Rights and Technology at the Center for Democracy and Technology. CDT is a nonprofit, nonpartisan organization fighting to advance civil rights and civil liberties in the digital age. CDT has been watching closely as policymakers across the country grapple with the potential benefits and risks of AI. We greatly appreciate the effort that you, Senator Maroney, and others have clearly put into crafting this sweeping legislation. Our written testimony contains a number of suggestions reflecting how important it is to get this legislation right. On the positive side, we broadly support the vast majority of sections in this bill. My testimony will focus on significant concerns we do have with sections 1, 2, 3, and 7. First, while it's true that AI is already in wide use, it's equally true that Connecticut already has important civil rights and consumer and worker protections. It's essential that SB2 build on those protections rather than confusing or undermining them. That requires listening closely to advocates for consumers and workers with expertise in the many subject matter areas that the bill covers. I've been watching this hearing all day and can see that you clearly are, and I urge you to continue to do so. Second, the requirement that a covered system be a controlling factor in a decision fatally weakens the bill. This standard is not consistent with existing anti-discrimination laws, which would prohibit any practice that contributes to unlawful discrimination, not merely those that dominate the decision-making process. This requirement would effectively allow companies to opt out of compliance. Vendors always say that their systems are designed merely as tools to assist humans, and deployers always say that humans have final say in decisions, even if in reality the tool's recommendations are decisive. That creates a catch-22 under SB2. Once a company chooses to assert that a tool does not meet the controlling factor requirement, it need not even disclose the existence or use of the tool. Consumers unaware of the tool's existence cannot challenge the employer's assertion that it is not a controlling factor. To ensure accountability, the controlling factor standard must be removed. Third, while SB2 requires some notice for AI-driven decisions, more is needed. Effective transparency means consumers and workers know what types of decisions an AI system will make about them, what personal data and attributes the system uses, how it uses that information to make decisions, and provide explanations of adverse decisions. This is crucial. It is fundamental to accountability. The bill should be amended to ensure such transparency. Finally, and as others have noted, vesting exclusive enforcement authority in the AG is not adequate. The bill should give parallel enforcement authority to the CHRO or incorporate the full enforcement provisions of the Unfair Trade Practices Law. Relatedly, the bill creates a number of rebuttable presumptions, affirmative defenses, and FOIA carve-outs, as others have mentioned, that would give developers and deployers special privileges not enjoyed by other businesses. That would severely undercut enforcement and accountability and should be removed. It is imperative to do AI regulation well. I urge the committee members to consider the recommendations in our written testimony, as well as the testimony submitted by other labor and consumer advocates, and we can provide a complete red line if helpful. Thank you for your attention, and I'm happy to answer any questions.
Great. Thank you very much. Yeah, a red line would be appreciated.
Happy to do so.
Thank you so much. Are there any other questions? Okay, if not, so John is online.
John Unlicher.
Okay, John, I apologize. It said in person here, so I didn't realize you were online and I jumped you, but it is your 3 minutes.
Senator, I knew it was going to be a long hearing and I had another thing at home to do, so I switched it to online, and I appreciate you accommodating that. And for the late evening, I'm going to just try to keep this brief. AARP, my name is John Erlinghauser. I'm the Senior Advocacy Director for AARP in Connecticut. We're a nonpartisan social mission organization with an age 50+ membership. We have about 38 million members nationwide, 600,000 in Connecticut. And I'm here to testify on two bills, and I will briefly just mention that we are in favor of raised Senate Bill 201, and that concerning the Attorney General's recommendations regarding price disclosure service agreements, new home construction guarantee fund, and the Connecticut Unfair Trade Practices Act. We're only taking a position in support of the unfair service agreement sections of Senate Bill 201, and we're neutral on all other sections. And we do appreciate Attorney General Tong for bringing that bill forward. But more importantly, and the reason that I felt it was important to stay on and sit through this hearing, which was very interesting, was we're in very, very strong support of Senate Bill 3, an act consuming consumer protection. And I want to thank Senator Duff, Senator Maloney, and you, Senator Maroney, for having this bill introduced. And I will also note that unlike most people who have testified today, we're not taking any position on the sections that deal with drones, as well as the sections that deal with the requirements regarding connected devices, streaming services, billing practices, and the repairs of electronic devices. So I have submitted written testimony on this. We do offer some areas where we just think things could be tightened up and language could be a little bit stronger. And, you know, I would recommend that the committee and the sponsors of the bill look at that. We'd be happy to work with them, but we do think this was such an important bill that it was very important for me to not only submit my written testimony, but appear before you tonight virtually, if not in person. So I'd be happy to try to answer any questions you may have, but I do thank you all for staying late this evening and allowing me to testify.
Great. Thank you very much for your testimony. I don't see any questions. Are there any questions online? Okay, great. Thank you very much.
Thank you, Senator.
Next, Roxy Kosijic.
Hi, Senator Maroney. Yes, Roxy Kosicki. I know I have 17 vowels in my name. But before I get going, I actually wanted to really quickly thank you for working with us in the fall to get one of our companies, Homegrown in Connecticut, to appear, I think, virtually in the last moment for your AI panel and the kind of day-long conference that you had in December. So we're really happy that we could make that happen with Alva Health. And I am technically signed up to just testify for Senate Bill 3. But I'm meant to be, I've submitted comments for both Senate Bill 2 and 3, so I'll be brief for both. I'll go with Senate Bill 2 first, since some comments that are related were already made. I represent AdvaMed. We're the Advanced Medical Technology Association, so we represent manufacturers of medical technology, device, and diagnostics. And unlike most other industries that are kind of on the cusp of understanding and regulating AI, the FDA has regulated AI and machine learning for the last 25 years in medical devices. It's, you know, there's post-market surveillance. They regulate and constantly review the algorithms and the software. So it's not at all new. And I think it was the gentleman, the surgeon that spoke maybe about an hour ago, talking about similar kinds of regulations that, you know, overlaying this seems to be, you know, onerous and kind of duplicative, since the FDA really does actually, you know, not just regulate our devices and a lot of other things in healthcare, but they actually regulate AI and ML and have for the last 20+ years. So, you know, we would seek to work with you on how to best exclude those kinds of systems, knowing that they're highly regulated and safe and deemed safe. So those are kind of my remarks on that end. And, you know, my written testimony has a lot more detail, some really interesting and good reference material to kind of help educate and show you just what exactly we utilize right now every day, and closed loop, not generative AI, like CT scanners, PET scanners, and a lot of blood pressure machinery. So that's what I would kind of bring to your attention and say about Senate Bill 2. And, you know, happy to take questions now or at the end, but I can pivot also to Senate Bill 3 now. You know, Section 7 seems to be the intent to, you know, target consumer electronics, some home appliances. We've worked in a number of states where that intention was also the case. And unfortunately, medical devices, especially those used in the home and by patients themselves, often get looped in by this, unintentionally, of course. And so we want to bring that to your attention because unless there's an explicit exclusion, patient risk is kind of on the line here, since anyone could then be you know, fixing these machines or accessories that are, you know, life-saving devices that patients and providers rely on. So just a few examples of those are a portable ultrasound where the transducer is paired with a tablet and it's considered as part of the device. Patient-worn monitors with cellular capability, implantable pacemakers, X-rays that have SIM cards or X-ray devices and machines with SIM cards, and patient monitors that connect to a central station in a hospital from the patient's home. So just some examples of how that gets looped in. Again, I think it's inadvertent, but I'd like to just
Up at the 3-minute marker.
thank you. Bring that to your attention. And so on Senate Bill 3 and 2, I'd be happy to be a resource. And I regret not being in Hartford in person, but I'd be happy to come up there from DC to talk more about these issues. Thank you.
Great. Thank you very much. So I guess question, so the Minnesota bill, did that have the exemptions that you're looking for, or?
Yep.
Okay, great. And then the other question is, I guess I have a question around applying for a Medicaid waiver for remote monitoring. And I would assume that some of your companies that you represent do make products that can be used for remote home monitoring. And if you know of other states that have applied for a Medicaid waiver, or your thoughts around doing that, looking at trying to apply for a waiver for using remote monitoring for improving population health, or?
So just in general, or in terms of, you know, repair?
That's for SB2, not for 3.
Oh, okay.
So, getting Medicaid reimbursement, right? Applying for a waiver so that Medicaid could reimburse.
I see. I don't actually have an answer for you on that. We didn't have a problem with that section, but I can certainly go back and get some information for that to just be a resource and
Yeah,
help
if
answer
you
that
could find
question.
if any states have done that, that would
Yep.
be. Okay.
Happy to do that.
All right. Thank you very much.
Thanks so much.
Okay, next, Stephen Landis.
There we are. All right, I'll just get right into it for the sake of all of us. Good evening, Senator Maroney and members of the General Law Committee. My name is Stephen Landis, and I come before you today to voice my support for SB2 and ask you to expand it slightly. Just going to skip over that because it's been said. Short version is, I think it's great y'all are working ahead on this, and I appreciate it. Right after the remote feed picked up, I heard it mentioned that somebody was talking about President Biden having his voice stolen and used for political misinformation. But my interest is as a voice actor. As you can tell from this expensive chunk of hardware here, that is actually something I do and I love doing. As an artist, though, I'm actually in a little bit of a bind. Just by speaking here on the public record, I'm putting my future as a voice actor at risk. Almost anyone can take the recording of my voice that's going to be out there publicly available now and plug it into some easily available software, clone my voice, and use it without my consent and without compensating me in their own projects. And currently, there's very little I can legally do to stop them. Visual artists face a similar dilemma with their artwork on their websites. It can be stolen off their websites, used to train generative AI models that can clone their art style, and they aren't compensated for the use of the art in the training of that model. All sorts of artists are having that sort of problem. Authors, photographers, painters, voice actors, and more. We're getting our work stolen and used or really exploited by generative AI systems. So the expansion I would request is some kind of robust protection for artists whose work is being used to train AI models without their consent. It's, of course, one thing if we're licensing it for that purpose, but without that license, it's a form of theft that's really hard to enforce given current laws. And I urge the committee to add some form of protection for artists so we have a legal recourse to protect our livelihoods and ideally reclaim income lost to unauthorized use of AI recreations at industry standard rates. In any event, thank you very much for your time. Thank you for your forward thinking on the matter, and it makes me proud to see my legislature working on this.
Thank you so much. I do have a question. So,
Yeah.
Looking in the EUAI Act, one of the policies they require people, and even if it's open source or just a general purpose AI, so like they require the companies to put in place a policy to respect union copyright law in particular. Again, so that's in the EU, but are there copyright laws in the US that protect the use of your voice? And how do you protect that now?
Currently, there's not much I can do to protect my voice. Now, I think if you're a member of SAG-AFTRA, you get some protections that I currently, as a non-union actor, don't have. But there's, to my knowledge, nothing federally that would protect me and from having my voice stolen. I could potentially try to order a cease and desist through a lawyer, but again, that's sort of hit and miss. I have friends out elsewhere in the US that have had their voice stolen, and the most they can do is say, hey, this person's horrible. They're stealing my voice. They're stealing my income. Don't let them do that. But in terms of actual enforcement, it's very difficult.
Okay, great. No, thank you very much. Are
My
there
pleasure.
Representative Acker?
Yeah, I gotta ask a question. They steal you. How do they steal your voice? I mean,
Just with this recording, like this recording right here, which is going to be part of the public record, right? They could rip the audio track out of the video, and they can plug it into any number of generative AI models. My primary vocation actually is as a software engineer. I've done stuff like that before to my own voice, not to anybody else's, but it's very easy.
But what would they use it for? Who wants to hear this again? I mean,
well, they would use it to generate an AI model of my voice that then they could use in part of a text-to-speech program. So there's actually a scam going on right now where you get a phone call, you get some sort of scratchy voice in the background. You say hello, and even with just a few words, they can make a relatively decent recreation. It wouldn't pass over like a high-quality thing, but over a phone, it's enough to fool potentially like elderly family members. So you have something that kind of sounds like you coming over the phone to somebody who's not very tech savvy saying, hey, Aunt Sally, I really need some money. Can you wire me some money? And then that's a scam going on right now for people to scam the elderly and the non-tech savvy out of their money. It doesn't take a lot to take that voice model and plug in whatever other voice or whatever other words you want them to say. So from a scam perspective, that would be great to stop. But if there's something we can do also to protect artists from lost income from the same manner, that would be great.
Well, thank you again for your testimony and giving me some more information about this issue. Appreciate it.
Absolutely.
Thank you, Mr. Chair.
Thank you. And actually, I was at a conference where they shared a service that you train the model on your voice, and then it can make calls and interact with people. So as they talk, and you can train it on your own material. So if you want to use it for political purposes, you could train it on your platform, your biography, and then it calls in your voice. It would do those questions. So yeah, there is that potential. Again, there are legitimate businesses doing this with disclosures, but there's also places that are doing this for bad purposes. So, but thank you so much for hanging in there and for your testimony.
Absolutely, my pleasure. Thank you.
Next.
Kathy Jin.
Yes, hello. Good evening, Senator Maroney and other C members of the General Law Committee. My name is Kathy Jen. I'm a resident of New Haven, Connecticut, and I'm also a student pursuing my Master's of Public Health at Yale University. I'm here today, like many others, to advocate for Senate Bill number 2, which addresses the development, deployment, and use of AI. As I speak before you here today, it's actually crucial for me to clarify that the words you're hearing are not mine alone. They are a collaborative effort of technology with human oversight, as this testimony has been crafted with the assistance of ChatGPT, which is an AI language model. Right now, we stand at a critical juncture where technology is advancing rapidly, and it's undeniable that AI holds tremendous potential to revolutionize various aspects of our lives. However, with this potential also comes significant responsibility. As a public health student, I am particularly attuned to the potential implications of AI in healthcare. While we have seen tremendous successes, for example, in its use in identifying drugs to combat neurological diseases like Parkinson's, we must also acknowledge that healthcare is an essential service where the quality and type of care offered can often be a matter of life or death. Now, without regulations, risk mitigation, and human oversight, AI tools can make errors that are at best only costly and at worst are damaging and dangerous to health and well-being. Cases where AI has made consequential decisions, for example, overlooking racial minorities for high-risk care management programs, underscores the necessity of identifying the risk of unjustified differential treatment, which is seen in Section 2 of this bill. Now, despite the risk, AI does carry enormous potential to benefit patients, doctors, and hospital staff. Just as evidence in my testimony where AI was used to support the writing process, it's crucial to underscore the remarkable capability, advancement, and efficiency of AI. It's equally as important that we recognize that human oversight remains indispensable to ensure that accuracy, fairness, and ethical considerations are upheld. Now, the Biden administration outlines that AI should lead to healthcare outcomes that are fair, appropriate, valid, effective, and safe. And I applaud Sections 13.2D in recognizing the importance in providing training for those participating in or overseeing decisions created by AI. However, in Sections 2.2, which discusses examining the suitability of data sources and possible biases, I would suggest that the committee consider the importance of including language on diversity in both the data sets and the workforce used to train AI, as that type of diversity is essential for preventing biases and ensuring that AI applications are equitable and can also represent all communities that it is serving outcomes to. So overall, it's crucial to acknowledge that the journey towards a future supported by AI must be one marked by transparency, accountability, and inclusivity. I really strongly believe that Senate Bill 2 outlines initiatives that are supportive of these pillars, for example, through the training, piloting, and requirements that it outlines. In closing, I want to thank you for the opportunity to speak today, and I'm happy to take questions if there are any.
Great. Thank you so much for your testimony. And I think I definitely agreed that it is important that we include diverse voices, not only in the crafting of AI, as well as being thoughtful about the deployment and using it to try to reduce health inequities. I think that, one of the things we look back to is the example of seatbelts, right? When seatbelts were designed, they were designed with men in mind. And so we saw problems, right, with women or children were being harmed because their bodies were different. And so that importance of taking into account all the voices is critical. So thank you for taking the time to testify. And yep. And I think, is that it? Yeah. With that, thank you everyone for attending. This meeting is adjourned. So Mr. Clerk, do you know the date and time of our next meeting? Please stay tuned. We will be meeting potentially hold next Tuesday and definitely next Thursday.